The House will please come to order. Those persons not having privilege of the floor will please vacate the chamber at this time. Members and guests in the galleries will please rise as we are led in prayer this morning by Pastor John Muncie. He is the guest of the gentleman of the 19th, Douglas Hicks.
Let's bow our heads together. Jesus, we thank you for another day of life that comes straight from you and your kindness toward us. We thank you for the blessing of government, an institution that you ordained and established as a good gift to us to promote order and civility, that people made after your image would live in harmony with one another. Most importantly, Jesus, we thank you that you can give us a restored, true, lasting purpose in life and a relationship with you, all by trusting in you and what you did on the cross. Thank you. Lord, we thank you for each delegate that is here today, for each person that's here today, for you put them here and gave them their authority and position. We pray for each delegate that you would bless them with wisdom and understanding, that they would be able to make decisions based on what is good for our state and its people. We thank you for the progress that has been made so far and ask that it only continues to get better. Lord, I close this prayer by asking that you give us hearts for you and that your blessing would be upon the entire meeting today and all that flows from it. In the name of Jesus, I pray. Amen.
Members and guests will please remain standing as we are led in the Pledge of Allegiance this morning by the gentleman from the 44th, Douglas Hanna.
Thank you, Mr. Speaker. Members and guests, if you please join me in the pledge. I pledge allegiance
to the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all. Members and guests may be seated. Reading of the Journal.
Journal of the House of Delegates, Charleston, Monday, February 24th, 2020.
The gentleman of the 16th, Douglas Mant.
Thank you, Mr. Speaker. Good morning, everybody. Yeah, I ask unanimous consent that further reading of the Journal be dispensed with and that it be approved as having been read.
The gentleman of the 16th, Douglas Mant, asks unanimous consent that further reading of the Journal be dispensed with and be approved as having been read. Are there objections? The chair hears no objections. Reordering of the calendar. Lady from the 49th.
Thank you, Mr. Speaker. From special calendar to House calendar today, committee substitute for Senate Bill 502, committee substitute for House Bill 4558, and Senate Bill 572. From the House calendar to the special calendar, House Bill 4524, committee substitute for House Bill 4852.
Introduction of guests. Introduction of guests. Lady from the 49th, Douglas Summers.
Thank you, Mr. Speaker. Joining me today in the West Gallery is students from Taylor County Middle School and Grafton High School and their teachers as well, if they'd stand and we can make them feel welcome. Jade Hall, Kayla Greathouse, Brylan Perkey, River Sipes, Jocelyn Workman, Maddie Motes, Savannah Wyckoff, Carolyn Wellman, Landon Hulley, Cole Lambert, Cole Goldison, Isaac Lowe, Chris Knotts, Nathan Castle, Justin Gaynor, Alex Himes, Jason Gaynor, and their chaperones for today, Lindsay Stepanek, Jill Childers, and Sam Myers. If the House could please make them feel welcome.
The gentleman of the 46th, Douglas Martin.
Thank you, Mr. Speaker. In the North Gallery today, on behalf of the delegates from Upshur County, we have some guests joining us. If they would please stand as I state their name, Judge Jake Rigger, Judge Kurt Hall, and our Magistrate Mike Kaufman. And if the House would please make them feel welcome.
The gentleman of the 34th, Douglas Boggs.
Thank you, and good morning, Mr. Speaker. I'm very happy today to have a wonderful friend today, Seth Backus, Fairmont State today, along with Frankie Delapaz in the gallery. Both are Fairmont State students, and Seth was down here a couple weeks ago as a Fraser Singleton with the delegate from Randolph, Douglas Hartman. So if they would stand, the members would please make them welcome.
Gentleman of the 41st, Douglas Hill.
Thank you, Mr. Speaker. On behalf of the gentleman from the 44th and myself today, we have some pages from Summersville Middle School. If they will please stand when I call their name. We have Caton Strader, Catherine Jarvis, Colin Flanagan, Aaron Mann, Valerie Mullins, and Jack Chapman. And their chaperones are Jennifer Jarvis, Jim Bob Flanagan, Amy Mann, Donnie Mullins, and Christy Chapman. If they will all stand in the House, please make them welcome.
To gentleman the 10th, I got Kelly.
Thank you, Mr. Speaker. This morning from Blennerhassett Middle School in Wood County, we have pages. We have Logan Arnold, Patrick Arnold, Zane Van Fossen, and Gabe Van Fossen, and they're accompanied today by their parents, Craig and Amy Arnold, and Susan Van Fossen. If they'd all stand, and would the House please make our friends feel welcome. Thank you.
Lady in the 42nd, Doug at Lavender Bow.
Thank you, Mr. Speaker. I'd like to recognize apprentices from the Carpenters Local 439 in the South Gallery. If you'd please stand. We have representatives from Cabell, Kanawha, Wayne, and Greenbrier counties represented today. Thank you.
To gentleman the 47th, Doug Phillips.
Thank you, Mr. Speaker. From Barber County, we have some guests with us today in the West Gallery with Youth and Government. From Philippi, we have Marissa Dines, Mackenzie Shahan. From Casson, we have Brian Sparks, Arrington Sparks, Madeline Freeman, Carson Canfield, Katie Kennedy, Grant Scola. And from Beelington, we have Alexis Finley, Maggie Mincy, Natalie Dumeyer, Joseph Kittle, Taryn Tomlinson, Mackenzie Schoonover, Taylor Skidmore, Briley Coker, Alyssa Moss, Georgia Lynn Ward, and they're escorted by the teachers Sarah Harris, Selena Dennison, Hillary Hulver, and Rochelle Nestor. Please give them a warm house welcome.
To gentleman the 14th, Doug Butler.
Thank you, Mr. Speaker. Joining us with the page program today from Point Pleasant Intermediate School, I have 3 pages. If these guys would stand up as I call their names, and also their parents who are up in the West Gallery, I believe. We have Lindy Taylor and her mom, Melissa Burdette. We have Trent Hanley and his dad, Rick Hanley, who also happens to be the county commissioner for Mason County. And we also have Aaliyah Peck and her mom, Liz Arthur. If the House would please welcome these folks.
To gentleman the 28th, Doug Cooper.
Thank you, Mr. Speaker. Up in the North Gallery today, we have visiting with us with the YLA group, some pretty special people from Monroe County, and if they would stand when I call their name, Lieutenant Colonel Scott Womack. That would be you, sir. Riley Sparks, Abby Fraley, if she's up there, and Carter Brown, if he happens to be there. Thank you all very much for coming. And anybody else from Monroe County, please stand up. I didn't get all your names. Thank you very much. Thank you, Mr. Speaker.
To gentleman the 28th, Doug Pack.
Thank you, Mr. Speaker. My colleague, Delegate Cooper, I think beat me to the punch on part of that, but I would like to introduce the folks from Peterstown, if they wouldn't mind to stand. Elizabeth Adkins, Isabel Adkins, Paige Amos, Justin Feemster, Carolyn Keys, Caleb Long, Hannah Mann, Sadie Maxey, Mary Beth Meadows, Jackson Mills, Madison Rife, Rosalind St. Clair, Cole Thomas, Abigail Tolley, Catherine Byers, and Bryson Witt. If they would all stand in the House, please make them welcome.
Lady in the 50th, Doug Longstreth.
Thank you, Mr. Speaker. I have a special guest today. He is from Fairmont State University. He's the Chief of Staff for the Student Government Association. He's been here before. A good friend, Zachary Fancher. Would you please welcome him?
Lady in the 52nd, Dr. Saipo.
Thank you, Mr. Speaker. Preston County has some students down today for Youth and Government Day. They were visiting on the Senate side. I don't know if they've made it over. I cannot see in the gallery behind me, but I did not want to forget them and not recognize Preston County if they made it to the galleries. Thank you.
The gentleman, the 42nd, Doug Campbell.
Thank you, Mr. Speaker. On behalf of the delegates representing Monroe County, we have more YLA students from Mountain View School in Union in our North Gallery. If they'll stand when I call their name: Shane Arthur, Emma Ballard, Katie Collins, Lindsay Dunbar, Tyler Fury, Luke Hunter, Jordan Lowe, Caden Lowe, Jackson Phipps, Leanne Richmond, and Morgan Bass, also from James Monroe High School. Youth Governor Carter Brown, Youth Speaker of the House Riley Sparks, and Youth Secretary of State Abigail Fraley. Will the House please make them welcome?
Lady in the 4th, Doug Zukoff.
Thank you, Mr. Speaker. This morning, Delegate Canestraro and I are pleased to welcome Marshall County students that are here in Youth and Government from Sherrard Middle School, Moundsville Middle School, and Cameron Middle School. If they would please stand when I call their name. Jeff Stevens. These are their teachers. Jeff Stevens from Sherrard Middle School, Daniel Gatz from Sherrard Middle School, Valerie Yarnell from Moundsville Middle School, and their students, Lillian Roman, Brody Williams, Megan Williams, Grace Gatz, Charles Heitz, Anandra Dudley, Mara Tharp, Bailey Sabrowski, Thad Deppenwolf, Chelsea Saman, Carter Bertram, and Caitlin Connor. If the House would please make them welcome.
The gentleman, the 20th, Doug Brown.
Thank you, Mr. Speaker. Myself and Delegate Mark Dean from the 21st have some special guests here today from Mingo County we would like to recognize from the House floor. With us, we have Amy Hanna, Kristen Debord, Alexis Batalza, Rebecca Casey, and Julius Hatcher, if they'll stand. These group of people work for an entity in Mingo County called the Williamson Health and Wellness Center. They recently won an award for gold status in the state for their work in improving the community health and having a positive impact on the West Virginia economy. In addition to those individuals, we have April Hall with the Mingo County Health Department, Kay Maynard with the Mingo County Schools, and Chris Dotson with the DHHR. If the House would make them welcome, I'd appreciate it. Thanks.
The gentleman, the 19th, Doug Thompson.
Thank you, Mr. Speaker. In the South Gallery with the apprentices, we have one of my former students from Wayne High School, Justin Crockett. If he would please stand up and the House give him a warm welcome. Thank you.
The gentleman, 39th, Doug Bartlett.
Thank you, Mr. Speaker. I'm delighted to welcome a couple of pages from the Sissonville Middle School. Brody Scott, if you'd stand, please. Blake Fisher, and I think they're out on there's all right there, and they're escorted today by mother and grandparents. And please make them feel welcome, and thank you for being here to serve us today. Thank you, Mr. Speaker.
The gentleman, the 50th, Doug Angelucci.
Thank you, Mr. Speaker. On behalf of Delegates Caputo, Longstreth, and myself, I'd like to welcome faculty, staff, and President Dr. Martin from Fairmont State University. Today is Fairmont State University Day at the Capitol, so I invite all members and guests to please go out to outside the chambers and look at all the displays that Fairmont State has brought down here. They're pretty remarkable to see the progress that Fairmont State is making in higher education. So thank you for all of them for coming down and visiting with us.
The gentleman, the 5th, Doug Pethel.
Thank you very much, Mr. Speaker. Today I have students and teachers here for Youth and Government from Wetzel County. They're in the South Gallery. I'd ask as I call their name that they please stand, and when I conclude you can make all of them welcome. From Payton City High School, Ava Giovanazzo, Talon Chambers, Mallory Dennis, Maddie Still, Jocelyn Solinsky, and their teacher, Mr. Bill Bell, and the principal of Hayden City Elementary School, Tammy Chambers. From New Martinsville School, Timbra Thompson, Bailey Sly, and their teacher, Amy Little. From Shortline School, Lila Palmer, Tessa Delaney, Casey Barker, Charity Bates, and their teacher, Joe Candela. And from Long Drain School, Jolie Hayes, Roxy Huggins, Mason Norris, and their teacher, Brandon Miller. I would ask they all please stand and the House make them welcome. Thank you, Mr. Speaker.
Are there any further introductions this morning? If not, report to standing committees.
Your Committee on Judiciary has had under consideration Senate Bill 509 relating to custodial allocations actions independent of divorce, and Committee Substitute for Senate Bill 706 clarifying duties of Law Enforcement Training and Certification Subcommittee. Reports the same back with the recommendation that each do pass.
The report will be received.
Your Committee on Judiciary has had under consideration Committee Substitute for Senate Bill 240 requiring hotels and restaurants secure manhole covers of certain grease traps. Committee Substitute for Senate Bill 529 establishing limitations on claims and benefits against the state. And Committee Substitute for Senate Bill 583 creating program to further development of renewable energy resources. Reports the same back with amendment with the recommendation that each do pass as amended.
The report will be received.
Originating in the Committee on Government Organization are House Concurrent Resolution 113 requesting the Joint Committee on Government and Finance study the licensing categories and regulation of contractors by the West Virginia Contractors Licensing Board. House Concurrent Resolution 114 requesting the Joint Committee on Government and Finance to conduct a study of licensure, certification, and registration forms of occupational and professional regulation. House Concurrent Resolution 115 requesting the Joint Committee on Government Finance to conduct a study of the feasibility of a single building to house all occupational and professional regulatory boards. House Concurrent Resolution 116 requesting the Joint Committee on Government Finance to conduct a study duplicative and unnecessary professional and occupational regulations. House Concurrent Resolution 117 requesting the Joint Committee on Government Finance to conduct to study state procurement policies to identify best practices, including exploring exceptions to the statewide contract and purchasing policies generally. And House Concurrent Resolution 118 requesting the Joint Committee on Government and Finance to conduct a study of state logging regulations regarding trucking and related insurance requirements compared to other logging intensive states. These are reported with recommendation that they be adopted and that they be referred to the Committee on Rules.
The report will be received and all resolutions be referred to the Committee on Rules.
Your Committee on Government Organization has had under consideration Committee Substitute for Senate Bill 686 exempting contract and common carrier laws for certain vehicles. Reports the same back with recommendation that it do pass.
The report will be received.
Your Committee on Government Organization has had under consideration House Concurrent Resolution 96 requesting the Joint Committee on Government and Finance study the hiring exemptions of the West Virginia State Tax Department and the West Virginia Division of Highways, Department of Transportation. Reports the same back with recommendation that it be adopted, that it be referred to Committee on Rules.
The report will be received. The resolution will be referred to the Committee on Rules.
Your Committee on Pensions and Retirement has had under consideration Senate Bill 523 extending deadline for municipalities to offer Social Security coverage to certain municipal retirement system members. Reports the same back with amendment with recommendation that it do pass as amended.
The report will be received.
Your Committee on Political Subdivisions has had under consideration Committee Substitute for Senate Bill 96, prohibiting municipalities from limiting persons' rights to possess certain weapons. Reports the same back with amendment with the recommendation that it do pass as amended, that it be referred to Committee on Judiciary.
The report to be received and the bill to be referred to the Committee on Judiciary.
Originating in the Committee on Political Subdivisions is House Concurrent Resolution 112, requesting a joint Committee on Government Finance to conduct a study on impact on counties that pay for the cost of transporting persons requiring mental health treatment and or substance abuse treatment to mental health facilities or state hospitals outside of that county. This is reported with recommendation that it be adopted, that it be referred to the Committee on Rules.
The report to be received and the resolution will be referred to the Committee on Rules.
Your Committee on Government Organization has had under consideration Senate Bill 552, requiring contracts of $25,000 or more be competitively bid. Reports the same back with amendment with recommendation that it do pass as amended.
The report will be received.
Your Committee on Government Organization has had under consideration Senate Bill 202, allowing one member of PSD Board to be County Commissioner. Committee substitute for Senate Bill 225, empowering municipalities to adopt a street programs. Senate Bill 281, removing residency requirements for persons applying for reappointment to a municipal police department. Senate Bill 307, correcting code citation relating to certain tax liens. And Committee substitute for Senate Bill 576, relating to management of public records. Report the same back with recommendation that these do pass.
The report will be received.
Your Committee on Education has had under consideration Committee substitute for Senate Bill 241, requiring State Board of Education develop method for student transportation costs as standalone consideration. It's reported with a title amendment with recommendation that it do pass as amended.
The report will be received.
Your Committee on Education has had under consideration Senate Bill 652, authorizing school building authority to promulgate legislative rules. Senate Bill 703, increasing earning limit for employees who accept separation incentive. Senate Bill 712, correcting name of forensic analysis laboratory. Senate Bill 781, relating to reports regarding collaborative agreements between community and technical colleges and federally registered apprenticeship programs. Reports the same back with recommendation that these do pass.
The report to be received.
Your Joint Committee on Enrolled Bills has examined, found truly enrolled on February 24, 2020, presented to His Excellency the Governor for his action. Committee substitute for House Bill 2086, Uniform Real Property Electronic Recording Act. Committee substitute for House Bill 2497, relating to the whistleblower law. And Committee substitute for House Bill 4058, relating to pharmacy benefit managers.
The report will be received. Are there further reports of standing committees? If not, reports of select committees. Messages from the Executive.
Delegate Hanshaw, Mr. Speaker, presents a communication from His Excellency the Governor advising that on February 24, 2020, he approved Committee substitute for House Bill 2602, Committee substitute for House Bill 2924, Committee substitute for House Bill 4129, House Bill 4141, Committee substitute for Senate Bill 46, Committee substitute for Senate Bill 364, Committee substitute for Senate Bill 470, Committee substitute for Senate Bill 487, Committee substitute for Senate Bill 500, and Committee substitute for Senate Bill 501.
The message will be received. Message from the Senate.
The Clerk of the Senate announces the passage by the Senate of Committee substitute for Senate Bill 528, creating Uniform Worker Classification Act.
The message will be received. Bill will be referred to the Committee on Judiciary.
The Senate has passed Committee substitute for Senate Bill 578, recalculating tax on generating, producing, or selling electricity from solar energy facilities.
Message will be received. Bill will be referred to the Committee on Finance.
The Senate has passed Committee substitute for Senate Bill 579, changing and adding fees to wireless enhanced 911 fee.
Message will be received. The bill will be referred to the Committee on Finance.
The Senate has passed Committee substitute for Senate Bill 586,
the message will be received.
Reorganizing and redesignating Department of Military Affairs and Public Safety as Department of Homeland Security.
The message will be received. Lady from the 49th.
Mr. Speaker, I ask unanimous consent that the bill be taken up for immediate consideration, dispense with the committee reference, and read a first time.
The lady from the 49th asks unanimous consent that committee substitute for Senate Bill 586 be dispensed with, that the bill be taken up for immediate consideration and read a first time. Are there objections? The chair has no objection. The clerk will read the bill the first time.
Committee substitute for Senate Bill 586, reorganizing and redesignating Department of Military Affairs and Public Safety as Department of Homeland Security.
Bill will be advanced to second reading. Next message from the Senate.
The Senate has passed Senate Bill 651, relating the definition of mortgage loan originator.
The message will be received and the bill will be referred to the Committee on Judiciary.
The Senate has passed Committee substitute for Senate Bill 689, enacting and requiring accountable pharmaceutical transparency, oversight, and reporting act.
The message will be received and the bill will be referred to the Committee on Health and Human Resources.
The Senate has passed Senate Bill 691, limiting programs adopted by State Board of Education.
The message will be received and the bill will be referred to the Committee on Education.
The Senate has passed Committee substitute for Senate Bill 705, allowing military veterans with certain experience qualify for examination as electrician or plumber.
The message will be received and the bill will be referred to the Committee on Government Organization.
The Senate has passed Committee substitute for Senate Bill 707, relating to nursing career pathways.
The message will be received and the bill will be referred to the Committee on Education.
The Senate has passed Senate Bill 723, requiring Department of Education to develop plan-based analyzed data on school discipline.
The message will be received and the bill will be referred to the Committee on Education.
The Senate has passed Senate Bill 727, relating to disbursement of funds for highways road repair.
The message will be received. Lady from the 49th.
Mr. Speaker, I ask unanimous consent that the bill be taken up for immediate consideration, dispense with a committee reference, and read a first time.
The lady from the 49th asks unanimous consent that the bill be taken up for immediate consideration, the committee reference be dispensed with, and the bill be read a first time. Are there objections? The chair has no objections. The clerk will read the bill a first time.
Senate Bill 727, relating to disbursement of funds for highway road repair.
The bill will be advanced to second reading. Next message.
The Senate has passed Committee substitute for Senate Bill 728, exempting all property used for agricultural purposes from county property maintenance codes or ordinances.
The message will be received and the bill will be referred to the Committee on Government Organization.
The Senate has passed Senate Bill 734, clarifying powers and duties of DOH in acquiring property for state road purposes.
The message will be received. Lady from the 49th.
Mr. Speaker, I ask unanimous consent that the bill be taken up for immediate consideration, dispense with a committee reference, and read a first time.
The lady from the 49th asks unanimous consent that Senate Bill 734 be taken up for immediate consideration, that the committee reference be dispensed with, and that the bill be read a first time. Are there objections? The chair has no objections. The clerk will read the bill a first time.
Senate Bill 734, clarifying powers and duties of DOH in acquiring property for state road purposes.
The bill will be advanced to second reading. Next message.
The Senate has passed Committee substitute for Senate Bill 751, removing certain requirements of municipality annexing property within urban growth boundary.
The message will be received and the bill will be referred to the Committee on Government Organization.
The Senate has passed Senate Bill 755, relating to High Wage Growth Business Tax Credit Act.
The message will be received and the bill will be referred to the Committee on Finance.
The Senate has passed Committee substitute for Senate Bill 770, revising requirements for postdoctoral training.
The message will be received and the bill will be referred to the Committee on Health and Human Resources.
The Senate has passed Senate Bill 782, relating to fees assessed by Healthcare Authority on certain hospitals.
The message will be received and the bill will be referred to the Committee on Health and Human Resources.
The Senate has passed Committee substitute for Senate Bill 787, providing benefits to pharmacists for rendered care.
The message will be received and the bill will be referred to the Committee on Health and Human Resources.
The Senate has passed Senate Bill 803, supplemental appropriation of money out of General Revenue Fund to DHHR.
The message will be received. The bill will be referred to the Committee on Finance.
The Senate has passed Senate Bill 837, providing exemptions from ad valorem taxes for certain types of personal property.
The message will be received and the bill will be referred to the Committee on Finance.
The Senate has passed Senate Bill 838, directing state police to establish a referral program for substance abuse treatment.
The message will be received and the bill will be referred to the Committee on Judiciary.
The Senate has adopted Senate Concurrent Resolution 46, requesting DEP and DHHR propose public source water supply study plan.
The message will be received. The resolution will be referred to the Committee on Health and Human Resources, then the Committee on Rules. Are there further messages from the Senate? If not, resolutions.
House Concurrent Resolution 105, United States Air Force Colonel Rishal C. Walker Memorial Bridge.
Lady in the 49th.
Mr. Speaker, I ask unanimous consent that the further reading of resolutions introduced be dispensed with, and that each resolution be considered as formally introduced and referred to the appropriate committees as indicated on the chamber automation system.
The lady from the 49th asks unanimous consent that further reading of resolutions introduced be dispensed with, and that each resolution be considered as having been formally introduced and referred to the appropriate committees as shown on the chamber automation system. Are there objections? The chair has no objections. Petitions, motions. The gentleman from the 26th, Douglas Evans.
Mr. Speaker, I ask unanimous consent for purpose of an introduction.
Are there objections? No objections heard.
I'm a little late getting into the chamber for playing with CBS, and I do apologize, but I do have some pages from Fall River Elementary School that I'd like to introduce. As I call your name, would you please rise? Addison Dotson, Michaela Barnes, Haley Green, and their chaperones, I think, are up in the gallery behind me, one of my former students. And I'd make the house, if you would please, make them feel welcome.
Bills introduced.
House Bill 4972, making a supplementary appropriation to the Department of Health and Human Resources.
Laid in the 49th.
Mr. Speaker, I ask unanimous consent that the further reading of bills introduced be dispensed with and that each bill be considered as formally introduced and referred to the appropriate committees as indicated on the chamber automation system.
Laid in the 49th, I ask unanimous consent that further reading of bills introduced be dispensed with and that each bill be considered as having been formally introduced and referred to the appropriate committees as shown on the chamber automation system. Are there objections? The chair hears no objections. Unfinished business. Bills on third reading.
Committee substitute for House Bill 2088 relating to admissibility of certain evidence in a civil action for damages.
The question before the House is, shall the bill pass? Are there objections to having the bill explained in lieu of having it read? The chair hears none and recognizes the gentleman of 27th, Delegate Schott, to explain the bill.
Thank you, Mr. Speaker. This deals with the rule regarding the admissibility of evidence as to the use of a seatbelt, a safety seatbelt in a motor vehicle. We had a statute that goes all the way back to 1993 that requires the operator and any passenger of a passenger vehicle to wear a seatbelt. However, the statute provides that the failure to use the seatbelt is not admissible in a civil litigation on the question of negligence or mitigation of damages. There is a small exception to that, basically, in which the court can conduct a hearing to determine if the failure to use a safety belt was the proximate cause of the injuries, and if it is, it can reduce the medical damages that are awarded in that lawsuit by 5%. This bill basically modifies that rule and allows the admissibility of the lack of use of a seatbelt in certain specific instances. The first of which is if the plaintiff is actually ejected from the vehicle and the vehicle is equipped with a safety belt that met federal standards. In that case, the use or non-use can be admissible in that case. Also, if the plaintiff files a product liability claim, which addresses the overall crash worthiness of the passenger vehicle, the use or non-use of the seatbelt can be admitted in that case. If the occupant of the vehicle dies as a result of the accident, the use or non-use of the seatbelt could be introduced in that situation. And if the medical expenses, which the plaintiff seeks, exceed $50,000 in the case, then the non-use of the seatbelt is admissible in the case. In that particular instance, though, the plaintiff has to disclose those medical expenses before the discovery deadline. Otherwise, any offer of medical expenses above that $50,000 is barred. Now, if in any of those cases the defendant is required to raise that defense in its answer or in a timely amended answer in according with the rules of civil procedure, and the defendant has the burden to prove, first of all, that the section requiring the use of the seatbelt was violated, second, that the use of the seatbelt would have reduced injury or in the event of a death would have prevented the death, and thirdly, the extent of the reduction in the injury. Except in the case of an ejection, the proof of that would have to be by expert testimony that is subject to the standards for admissibility of expert testimony under the West Virginia Rules of Evidence. The bill also provides that either party may request that the issue related to admissibility of the seatbelt evidence may be heard out of the jury's presence. And finally, the findings of the trial judge on that particular issue are limited to the admissibility of the evidence and do not constitute a finding of fact. Mr. Speaker, that's a summary of the bill. I urge its passage.
The question before the House is, shall the bill pass? Are the members who wish to speak to passage of the bill? The gentleman of the 14th, Delegate Butler, is recognized.
Thank you, Mr. Speaker. Would the chairman yield to a question, please? Yes. Thank you, Mr. Chairman. Are there other factors that would not be admissible at this point other than a seatbelt? Are there other things are there other things that would not be admissible? Just a question.
I'm not aware of any. If you have some specific examples you want me to opine on, I'll be happy to try to do so.
Okay, well, just off the top of my head, maybe like blood alcohol content or speed or those types of things.
In the civil case, I think if you had adequate proof of the blood alcohol content, it would be admissible. If the speed, certainly, if you know, it's a question of whether the evidence that supports that fact meets the rules of evidence, then speed would be also would be admissible.
Okay, so do you think that this requirement is consistent with the other things that are admissible then?
Do I think that this modified version of the bill is consistent with the others?
Yes. In other words, are we treating seatbelt use any different than say any other safety equipment, like maybe a child car seat or operational airbags, anything like that?
Well, to the gentleman, I think there's some policy issues surrounding whether you get into what lawyers refer to as a trial within a trial. And so with respect to seatbelts, you've got really a two-level type situation. One, did you use it or not? And two, what difference does it make? And so you could have a trial basically on the use of it, and then secondly, you could have a trial, did it make any difference? I didn't use it. You know, there are cases, for instance, where somebody's wearing a seatbelt, goes off the road into a creek or river and drowns, and then you've got a whole different situation. Maybe I shouldn't have been using the seatbelt in that case. But no, I think there's some policy issues that are entwined with this as to whether in every case it makes sense to admit the evidence of the non-use of a seatbelt. I think this sort of strikes a balance in those more severe cases that maybe it's worth the effort to try to get to that second level of analysis. That's my personal opinion.
Okay, fair enough. Thank you. Thank you, Mr. Speaker.
The gentleman 55th, Douglas Sponagle.
Yield.
Yes.
Just to follow up, one point that something's not admissible at these trials is automobile liability insurance admissible evidence that the defendant had when these cars?
No, it's not. Good point.
All right. Thank you, Mr. Chairman.
The gentleman 17th, Doug Lovejoy.
Thank you, Mr. Speaker. Chairman Yield.
Yes.
Chairman, I'm trying to understand the application. As we sit here today, if I was driving and was hit by a drunk driver, I'm not wearing my seatbelt, there's a 5% reduction in my medical expenses?
If the court determines that the lack of use of the seatbelt had some bearing on your injuries, yes.
Now, let's say if this bill passes, same factual scenario, I'm hit by a drunk driver, I'm not wearing my seatbelt. Now, the fact that I'm not wearing my seatbelt can be admitted into the case for purposes of comparative negligence?
If one of those four situations is triggered.
And if a jury were to find I'm 51% at fault for not wearing my seatbelt, would the drunk driver escape any liability?
Under the current status of the law, yes.
Under the bill if we pass this?
If one of these is, if you were, for instance, ejected from the vehicle,
right,
and the jury found that your resulting injuries contributed 51%,
yeah,
sure.
Or let's say in the matter of death, if I'm killed, hit by a drunk driver and killed, and I'm not wearing my seatbelt, if we pass this bill, and if a jury finds 51% fault for not wearing my seatbelt, the drunk driver escapes any liability?
Assuming that the evidence is presented in accordance with this, and I can't imagine a jury in that particular case finding 51%, but you'd have to have expert testimony that you were killed and that you wouldn't have been killed had you been wearing your seatbelt, right, and then the jury could factor that into it. If there was adequate testimony that you would have survived and not been hurt at all when you were hit by the drunk driver, there's a possibility.
Okay.
I think it's remote, but there's a possibility, yes, you'd be barred.
Thank you, Mr. Chairman. Thank you, Mr. Speaker.
The gentleman 36th, Doug Rowe.
Thank you, Mr. Speaker. Would the chairman yield for question?
Certainly.
In civil litigation for damages, there's a comparative negligence rule, and that's what we were speaking of when you were talking about 51% just a moment earlier. I'm wondering if this evidence would weigh in at the same level as intentional drunk driving. In other words, sometimes when negligence is reckless or wanton disregard for the safety of others, then there's a different standard of proof, and the jury doesn't compare. The judge
yes.
says you shall not compare this.
To the gentleman, you're correct. If it's willful, wanton, gross negligence, then the issue of comparative negligence, as I understand it, is not triggered, so it wouldn't come into play in that situation.
Now, I don't know what's required on school buses. I know large buses certainly don't have to have seat belts, but what about on smaller buses that hold less than 15 students? Would they have to have seat belts as a result of this law?
I believe under this statute, with the modification to a passenger vehicle is considered anything 15 or less. So in that particular situation, keep in mind this requires that the vehicle has to be equipped with a seat belt that meets the federal standards. If it's not equipped, then this change in law doesn't apply at all. But if it is equipped, then this statute would affect that situation. Yes.
And when you say equipped, you mean officially and properly equipped?
Properly installed where the passenger can use it in accordance with federal standards. Yes.
Now, if the vehicle were very old or the owner manipulated it and the passenger couldn't actually use a seat belt because it wasn't really available, would that count against them?
No.
Is there language in the bill that specifically says that?
Yes, give me a second. I think I can point to it.
Yes, sir.
To the gentleman, I think if you look at the first subsection A of the bill, it basically talks about all passenger vehicles manufactured after January 1, 1967, and being 68 models are all required to comply with this section. So the seat belt is referred to in the first part of that section, and any passenger, the front seat of the passenger vehicle, restrained by a safety belt meeting applicable federal motor vehicle standards.
Would the statute allow a lawsuit against the owner of the vehicle for manipulating or not keeping the seat belts properly maintained?
I think that would be under general negligence. I don't think the statute would give you any would cover that situation. In other words, you still have a negligence claim against the owner-operator of the vehicle if you're traveling, for instance, in one of these 15-passenger buses and it's not properly equipped. Then yes, I think you'd have a claim against them, just under general negligence.
Thank you, sir. Thank you, Mr. Speaker.
The gentleman, 36, Secretary Robinson.
Thank you, Mr. Speaker. Now, listening to my friend from the 17th, a scenario came up in my mind. And on November 1st, 2014, my grandfather and his small dog were hit head-on by a drunk driver. They were driving less than a half mile up the street to get lottery tickets from my grandmother right after the West Virginia game. And on that day, the following months, if this bill would have been in effect at that time, my grandmother would have been having the discussion of whether or not my grandfather was wearing a seatbelt rather than receiving compensation for her loss and the loss of my grandfather's life. So for that reason, I would urge the body to reject this legislation. Thank you.
Are there other members who wish to speak to the passage of the bill? If not, does the gentleman wish to close debate on the bill? The question before the House is, shall the bill pass? Those in favor of passage will vote aye. Those opposed will vote no. The clerk will prepare the machine. Has every member voted? If so, the clerk will close the machine and ascertain the result. On this question, there are 45 ayes, 54 nays, 1 member absent, not voting. Less than a majority in favor. The chair declares the bill rejected. Next bill on third reading.
Committee substitute for House Bill 2149 relating to farm to food bank tax credit.
The question before the House is, shall the bill pass? Are there objections to having the bill explained in lieu of having it read? The chair hears no objection and recognizes the gentleman of the 10th, Chris, to explain the bill.
Thank you, Mr. Speaker. Good morning. This bill would amend the provisions of the West Virginia Code relating to the West Virginia Farm to Food Bank tax credit. This tax credit is available for farm taxpayers who make a donation of edible agricultural products to nonprofit food programs in the state. The existing credit is against your West Virginia personal income or your corporate net income tax, equaling to 10% of the value of the donated food, not to exceed $2,500, or an aggregate of no more than $200,000 per year for all taxpayers qualifying for the credit. The committee amended the bill, and in the amendment, we raised the credit to 30% of the value of the edible agricultural products donated. Mr. Speaker, I urge passage.
The question before the House is, shall the bill pass? Are there members who wish to speak to passage of the bill? If not, those in favor of passage of the bill will vote aye. Those opposed will vote no. The clerk will prepare the machine. Has every member voted? If so, the clerk will close the machine and ascertain the result. On this question, there are 99 ayes, 0 nays, and 1 member absent not voting. A majority of members having voted in the affirmative, the chair declares the bill passed. The clerk will please report the title.
Committee substitute for House Bill 2149.
Are there amendments to the title? If not, the title is read by the clerk, will be and remain the title of the bill. The clerk will please communicate the action of the House to the Senate, request concurrence therein. Next bill on third reading.
Committee substitute for House Bill 2646, providing a safe harbor for employers to correct underpayment or non-payment of wages and benefits due to separated employees.
The question before the House is, shall the bill pass? Are there objections to having the bill explained in lieu of having it read? The chair hears no objection. The gentleman of the 27th, Dr. Scott, is recognized to explain the bill.
Thank you, Mr. Speaker. This bill adds a new section to what's called the West Virginia Wage Payment and Collection Act. Basically, and this only deals with employees who are separated from their employment. What it requires is the employee that seeks wages or fringe benefits that employee contends were underpaid or unpaid at the separation to make a written demand to his or her employer. And after that, receiving that demand, the employer has 7 calendar days to correct the alleged underpayment or non-payment of wages before a lawsuit may be filed. Basically, in a wage payment case, you can seek wages, attorney's fees, and liquidated damages, which are equal to twice your wages. In this particular case, the employee can seek wages at any time, whether or not he complies with this section. But compliance with this section is a prerequisite to seeking the liquidated damages and attorney's fees. There's a definition of the term written demand, which is a writing, which can include an email, that is made to the employer by the employee stating that the employer has not paid all the wages or fringe benefits which the employee is owed. However, upon separation, the employer has to provide the employee with the identity of who the authorized representative to receive the notice is, or the demand, and where to send the written demand through both email and regular mail. Otherwise, this section is not triggered. So the employer has to provide that information at separation or with the final paycheck. There's also a provision in the bill that if a class action is brought by multiple employees for the underpayment or non-payment of wages and fringe benefits, the written demand, if it states that the demand is for all similarly situated employees, and if the person who's named in that demand ultimately is made whole, in other words, paid what that person is due or owed, then the rest of the class members may continue with their suit even though that person is no longer in the lawsuit. Mr. Speaker, that's a summary of the bill. I urge its passage.
The question before the House is, shall the bill pass? Are there members who wish to speak to passage of the bill? The gentleman of the 20th, Doug Brown, is recognized.
Thank you, Mr. Speaker. Would the chairman of the judiciary yield for a couple of questions?
Yes.
Yes. Thank you, Mr. Chairman. I just got a couple of questions. I want to make sure we're all clear what we're voting on here today.
Sure.
Could you explain to me, as it relates to this bill, the current state of the law when it comes to the payment of underpaid or wages owed to an employee at the time of separation of employment?
I will give you my best recollection of how the law currently works. It's been a while since I was involved in any of these cases. As I understand it, with the employee who separates, and this obviously only deals with separated employees, the wages are supposed to be paid with the last paycheck. And if they're not paid with the last paycheck, then the employee can file a suit. And if the employee prevails in that suit, the employee will recover the disputed wages or the amount of wages that he successfully proves, plus his attorney's fees and liquidated damages equal to twice the amount of those wages. That's my understanding of the current law.
Okay, well, this is my understanding, and you can tell me if I'm wrong. But currently the law says that when an employee is separated from employment, those wages which are due and owed, which include fringe benefits, are to be paid by the next regularly scheduled pay period. Is that correct?
That is correct.
And that pay period could be sometimes 2 or 3 weeks after an employee is separated from employment. Would you agree with that?
Yes, could be.
So we already have a period of time from 2 to 3 weeks in which an employer is allowed to pay an employee its final pay that they are owed. Is that correct?
It could be up to that long, yes.
Okay. Do you know any requirement in the federal law that makes an employee under the Fair Labor and Standards Act make a written demand on an employer for the wages they're owed at the time?
I'm not aware of any requirements.
Do you know of that requirement in any other state?
I can't say whether it is or not. I'm not sure. It's not my bills.
Okay. So I want to make sure we're clear. We're requiring an employer to provide an employee the name and the address of the person of which a written demand should be made for wages owed should this bill pass. Is that understand? Or is that correct, rather?
Yes. That was one of the changes made as the bill worked its way through the committee system, yes.
Okay. And if the employee does not make that demand, then they're precluded from suing and collecting what is known as liquidated damages or attorney fees. Is that correct?
Yes, they would be barred from 2 parts of their damages, yes.
Okay. So if we have an employee, let's say, making minimum wage, and that employee is working 40 hours a week, which comes to about $330 a week gross, and they believe that those wages are owed, they've got to make a written demand on the employer to be able to retrieve those wages, 1, and 2, to be able to avail themselves to an attorney who would collect fees and costs. Is that fair?
I'm not sure I used the word fair. I think that's what the bill does. You know, fair is sort of like beauty. It's in the eye of the beholder.
I understand, Mr. Chairman. I guess is that a fair statement is what I was getting at.
That is a fair statement,
okay.
Yes.
And what is your understanding under the current law, what is the reason that liquidated damages or attorney fees are included in the law as it currently stands?
I assume it's basically to compensate the person for the cost of trying to recover those wages.
Okay, so let's go back to my example of somebody that's making minimum wage. What is the current filing fee to file a civil lawsuit in the state of West Virginia? Do you know that?
Not for sure. It's been a while since I filed one. I'm thinking it's either $100 or $200.
Okay, I can proffer to you it's about $200. If you have to go through the Secretary of State, it's additional $25. Then you have to pay to have it served. So it's somewhere around $300. Is there any provision in this bill, if it were to pass, to allow the employee to recover that cost absent hiring a lawyer or absent making a written demand and then the employer failing to pay those wages?
I'm sorry, I lost you halfway through that hypothetical.
Okay, is there anything in this bill that would preclude or prohibit the employee from recovering those costs to file a lawsuit on a minimal amount of money if they do not make the written demand? In other words, is there any avenue for that employee to recover those costs?
I assume if the employee went to court and recovered the $300+, the court would award court costs. That's typically a part of the judgment that's given in any civil case.
Okay.
But the court costs wouldn't include the attorney's fees, if that's what you're getting at.
Yeah, I guess I'm a little confused because I'm under the understanding, absent a contract or statute, the court will not award fees or costs in any civil lawsuit. Is that true?
I'm not sure I'll accept that. I don't think I've ever filed a lawsuit that I prevailed in that I didn't get court costs awarded.
Okay.
It's typically in the demand of your lawsuit that you seek recovery of X dollars plus court costs.
Okay. Thank you, Mr. Chairman.
Okay.
Speaker, may I
yes,
speak?
the gentleman is recognized.
Colleagues and friends, This bill come out of judiciary as an agreement between some stakeholders. It's far better than what we were first presented with, but I still would submit to you that it's not a good bill. I mean, I don't know how I'll vote on it here on the floor, but there's something patently unfair about making an employee make a demand for wages that they work for and they're owed. And when an employer already has 2 or 3 weeks to pay those wages, when federal law requires that employer already to keep accurate records, and there's no stipulation in federal law that there be a written demand. I use the example in industry and labor rather. I've got a 20-year-old son. My son goes to work, say he quits or gets fired. He's waiting on his last paycheck. It's not paid timely. Now we're going to make him make a written demand for wages that are owed to him. He couldn't survive during that period in paying his bills if it wasn't for me. Frankly, I don't want to pay his bills. I'll do it, but I shouldn't have to. So one of my colleagues in the judiciary who half-heartedly said, you must not have a lot of faith in your son if he can't send a written demand for the payment. And I kind of laughed it off, but that evening I got to thinking, why should he? Why should he have to? He worked for them, they're owed, we've given them 2 weeks. This law in the last 10 years has been revised several times, and I'm going to walk you through it. In 2010, thereabout, the employer had 72 hours to pay an employee what was owed. At that time, the liquidated damage clause was 3 times what was owed, plus attorney fees and costs. And being a lawyer, I'll tell you, I thought that was unfair. I wasn't a lawyer at that time. I worked in the industry, and I got stuck with it a couple of times. The way I learned about it is when we failed to pay somebody within 72 hours. But this legislature took action, and they moved that from 72 hours to 4 business days. So that would not have included weekends and holidays. You truly had 4 business days to pay employees what they were owed. So that wasn't, I guess, good enough for some on the in the legislature at that time. I'm not saying anybody in here, but several years ago. We then changed it from 4 business days to the next regularly scheduled payday. We reduced liquidated damages down from 3 times to 2 times. So we have took action on this statute several times in the last 10 years. And I know trial lawyers get a bad rap, and I'm not up here over liquidated damages or attorney fees and costs. I mean, everybody here knows I'm a lawyer. That's not why I'm speaking about this. I'm speaking because I'm afraid there are people in this chamber who care more about people that sign the fronts of paychecks and not the backs. And I represent the people that sign the backs of paychecks. And that's why I was sent up here. That's who I'm going to look after. So when we get back to the liquidated damage clause, I'll tell you that these are not a boon for lawyers, but what they do is allow people who make minimum wage, people who don't make a lot of money. It's an incentive, one, for employers to try and to resolve this matter without ever going to court, because they know if there's a lawyer involved, there may be a chance they've got to pay more money than they otherwise should have. And 2, it's an incentive for a lawyer to take the case. Let's be honest. What lawyer is going to take a wage payment claim that's worth $500? Nobody. And we may not think this affects us any at all, and it may seem like a good idea, but I submit to you, when it's your family, when it's your son, it's your daughter that has not got paid wages that they've worked and they're owed, then it becomes your problem. So I would ask you to take a good look at this bill. I would ask you to give some consideration and serious thought to what you're about to vote on. I'll remind this body this bill was ran last year and it failed. We have changed it somewhat. It's somewhat better than it was last year. In all honesty, it's better than what was presented to us in committee. I just could not let this bill pass without saying something about it. I think this body knows I don't talk a lot in here. Rarely do I say much. But when I know what I know, I think I should tell you how this works, who it's going to affect, and what the outcomes will likely be if this bill passes. Thank you, Mr. Speaker.
The gentleman of the 15th, Douglas Foster, is recognized.
Thank you, Mr. Speaker. This bill, and I think there's a little bit of mischaracterization to this bill just recently. The bill does something very different than has been portrayed over there. It allows somebody between the employee and employer to settle a disagreement before it has to go to court. And I think that's one of the most important things, is it's a demand for the money. So say, hey, you underpaid me. And then the employer has 7 days. So the employer is made whole within 7 days, or they can be sued. And that's exactly what this does. It's what I believe the gentleman was suggesting, is that he doesn't want it to go to court, wants it to get settled before court and handled appropriately. Well, you still have that threat. As you make the written demand, ask for the money. If it's not paid within 7 days, then it's going to go to court, double damages and attorney's fees. This just allows the employee to get paid within 7 days before they have to go through the cost of a court case and all that difficulty. So I would urge passage.
Are there other members who wish to speak to the passage of the bill? Does the gentleman wish to close debate on the bill? Gentleman from 27th, Delegate Schott, to close debate on the bill.
Thank you, Mr. Speaker. There is a valid purpose for this Wage Payment Act, and in many cases it serves that purpose. But there's also a gotcha sort of trap in this bill, and it's been abused, or in this law, and it's been abused in the past, which is the reason this bill is before you and has been in previous years. What happens? In most cases, it's not a failure to pay situation. It's a dispute as to how much the person actually got paid. And sometimes you'll have payroll companies that use computerized software to calculate, and they may be off by $1 or $2, or at least the employee may feel like he's entitled to a couple bucks more than what shows up. That's the typical case. But what happens in that case is it becomes a class action among a lot of employees, and the employer is faced with multiple claims on what amounts to a tiny amount of money, which then multiplies by thousands of dollars due to attorney's fees and liquidated damages, and it becomes basically a tool to extort large sums of money from some of these larger employers. This bill has been worked on several years to make it more reasonable, but basically what it does, it encourages the employer to try to get to the bottom of that situation, if it's $2 or $10 or whatever, in those underpayment cases, quickly without having to go to court, without having to hire their own lawyer, and without having to pay the other guy's lawyer when it may have been a minor problem. And in essence, basically encourages those parties to settle without either one of them incurring the cost of litigation. I think it's a reasonable effort to try to address a problem that has plagued a number of individuals, and I would urge you to pass the bill.
The question before the House is, shall the bill pass? Those in favor of passage will vote aye. Those opposed will vote no. The clerk will prepare the machine. Has every member voted? If so, the clerk will close the machine and ascertain the result. On this question, there are 51 ayes, 48 nays, and 1 member absent not voting. A majority of members having voted in the affirmative, the chair declares the bill passed. The clerk will please report the title.
Committee substitute for House Bill 2646.
Are there amendments to the title? If not, the title is read by the clerk will be and remain the title of the bill. The clerk will please communicate the action to the House or the Senate. Request concurrence therein. Next bill on third reading.
Committee substitute for House Bill 4019, Downstream Natural Gas Manufacturing Investment Tax Credit Act of 2020.
The question before the House is, shall the bill pass? Are there objections to having the bill explained in lieu of having it read? None are heard. The gentleman of the 10th, Delegate Kelly, to explain the bill.
Thank you, Mr. Speaker. This bill was created to encourage investment in downstream natural gas manufacturing businesses using an income tax credit. This credit applies only to new investments and to taxes due on the newly created revenue stream. The credit will apply to corporate net income taxes or personal income taxes. Eligible taxpayers are allowed to credit against a portion of their income taxes that are a consequence of the taxpayer's investment in a new or expanded downstream natural gas manufacturing facility, provided the investment results in the creation of new jobs. In most circumstances, the credit amount is allowed against 80% of the portion of the taxpayer's state tax liability, which is the direct result of the investment. The credit is 1/10 of the investment amount per taxable year for 10 years. If the tax credit remains after a given tax year, the excess amount is carried forward to the following year until it's used. If any unused credits remain after the 20th year, the credit is forfeited. If the taxpayer prematurely removes investment property from service, or the number of new jobs falls below the required number, there are full or partial recapture provisions. The bill includes provisions providing for application process, record keeping, reporting requirements, and also allows the tax commissioner to promulgate rules. Mr. Speaker, this is a job creation bill, and I urge passage.
The question before the House is, shall the bill pass? Are the members who wish to speak to passage of the bill? If not, the gentleman at 36, Doggett Rowe.
I have a question.
Does the gentleman yield for a question?
Yes, sir.
Certainly.
Is there a maximum allowed amount under this credit? Lots of times we'll have tax credits. I think in the bill we just passed about the farm contributions, it was a $200,000 maximum credit allowed. Is there one like that in this bill?
There is no maximum cap on the tax credit. It will provide up to a tax credit for up to 80%. It is allowed to be taken in 10% increments for a 10-year period. If the full amount isn't used in a total of 20 years, then any further credit would be forfeited.
All right. Thank you, sir. Thank you, Mr. Speaker.
The gentleman at 30th, Doggett Bates.
Thank you, Mr. Speaker. Would the gentleman continue to yield?
Certainly.
Thank you, sir. This is on new investment, is that correct?
It is on new investment.
So there's no way, to the gentleman's point, there's really no way to know whether this is going to be $1 million or $10 million or $10 billion of investment.
The bill is created on new investment and new jobs. Okay. There is no current tax money involved in this bill whatsoever.
That's right. So there's no impact on this fiscal year or future fiscal years, because that's not building any revenue projections, because we don't know what the revenue would have been for investment that doesn't exist as yet. Is that correct?
This does not take into account any investment that has been made to date.
Okay.
This totally is new investment.
And it doesn't does it require the investment to be over a certain level? Is there a minimum amount of investment that's required before?
There is no minimum.
Okay. And this is a credit on corporate income tax?
It can be used with both corporate income taxes as well as personal income taxes, and the tax credit actually is tied to the number of jobs that are created through the investment.
And when you talk about personal income tax credit, it would be a personal income tax credit in terms of pass-through entities. Entities that as opposed to a wage earner's personal income tax.
Yes.
So it's aimed to provide for a tax credit for businesses that provide investments in this sector in West Virginia. Is that correct?
That is correct.
Thank you.
Yes, sir.
Thank you.
Yes, sir.
Speak very briefly.
Yes, gentleman is recognized.
There are a couple of big tax credit bills here today, and I just want to make sure that everyone's sort of aware of what we're doing as we do it. And I'm in favour of investment in West Virginia, in favour in investment in West Virginia's natural gas sector. But this bill and the companion bill later on this morning, or probably this afternoon, 4421, basically provides for potentially a large amount of future income to be taken off the books. So, and if that's a policy of this decision, the policy decision of this body, then be it. But I want to make sure that we're all aware of what we're doing now when we're back here, some of us, in next year, the year after that, and the year after that, and the year after that, and the year after that, looking for money to close holes in future budgets. Thank you, Mr. Speaker.
Are there other members who wish to speak to the bill? If not, the question before the House is, shall the bill pass? Those in favor of passage will vote aye. Those opposed will vote no. The clerk will prepare the machine. Has every member voted? If so, the clerk will close the machine and ascertain the result on this question. For what purpose? On this question, there are 87 ayes, 12 nays, and 1 member absent not voting. Majority of members having voted in the affirmative, the chair declares the bill passed. The clerk will please report the title.
Committee substitute for House Bill 4019.
Are there amendments to the title? If not, the title is read by the clerk will be and remain the title of the bill. The clerk will please communicate the action of the House to the Senate. Request concurrence therein. Next bill on third reading.
House Bill 4354, adding naboxamols to the permitted list of distributed prescribed drugs.
For what purpose does the gentleman, the 20th Douglas Brown, seek recognition?
Speaker, if no one would object, I'd like to return to the introduction of guests real briefly to introduce some colleagues that have showed up and will not be here alone.
No objections. There are no objections.
Thank you, colleagues. In the West Gallery, I'd like to introduce on behalf of myself and Mark Dean from Mingo County, some educators from Birch Middle School that have showed up here today. And some of you all have been here long enough to remember Harry Keith White. I see Harry Keith White's nephew up in the gallery today. If you all would stand up in the House to recognize them and give them a warm welcome.
The question before the House is on the passage now of House Bill 4354. Are there objections to having the bill explained in lieu of having it read? The chair hears no objection. The gentleman, the 18th, Douglas Worrell, is recognized to explain the bill.
Thank you, Mr. Speaker. The purpose of this bill is to add nabiximols to the permitted list of distributed and prescribed drugs if scheduled or descheduled by the Food and Drug Administration. Mr. Speaker, I urge passage.
The question is, shall the bill pass? Are there members who wish to speak to passage of the bill? If not, those in favor of passage of the bill will vote aye. Those opposed will vote no. The clerk will prepare the machine. Has every member voted? If so, the clerk will close the machine and ascertain the result on this question. There are 97 ayes, 0 nays, and 3 members absent not voting. A majority of members having voted in the affirmative, the chair declares the bill passed. The clerk will please report the title.
House Bill 4354.
Are there amendments to the title?
Delegate Schott moves to amend the title.
The question is on adoption of the title amendment. Those in favor of the title amendment will say aye. Aye. Those opposed will say no. The ayes have it. Chair declares the title amendment adopted. The title as amended by the House will be and remain the title of the bill. The clerk will please communicate the action of the House to the Senate. Request concurrence therein. Next bill on third reading.
Committee substitute for House Bill 4360, exempting certain persons from heating, ventilating, and cooling system licensing requirements.
The question before the House is, shall the bill pass? Are there objections to having the bill explained in lieu of having it read? The chair has no objection. The gentleman, the 15th, Douglas Foster, to explain the bill.
Thank you, Mr. Speaker. The purpose of this bill is to exempt certain persons from licensed and authorized to perform work as an electrician or a plumber to perform work on heating and ventilating or cooling system as long as the work is within their scope of practice. Some of the examples of the work that would be performed is in heating and ventilating or cooling systems would be thermostats, bathroom fans, and tankless water heater ventilation. Current law exempts persons from performing electrical or plumbing or heating work or cooling systems as long as the person is otherwise licensed as an electrician or plumber or other authorized to perform work. I urge passage.
The question before the House is, shall the bill pass? Are there members who wish to speak to passage of the bill? If not, those in favor of passage of the bill will vote aye. Those opposed will vote no. The clerk will prepare the machine. Has every member voted? If so, the clerk will close the machine and ascertain the result. On this question, there are 63 ayes, 35 nays, and 2 members absent not voting. A majority of members having voted in the affirmative, the chair declares the bill passed. The clerk will please report the title.
Committee substitute for House Bill 4360.
Are there amendments to the title? If not, then the title is read by the clerk will be and remain the title of the bill. The clerk will please communicate the action of the House to the Senate. Request concurrence therein. Next bill on third reading.
Committee substitute for House Bill 4377, the protection of vulnerable adults from financial exploitation.
The question is, shall the bill pass? Are there objections to having the bill explained in lieu of having it read? The chair has no objection. The gentleman, the 35th, Douglas Capito, to explain the bill.
Thank you, Mr. Speaker. The act before you provides a new law within the Uniform Securities Act, which is targeted toward protecting our seniors in West Virginia. What the bill does is it requires broker-dealers and investment advisors who suspect financial exploitation of vulnerable adults to notify the Adult Protective Services and the Securities Commission, and may notify other reasonably associated individual. The bill permits broker-dealers and investment advisors to delay a disbursement where financial exploitation is suspected and requires the retention of records relevant to the same. The bill provides immunity from administrative and civil liability to broker-dealers and investment advisors who comply with the provisions of the Act. Mr. Speaker, I'm happy to take questions. I urge passage.
The question before the House is, shall the bill pass? Are there members who wish to speak to passage of the bill? If not, those in favor of passage will vote aye. Those opposed will vote no. The clerk will prepare the machine. Has every member voted? If so, the clerk will close the machine and ascertain the result. On this question, there are 95 ayes, 2 nays, and 3 members absent not voting. A majority of members having voted in the affirmative, the chair declares the bill passed. The clerk will please report the title.
Committee substitute for House Bill 4377.
Are there amendments to the title? If not, the title is read by the clerk will be and remain the title of the bill. The clerk will please communicate the action of the House to the Senate and request concurrence therein. Next bill on third reading.
House Bill 4396 relating to reporting suspected governmental fraud.
Question before the House is, shall the bill pass? Are there objections to having the bill explained in lieu of having it read? The chair has no objection. The gentleman of 35th, Dr. Capito, to explain the bill.
Thanks, Mr. Speaker. When a county or municipality or municipal government suspects fraud in the ranks, there are a list of agencies statewide that it's required to report to. We're adding 2 agencies to that list, one being the Commission on Special Investigations and the State Auditor. Mr. Speaker, I urge passage.
The question is, shall the bill pass? Are there members who wish to speak to passage of the bill? If not, those in favor of passage will vote aye. Those opposed will vote no. The clerk will prepare the machine. Has every member voted? If so, the clerk will close the machine and ascertain the result. On this question, there are 98 ayes, 0 nays, and 2 members absent not voting. A majority of members having voted in the affirmative, the chair declares the bill passed. The clerk will please report the title.
House Bill 4396.
Are there amendments to the title? If not, the title is read by the clerk will be and remain the title of the bill. The clerk will please communicate the action to the House of the Senate and request concurrence therein. Next bill on third reading.
House Bill 4409 relating to transferring remaining funds from the Volunteer Fire Department Workers' Compensation Premium Subsidy Fund.
The question before the House is, shall the bill pass? Are there objections to having the bill explained in lieu of having it read? The chair hears no objection. The gentleman from the 22nd, Douglas Maynard, to explain the bill.
Thank you, Mr. Speaker. House Bill 4409, the bill would move $1.8 million into the from the Workers' Compensation Premium Fund to the Fire Service Training Fund, and would extend the Workers' Compensation Premium Fund for volunteer fire departments to June 30th, 2022, leaving $1 million in the balance. Thank you, Mr. Speaker, and I urge passage.
The question before the House is, shall the bill pass? Are there members who wish to speak to passage of the bill? If not, those in favor of passage of the bill will vote aye. Those opposed will vote no. The clerk will prepare the machine. Has every member voted? If so, the clerk will close the machine and ascertain the result. On this question, there are 99 ayes, 0 nays, and 1 member absent not voting. A majority of members having voted in the affirmative, the chair declares the bill passed. The clerk will please report the title.
House Bill 4409.
Are there amendments to the title? If not, the title is read by the clerk will be and remain the title of the bill. The clerk will please communicate the action of the House to the Senate and request concurrence therein. Next bill on third reading.
Committee substitute for House Bill 4421, Natural Gas Liquids Economic Development Act.
The question before the House is, shall the bill pass? Are there objections to having the bill explained in lieu of having it read? The chair hears no objection. The gentleman from the 8th, Douglas Anderson, to explain the bill.
Thank you, Mr. Speaker. The purpose of this bill is to encourage the development and transportation and use of natural gas liquids for the economic benefit of this state. It provides tax credits related to transportation and storage of natural gas liquids. The bill promotes the development of natural gas liquids storage hubs and pipelines in an effort to grow manufacturing in this state. There are 2 components of this bill. First, it creates the Natural Gas Liquids Economic Development Act and the West Virginia Natural Gas Liquids Property Tax Adjustment Act. The first portion provides legislative findings and declarations of public policy. Essentially, the legislature finds that the advancement of technologies has enabled the development of natural gas liquids from underground shale formations and finds that production of natural gas liquids may bring opportunities for further economic development. Those who produce, transport, and store natural gas liquids face many regulatory burdens at the present time. The bill urges state agencies to review existing rules and avoid duplication so regulatory programs are effective but less burdensome. The legislature declares that the development of natural gas liquids will serve the citizens of the state by promoting economic growth. The second portion of the bill creates a tax credit for those who store, transport natural gas liquids. The credit is allowed against personal income taxes or corporate net income taxes. The available tax credit is the amount of the West Virginia ad valorem property tax paid on inventory and equipment by the taxpayer during the year. There are recapture provisions with penalties if the taxpayer takes a credit to which they are not entitled. The credit is effective for tax years after July 1st, 2020, and will sunset in 10 years. The tax commissioner is granted rulemaking authority and is required to provide periodic reports to the legislature. I urge passage of the bill.
The question before the House is, shall the bill pass? Would the members who wish to speak to passage of the bill? If not, then those in favor, the gentleman of the 30th, Doug Bates, is recognized.
Thank you, Mr. Speaker. Just real quick, as I pointed out earlier, this is a companion really to 4019. And before I speak briefly on this, I would point out to the body that if you look further down your page, there is committee substitute for House Bill 4558. We won't actually be taking up that tax credit, which is a tax credit for firefighters, because that bill was moved to the House calendar. What's before us right now is another tax credit for the natural gas industry. This bill contains two articles. The first article, Article 5, is really a resolution in the form of an article. There's nothing substantive in it. It's essentially a sonnet to the industry. The second article, Article 11, is actually real legislation. And what's interesting here is that we're providing for a tax credit for a deductible business expense for this particular industry. So, which is, again, if it's the policy that this body has, then that's the policy this body has. But let's make clear, so in the course of operating a business, you get to deduct your expenses. And one of those expenses is the taxes you pay on your personal property and inventory tax. So you pay that to the counties. So you get to deduct that as an operating expense. And once you deduct all your expenses from your revenue, you end up with what tax you owe. So now we let you take that deduction and then drop it below the line and then take a credit in that amount, which is pretty neat if you're in this industry. So, but if you're in the coal business, you don't get to do that. If you're in the heating and cooling business, you don't get to do that. If you're in the pizza business, you don't get to do that. If you're in this industry, you get this treatment. So I'm in favor of economic development, and I'm in favor of economic development in the natural gas sector. But I'm in favor of economic development in all sectors of the economy. And for that reason, I'll be voting no. Thank you, Mr. Speaker.
The gentleman of the 8th, Doug Anderson, is recognized.
Thank you, Mr. Speaker. For the body to consider, this is an important piece of legislation because we are at a point in the development of the natural gas liquids in this state where we are either going to keep them in the state to contribute and employ citizens of this state. we must develop manufacturing of these liquids in this state. Our alternative is simply this. Are we going to put them in a pipeline and send them to the Gulf Coast and create the jobs there? Or are we going to encourage development in this state of a natural gas storage hub? And I want to connect a few dots to the body this time. The development of a storage hub with private investment is an important component in a chain that must be connected together to hold our resources in this state and create jobs for the citizens of this state. The development of a hub, which is essentially stores the natural gas liquids, will increase the chances of development of a cracker plant in this state. A cracker plant in this state will increase the chances of downstream manufacturing, which is where the real jobs for West Virginians are going to be created. It is a very important component that we encourage this beginning. This legislation has an expiration date of 10 years. The fiscal note on this indicates if someone is willing to step forward and take the chance and create a storage hub, that the fiscal note at the present time is less than $1 million tax revenue. The drilling companies risk millions of dollars drilling a well, but the results of that drilling and production of natural gas liquids is a capital-intensive industry. Once the drilling is put together and the wells are under development and producing, that's not where the jobs are. The jobs in the future for this state is not shipping these natural gas liquids to the Gulf Coast and adding more jobs down there. The future is holding those natural gas liquids, creating encouragement for people to invest in this state. Hopefully, first a cracker, then the downstream manufacturing. This is an important step, an important decision to make. I respect the opinion of the gentleman from Raleigh, but as I look to the future in the long term, I want young people in West Virginia to have a chance to stay here and occupy good-paying jobs. Thank you very much, Mr. Speaker. Legislation.
The gentleman from 36, Doggett Road.
Yes, if the gentleman from the 30th would answer a question or two on this.
I will certainly do my best.
Thank you. Now, as I understand it, the bill we had before this was on new investment, new jobs created, and there were several factors that would calculate the amount of the credit. As I understand this bill, those requirements aren't made. In other words, if they're in this business today, they get their property taxes free.
That's my understanding as well. The gentleman's correct.
And the state, in other words, the locals get their taxes, but then the state is the one that bears the loss of
it's sort of an elegant way to do a inventory and property tax elimination for this industry without actually running a resolution.
Yeah. Now, is there anything, we want development and jobs in West Virginia, but is there anything that would really require that for the credit to be given?
No. In the other bill, there was a formula, a kind of complicated formula that provided for the amount of the credit, whereas this is purely based upon the amount of personal property inventory tax that you pay for this sector. So there's no job criteria, as I understand it.
And so this would have a fiscal impact because this would cost the state immediately because of the investments that have already been made here.
Yeah, I would need to verify that, but I believe that it doesn't necessarily. The gentleman's correct, but you may direct your question to the finance chair for confirmation of that.
Yeah. And is there a cap?
I didn't see one. No, so it's somewhat unlimited in terms of the amount of this investment. that will be subject to this.
Thank you, sir.
Thank you.
Thank you, Mr. Speaker.
Lady in the fourth, Dr. Zukoff.
Thank you, Mr. Speaker. Will the chairman of finance yield?
Yes, ma'am.
Thank you, sir. Could you clarify, can this credit be used by businesses that are already in state doing this work?
That's not correct, because keep
I'm
in
just
mind,
asking you if it can.
it cannot, because keep in mind, this is all for new investment. This is for new technology that we're not doing now. Keep in mind, these counties aren't even receiving any money. The state government, they're not receiving any of this tax revenue. So what we're trying to do is spur new economic development for downstream manufacturing.
Okay, I just wanted to clarify because we have some businesses that are doing, like midstream companies that are already storing the liquids and things like that. I just wanted to clarify. Thank you, sir.
The gentleman with 55th, Dr. Spunoggle.
Thank you, Mr. Speaker. And I think the finance chairman might be just a little confused. I think a committee, there were 10 entities that were going to be able to collect this immediately. That's where the $1 million price tag comes out of. I think you might be confusing the prior bill. The prior bill that we passed was the growth going forward. This bill actually is just a property tax now.
I apologize to the lady. You are correct.
All right. Permission to speak to the bill.
Yes, gentleman is recognized.
Up in committee, I voted yes in favor of the other bill. I'm not in favor of this bill. This basically is just eliminating the property tax that these transporters carry to and from now. It costs $10 million, and 10 entities are going to get it. And I bring that up because of a cracker plant or a storage hub. There's a ProPublica story just here 6 months ago. The state of West Virginia is trying to get a $10 billion with a B storage hub on the Ohio River. Or these things cost $200, $300, $400 million a year. And we're giving something away for $1 million. Now, that's not going to drive the needle one way or the other, whether we're going to get those investments. But that $1 million is gone and you're wasting it. So if you got a leaky roof and you're only going to spend $5 and it costs $1,000 on your leaky roof, you're still going to have a leaky roof. What I am concerned about, as my friend from the 30th said, for example, other tax credits that could be beneficial to the state. Volunteer firefighters. That has a price tag about $9 million. This $1 million, in my opinion, would do more in that effort than something that's going to take billions of dollars to drive economic investment. So we have limited resources on where you're going to put these credits out. Again, I supported the prior one. I don't support this one. I don't think it's going to reach the economic goal, the policy that this body is trying to do. And frankly, I think it's a waste of money and a giveaway. So for those reasons, I'll be voting no on this one.
The gentleman 13th, Dr. Cadle.
Thank you, Mr. Speaker. I'd like to speak to the bill.
Yes, gentleman is recognized.
Let me explain something to you guys. A storage hub is a void in the ground, basically, where they will store gas. And if we had some people come down here the other day, I don't know, a few months back, not the other day, but they said that West Virginia we could support right now 5 cracker plants, but we needed 7, but we could support 5 right now. And 1 cracker plant equals 30 to 50 manufacturing plants that make things within a 100-mile radius of it. So think about that. We have the cheapest gas in the world, and we have the most gas in the world, right? West Virginia, New York, Pennsylvania. So, we have to be able to supply these plants, and the storage hub, like it takes a 30-inch gas line to run one of these plants. If something happens, let's say you're hooked up to 5 wells and one of them goes down and your volume drops, then your plant's in trouble. They got to shut it down and cost thousands, hundreds of thousands of dollars to shut down. So what these storage hubs do, the storage hubs provide gas as a backup. That's why they're called storage. They can provide volume while those wells are being repaired or whatever happened. So that's why we need the storage hubs. And I would urge everyone to vote for this because the amount of income tax that we would get from all these jobs will put West Virginia first. Thank you, Mr. Speaker.
The gentleman the 10th, Dr. Kelly.
Thank you, Mr. Speaker. I don't think people realize the magnitude of the natural gas industry. If Pennsylvania, Ohio, and West Virginia became a separate nation, we would still be the third largest supplier of natural gas in the world. That's how much we've got. As a state, West Virginia competes against Ohio. We compete against Pennsylvania for development within the natural gas industry. And we have to match what they do, or they're going to take the businesses away from the state of West Virginia. The manufacturers will go where the best deal is. It's going to happen. It has happened. It will continue to happen. If we as a state are going to progress, we have to make our laws and our procedures at least equal to our competitors, Ohio and Pennsylvania. So far, we haven't done that. We're trying to do that, and that's what this bill is all about. Now, my friend back here from the 11th made some comments that the natural gas that we put out right now will fuel up to 7 cracker plants in the state. That's true. We can do that. But in order to do that, we have to have the facilities in the ground. We have to have pipelines. We have to have storage facilities. Right now, we're putting the pipelines in. The storage facilities are still somewhat of a pipe dream. We're still working on it. We've got some preliminary work done on some storage, but we need to get that in the ground. And if we're going to be an industrial state, and we're going to be a progressive industrial state, we have to get the infrastructure in the ground. A study from West Virginia University indicates that a storage and distribution center in the Mid-Ohio Valley will bring up to 100,000 new jobs into this area over the next 10 years. Now, we can sit here and we can play games with the numbers if we want to play games with the numbers. But that's reality. That can happen. Without them, it's not going to happen. You know, I firmly believe that we as a state have to take bold steps forward, or we're going to continue fighting and watching other states around us bring these jobs and these industries to the people of their states. Mr. Speaker, I strongly urge passage of this bill. Thank you.
Are there other members who wish to speak to the bill? If not, does the gentleman in the 8th, Doug Anderson, wish to close debate on the bill?
Thank you, Mr. Speaker. Once again, I would urge passage of the bill. I appreciate the thorough debate we've had here, but we have a choice here of stepping forward to take advantage of the God-given resources that have been given to this state and harness the energy of those resources to create jobs for the people in this state, or allow them to go elsewhere and create the jobs elsewhere. I strongly urge passage. Thank you, Mr. Speaker.
The question before the House is, shall the bill pass? Those in favor of passage will vote aye. Those opposed will vote no. The clerk will prepare the machine. Has every member voted? If so, the clerk will close the machine and ascertain the result. On this question, there are 85 ayes, 14 nays, and 1 member absent not voting. A majority of members having voted in the affirmative, the chair declares the bill passed. The clerk will please report the title.
Committee substitute for House Bill 4421.
Are there amendments to the title? If not, the title is read by the clerk will be and remain the title of the bill. The clerk will please communicate the action of the House to the Senate. Request concurrence therein. Next bill on third reading.
Committee substitute for House Bill 4433 relating to deeds of trust.
The question before the House is, shall the bill pass? Are there objections to having the bill explained in lieu of having it read? The chair hears no objection. The gentleman from the 27th, Doug Schott, to explain the bill.
Thank you, Mr. Speaker. This bill enacts a new code section to establish rules of construction pertaining to deeds of trust for the purpose of protecting deed of trust beneficiaries from diminution in the value of collateral resulting from a deed of trust grantor's actions or inactions with respect to the collateral. Specifically, the bill provides that unless it provides otherwise in the deed of trust itself, the deed of trust shall be construed to impose and confer upon the parties and beneficiaries the following duties, rights, and obligations. First, the deed of trust shall be construed as given to secure the performance of each of the covenants entered into by the grantor, as well as the payment of the primary obligation. The grantor shall be deemed to covenant that he or she will pay all taxes, levies, and other governmental assessments and charges upon the property so long as any obligation upon the grantor under the deed of trust remains undischarged. Also, that he or she will keep the improvements on the property in a tenable condition, that no waste shall be committed or suffered upon the property, that the grantor shall maintain, preserve, and protect the value of the collateral, that in the event of his or her failure to meet any of the obligations imposed, then the trustee or any beneficiary may satisfy such obligations to the extent reasonably necessary to protect its interests in the collateral. A covenant to pay interest shall be deemed a covenant to pay interest on the principal balance, as such rates may vary or be modified from time to time based on the provisions of the deed of trust, and any covenant that the lender shall be entitled to share in the gross income, net income, gross rent or revenues, or net rents or revenues of the property shall be on an equal priority with the principal secured. Mr. Speaker, that's a summary of the bill. I urge its passage.
The question of whether the House is shall the bill pass, or the members who wish to speak to passage of the bill. The gentleman 36, Dr. Robinson, is recognized.
Thank you, Mr. Speaker. This legislation, I know sometimes we get into the legal aspects, and the chairman of judiciary gets into the technicalities of things, and it's kind of hard to decipher what the actual like real life implications of this bill is. Now, when you sit down to sign a mortgage and sign the paperwork for a mortgage, all of these parameters are assumed to be in that mortgage, and you're signing that you'll keep the property in good condition, you won't commit waste on the property that would devalue the property and those kind of things. Now, what this bill does is put those things that you would typically agree to between you and your mortgage or lending officer, we're going to put that in state code. Now, that doesn't protect the person borrowing money. That protects the bank that has attorneys, loan officers, appraisers, more attorneys, and those kind of things. Now, this bill, we're putting strict parameters in that would protect the lender in these cases. Now, there was an amendment in House Judiciary that would cut out and remove residential borrowers. Who that leaves is your investors, your small entrepreneurs, the people that are taking and borrowing money to grow and sometimes go and renovate and clean up different apartment buildings, houses, commercial buildings across your municipalities. So what you're doing in this case is that if the large bank, if Chase Bank comes in and makes a mistake in some paperwork, and I know most of you that have signed those mortgage agreements, sometimes those mortgage agreements stack this high up on the desk. Now, if somewhere in those thousands of pages that you sign, they miss some parameter, that mistake is protected by the state of West Virginia if we pass this. But, you know, if the other side, if we make a mistake, if a piece of property we can't keep up with maintenance, they're going to come back because the state of West Virginia, the House of Delegates passed legislation to protect the bank. They're going to come back after you on that. So this legislation does not protect your constituents. It protects the large out-of-state banks and interests that would actually be able to force negative action on your constituents. So I urge a no vote on this bill.
Are there other members who wish to speak to the bill? If not, does the gentleman wish to close debate on the bill?
Just briefly, Mr. Speaker, this bill basically governs the duties between well-informed, well-financed individuals. It does not apply to residential buyers. It basically encourages lenders to seek out the very parties that the gentleman seems to say he wants to protect, the entrepreneurs and so forth. So I understand it's easy to attack out-of-state banks. There's nothing in this bill that says anything about out-of-state banks. It's easy to create a boogeyman out there and argue against a bill. This is a pretty straightforward bill. These terms are typically negotiated between knowledgeable parties, and that's who will be signing these type documents, and it simply confirms that these are expected conditions. If you borrow money from a lender, whether it be your grandmother or someone else, these are the terms that are expected to be enforced in the bill. There's nothing unreasonable about any of these terms, and it's certainly not intended to protect out-of-state boogeyman banks, and I urge its adoption.
The question before the House is, shall the bill pass? Those in favor of passage of the bill will vote aye. Those opposed will vote no. The clerk will prepare the machine. Has every member voted? If so, the clerk will close the machine and ascertain the result on this question. There are 80 ayes, 19 nays, and 1 member absent not voting. Majority of members having voted in the affirmative, the chair declares the bill passed. The clerk will please report the title.
Committee substitute for House Bill 4433.
Are there amendments to the title? If not, the title is read by the clerk will be and remain the title of the bill. The clerk will please communicate the action of the House to the Senate. Request concurrence therein. Gentleman from the 12th, Douglas Westfall, for an announcement.
Thank you, Mr. Speaker. It's going to be a long day, but on the East Wing, we do have some baked spaghetti, pizza, and salad. The pages look like they're little boards that might be able to help you. So it's on the East Wing in front of 204. Thank you, Mr. Speaker.
Next bill on third reading.
House Bill 4447, creating the Shared Table Initiative for senior citizens who suffer from food insecurity.
Question before the House is, shall the bill pass? Are there objections to having the bill explained in lieu of having it read? The chair has no objection. The gentleman of 56, Douglas Howell, to explain the bill.
Thank you, Mr. Speaker. The short title says it all. This bill is to create the Shared Table Initiative for senior citizens who suffer from food insecurity. I urge passage.
The question before the House is, shall the bill pass? Or the members who wish to speak to passage of the bill? The gentleman of 60th, Douglas Wilson, is recognized.
Thank you, Mr. Speaker. Would the gentleman please yield?
The gentleman does yield.
Thank you, sir. Does this bill create a new program? A new program for producing food?
It doesn't create a new program because the senior centers are already providing this service, but apparently the food that is left over they are required to throw away. This allows them to package it and sit it out for the seniors to take home.
Thank you, sir. So it's food that's already produced and it would otherwise be waste?
That is correct.
Thank you very much. Thank you, Mr. Speaker.
The gentleman of 66, Douglas Espinoza.
Chairman, continue to yield. Is this legislation feeding seniors now?
Yes.
Thank you.
Are there other members who wish to speak to the bill? If not, the question before the House is, shall the bill pass? Those in favor of passage will vote aye. Those opposed will vote no. The clerk will prepare the machine. Has every member voted? If so, the clerk will close the machine and ascertain the result. On this question, there are 99 ayes, 0 nays, and 1 member absent not voting. A majority of members having voted in the affirmative, the chair declares the bill passed. The clerk will please report the title.
House Bill 4447.
Are there amendments to the title? If not, the title is read by the clerk will be and remain the title of the bill. The clerk will please communicate the action of the House to the Senate. Request concurrence therein. Next bill on third reading.
Committee substitute for House Bill 4464, relating to driving privileges and requirements for persons under the age of 18.
The question before the House is, shall the bill pass? Are there objections to having the bill explained in lieu of having it read? The chair hears no objection. The gentleman from the 45th, Douglas Martin, to explain the bill.
Thank you, Mr. Speaker. The purpose of this bill is to extend the validity of a Level 1 driver's permit for active members of the military to 180 days from the date of the applicant turns 18, and the bill requires that new drivers may not operate a phone while driving. I urge passage.
The question before the House is, shall the bill pass? Are there members who wish to speak to passage of the bill? If not, those in favor of passage of the bill will vote aye. Those opposed will vote no. The clerk will prepare the machine. The gentleman 53rd, Delegate Jennings, your vote's not registered. Your vote is not registered. Has every member voted? If so, the clerk will close the machine and ascertain the result. On this question, there are 97 ayes, 2 nays, and 1 member absent not voting. Majority of members having voted in the affirmative, the chair declares the bill passed. The clerk will please report the title.
Committee substitute for House Bill 4464.
Are there amendments to the title? If not, the title is read by the clerk will be and remain the title of the bill. The clerk will please communicate the action of the House to the Senate and request concurrence therein. Next bill on third reading.
House Bill 4606, listing contractor classifications on a contractor license.
The question before the House is, shall the bill pass? Are there objections to having the bill explained in lieu of having it read? The chair hears no objection. The gentleman of the 45th, Douglas Martin, to explain the bill.
Thank you, Mr. Speaker. The purpose of this bill is to require that contractor licenses list the classifications on the license. I urge passage of the bill.
The question before the House is, shall the bill pass? Are there members who wish to speak to passage of the bill? If not, those in favor of passage of the bill will vote aye. Those opposed will vote no. The clerk will prepare the machine.
Thank you.
Has every member voted? If so, the clerk will close the machine and ascertain the result. On this question, there are 73 ayes, 26 nays, and 1 member absent not voting. Majority of members having voted in the affirmative, the chair declares the bill passed. The clerk will please report the title.
House Bill 4606.
Are there amendments to the title? If not, the title is read by the clerk will be and remain the title of the bill. The clerk will please communicate the action of the House to the Senate, request concurrence therein. Next bill on third reading.
House Bill 4715, authorizing municipalities to take action to grant certain fire department employees limited power of arrest.
The question before the House is, shall the bill pass? Are there objections to having the bill explained in lieu of having it read? The chair hears no objection. The gentleman of the 35th, Doug Capito, to explain the bill.
Thank you very much, Mr. Speaker. This is a local control bill, empowering our municipalities to control and police their areas. And what we're doing here is we are allowing municipalities with professional fire departments, not to be confused with volunteer fire departments, only professional fire departments, to allow their fire marshals to make arrests in very limited circumstances. We're mirroring on a municipal level. We're allowing our municipalities to institute rules similar to the laws that govern the state fire marshal. We are not increasing or expanding anything beyond the scope of what the state fire marshal has. In fact, the state fire marshal and their counsel was involved in the drafting of this bill. So, the guts of the bill: in limited circumstances, in the following circumstances, a fire marshal of a municipality may do the following. They may arrest any individual disobeying lawful orders at the scene of a fire, arrest any individual who violates prohibitions against arson and explosive offenses, malicious burning, obstructing a fire marshal, or failure to obey orders, make an arrest without a warrant if the conduct occurs in their presence, detain any person suspected of the commission of an offense for investigatory purposes, and make complaints in writing to the municipal court or other appropriate judicial officer in order to obtain a warrant for such an arrest and initiate a court. The training portion of this bill is important as well, and any officer given the authority shall receive an initial and annual training that complies with the law enforcement core training standards of the West Virginia State Fire Commission and the West Virginia State Fire Marshal. Mr. Speaker, I'm happy to take questions. I urge passage.
The question before the House is, shall the bill pass? The gentleman of the 32nd, Doug Fast.
Thank you. Would the Vice Chairman yield, please?
Yes.
Just wanted to clarify, it was my understanding that the state fire marshal and his or her marshals had to have actual police certification to be able to enforce arrests, which seems to be different here for municipalities. Can you address that?
I would actually yield to one of our probably our officer training or folks that are in this body. They could probably speak to that better. But it's my understanding that the training here is sufficient to incorporate the rights that were given to our municipalities. But to the specifics, I would defer because I wouldn't want to mislead the gentleman.
Thank you, Mr. Speaker. Would there be a member of the Delegate Miller? Would he yield?
Does the gentleman yield for a question?
Yes, Mr. Speaker. Start with the state fire marshal and his or her deputies. Do they, for them to be able to conduct arrest mechanisms, do they have to have actual police certification?
They don't have the regular law enforcement certification as provided in Chapter 30, Article 29, Section 5 as a state police officer or a deputy sheriff or a city police officer, but they have their own training academy because they are limited strictly to those provisions of arson and those fire-related criminal offenses that's enumerated in code. They do not attend the basic police academy as others do as of yet. As we stand here today, they do not, but there is pending legislation waiting to be enacted. I think it's running through the system that future state fire marshal officers would fall under the auspices of going to the training academy, as we know it for law enforcement, but they still have their own.
Okay, so currently they have their own training.
Yes.
This bill that requires initial and annual training, is that the same as what the fire marshal has?
It's my understanding everything at the local level, what's called for in this bill, mirrors exactly what the state fire marshal is called for their training and recertification, as well as what they have the authority to act on.
Thank you. Thank you, Mr. Speaker.
Are there other members who wish to speak to the bill? If not, the question before the House is, shall the bill pass? Those in favor of passage will vote aye. Those opposed will vote no. The clerk will prepare the machine. Has every member voted? If so, the clerk will close the machine and ascertain the result. On this question, there are 96 ayes, 1 nay, and 3 members absent not voting. A majority of members having voted in the affirmative, the chair declares the bill passed. The clerk will please report the title.
House Bill 4715.
Are there amendments to the title? If not, the title is read by the clerk will be and remain the title of the bill. The clerk will please communicate the action of the House to the Senate and request concurrence therein. Next bill on third reading.
House Bill 4760, modifying video lottery retailer licensing eligibility requirements.
The question before the House is, shall the bill pass? Are there objections to having the bill explained in lieu of having it read? The chair hears no objection. The gentleman of the 27th, Delegate Schott, to explain the bill.
Thank you, Mr. Speaker. Currently, the Lottery Commission and the Alcohol and Beverage Control Commission have two different measurement standards for licensees when determining a location's eligibility for whichever license is applicable. The purpose of this bill is simply to sync the method of determining that distance so that both measurements are the same, whether it be for the Lottery Commission or the ABC. And basically, it's changing from, in the Lottery Commission, the nearest wall to the nearest wall, to from the front door to the front door, which basically syncs up with the method that the ABC uses, and now will apply if this bill is adopted by both organizations, both agencies. Mr. Speaker, I urge adoption.
The question before the House is, shall the bill pass? Are there members who wish to speak to the bill? If not, those in favor of passage of the bill will vote aye. Those opposed will vote no. The clerk will prepare the machine. Has every member voted? If so, the clerk will close the machine and ascertain the result on this question. There are 93 ayes, 5 nays, and 2 members absent not voting. A majority of members having voted in the affirmative, the chair declares the bill passed. The clerk will please report the title.
House Bill 4760.
Are there amendments to the title? If not, the title is read by the clerk will be and remain the title of the bill. The clerk will please communicate the action of the House to the Senate and request concurrence therein. Next bill on third reading.
Committee substitute for House Bill 4780, permitting county boards to offer elective courses of instruction on the Bible.
Question for the House is, shall the bill pass? Are there objections to having the bill explained in lieu of having it read? The chair hears no objection. The gentleman of 27th, Delegate Ellington, to explain the bill.
Thank you, Mr. Speaker. The proposed committee substitute provides that county boards of education may, and I repeat may, offer to students in grades 9 and above an elective, again elective, social studies course on Hebrew Scriptures, Old Testament of the Bible, New Testament of the Bible, or Hebrew Scriptures and the New Testament of the Bible. The purpose of this course is to familiarize students with the contents, history, literary style, and the influence of the Hebrew Scriptures and the New Testament, and to enable understanding of the development of American society and culture. A student may not be required to use a particular translation of the Hebrew Scriptures or New Testament. The proposed committee substitute also requires a county board to submit to the West Virginia Department of Education the course standards for any elective course that's offered, including the teacher qualifications and required professional development. A course offered under this section must also follow all applicable law and all federal and state guidelines in maintaining religious neutrality and accommodating the diverse religious views, traditions, and perspectives of students in the school. The state board is also required to provide guidance to the county boards in complying with all of the above requirements. Mr. Speaker, I urge passage of the bill.
The question before the House is, shall the bill pass? The gentleman from the 67th, Doyle, is recognized.
Thank you, Mr. Speaker. Sadly, I suggest that we should defeat this bill for two reasons. It is a clear violation of the West Virginia Constitution. If you will read the provision in the Constitution on free speech that the gentleman from the 37th read to the floor yesterday, it is obvious that this bill violates the Constitution. The other reason is really more the signal it sends to the rest of the country. Now, as I mentioned yesterday when we were on an amendment, I voted for this bill to come out of the Education Committee. I did so hoping it could be broadened when it got out here. It was not. If we pass this bill, we will be saying to the rest of the country, now, first of all, I do not think this is the intent of the sponsor of the bill. I know that he is serious, that he wants real history taught in our schools in an unbiased way. But that is not the message that will be heard around the country. The message that will be heard is only Christians are welcome in West Virginia. We must not send that message, and I suggest that we should vote against the bill.
The gentleman from the 51st, Douglas Hanson.
Thank you, Mr. Speaker. I think it's unfortunate that we did not pass that amendment yesterday. I would have supported this bill if the amendment had passed. But I do have some concerns about the bill. And like the gentleman just mentioned, I don't think there's any bad intentions behind this bill. I think there are only good intentions behind this bill. But it makes me uncomfortable, and I wanted to just speak from my heart. The delegate from the 37th, in discussing the amendment yesterday, mentioned that he was one of two people in the legislature who were from a religious minority, and I'm the other. I'm also Jewish. And I believe this has an impact on Jewish kids and kids of other faiths, or will have an impact, would have an impact. There was a child, a third grader, who was here yesterday to provide his feeling about this bill. And what he said, this third grader, was that my little brother and I are the only Jewish kids in our school. One day last year at my after-school program, the teachers taught us about Jesus and made us pledge allegiance to the Bible. It made me feel very worried and confused. It felt like I was doing something wrong. And I understand that this bill is not written to force anybody to pledge allegiance to the Bible. But these things happen. And kids like Malcolm are made to feel like they don't belong. The legislature heard from the vice president of the Islamic Association of West Virginia, who felt similarly that teaching just the Bible automatically discriminates against children of other faiths or children of no faith. And I think she was right about that. The legislature also heard from a rabbi from Charleston who spoke up. He said he can't stand by when our sacred texts are used, even with the best of intentions like they are here, when our sacred texts are used in a way that would marginalize students of different faiths and say that one text is more important or sacred than another. And unfortunately, I think that's what this does. Now, there was an amendment that passed in a Senate committee, the same amendment that we failed to pass yesterday. It was offered by a Christian pastor. And we had an opportunity to pass that amendment, but we did not take that opportunity. For better or worse, West Virginia is a less diverse state than many others, than most others. It does not have as much religious diversity as many states. And I think for that reason, we need to be particularly careful about passing bills that would make our kids who are from religious minorities feel unwelcome in the public schools. The public school systems are for all of us, no matter what religion we're from. So for those reasons, I would urge that we defeat this bill. Thank you, Mr. Speaker.
The gentleman from the 43rd, Dr. Thompson.
Thank you, Mr. Speaker. Would the Chairman of Education yield for a couple questions?
Chairman does yield.
Yes, sir.
Thank you, Mr. Chairman. So I just have a couple questions here, and we kind of discussed these in our committee too, but I just want to make sure that I am understanding this correctly. So this, if we allow this, it will be it will be up to the county to determine whether or not they want to go through with this, offer this elective.
Yes, completely permissive.
Okay, so like currently right now, economics is an elective and geography is an elective, which I had training in that when I was going through my undergraduate program. I had training in, economics 101, 102, and geography, several courses. Will this now be, because those are elective courses at the high school level, will we be now requiring our college age, future teachers to be trained in courses to be prepared for this?
That is potential. It does say that the county has to determine what the training and the professional development would be for that certification.
So we could potentially be seeing like a praxis subsection for...
That has that potential.
All right. And I believe we answered this, but I want to make sure as well. Anyone who is currently certified in social studies 5 through adult will be able to teach this course if the county chooses to adopt it. And
I would say if they choose to adopt it, yes.
Okay. Will the teacher have any recourse or avenue if they choose not to? Like if the county adopts it and if it's a multi-school county and they have one school that has like 5 or 6 social studies teachers, but one school has maybe 1 or 2, would the teacher have any recourse to say, I really don't feel comfortable teaching this course for whatever reason, a religious reason, or maybe they don't feel they'd have the content? Is there any recourse in that for those teachers?
I would believe they'd already have that kind of recourse if they didn't want to teach a particular subject or subject matter.
I don't know about that, but because depending on the scheduling, but okay, I was wondering with that. So you believe that the teacher would have an option to not be told you will be teaching this course as you're teaching world history, but you're also going to teach this religious studies course. You would think that with this law they would have the opportunity to say, no, I have a religious objection to that. I may be Jewish or another religion, and I just don't feel comfortable with that.
The bill doesn't address that particularly, but I would imagine the state board would give guidance on if someone decided they didn't want to or had an objection, that they would give guidance on them pursuing it or not.
Okay. Thank you, Mr. Chairman. Thank you, Mr. Speaker.
The gentleman from the 32nd, Doug Fast.
Thank you, Mr. Speaker. I heard that the only message will be heard is that only Christians are welcome here. I disagree with that. The message is we're going to teach history, and we're going to teach it correctly and based upon true history, not any type of revisionist history. There's been a mention that some people are Jewish and that this could be somehow discriminatory against them. Well, it doesn't matter if students are Jewish or non-Jewish. We are Americans. Our history is our history. It does, if the Bible, it was the Bible that has influenced our country more than any other book. That is our influence. That is our history. And I will say that that influence has done a really good job, as it has greatly lent itself towards the development of this great country that we all enjoy. So I would urge us to consider the fact that we are allowing the Bible to be taught in its historical and literary value. The bill specifically says that it's not to be a theological teaching. I can understand that. I think all of us can understand that. But our history, if we don't understand and we don't pass on to the next generation where we came from, where did we get our criminal code? Where did we get the jurisdiction of the church? Where did we get the jurisdiction of civil government? Where did we get the jurisdiction of the individual? Well, I can tell you where all that came from. It came from the Bible. And so if we're just going to ignore that and throw it out and say, no, we don't want that, we're teaching a revisionist history. We're not teaching true history. For those reasons, ladies and gentlemen, I would urge passage of this bill.
The gentleman from 39th, Doug Bartlett.
Thank you, Mr. Speaker. Certainly I urge passage of this bill, and I respect and understand the basis of some fears concerning the bill, but the language, a careful reading of the language can allay those fears. That this bill is, as has been said, but I want to re-emphasize the point, it is a permissive bill. No school board is mandated to do anything. And the bill is offering an elective course, so 2 choice thresholds have to be made. The bill provides a statement, we're concerned about how West Virginia is looked, it provides a statement that the Bible is not unwelcome here. The Bible is not inappropriate here. But there is an appropriate way in a public school setting to look at the Bible in an academic way. If theology were part of this, I would be the first one against it. It is specifically because theology is not part of this that I am for it. When I learned about the possibility of this bill, read the language that came from some other states, or before I read the language from other states, but I heard about the bill, my first question was, well, who's going to teach that and from what perspective are they going to teach it? Then to understand that it was not theology. I'm happy to do that. I pastor a church and I'm trained in Bible studies. I'm happy to teach the theology of the Bible in the setting of my church. But to simply offer a class that is an elective class that would let students have an overview of the panorama of the Bible and how it has impacted culture, art, music, literature. We're still teaching Shakespeare in public schools, and Shakespeare has 1,300 references to the Bible. You can't study Shakespeare well if you don't have a working knowledge of the language of the Bible. Even in our common vernacular, if I were to say that's a David and Goliath story, if I were to say something about the Good Samaritan, if I were to say something about the Golden Rule, these things all come from the Bible. The Bible has impacted our culture, impacted our society, impacted our history like no other book. And that's why it stands apart, and that's why it's worthy of some additional study to be offered as an elective class. Now, again, the bill is not bringing the matter of faith into the classroom, but I'm bringing faith here this morning. Well, now it's this afternoon, excuse me. I have faith that the members of this body understand that you can look at a Bible and see the significance of it apart from the theological implications. I have faith that our elected school boards can implement a policy to make it so that it's appropriate according to the language of the bill. I have faith in our teachers to understand what the intent of the bill is, what the intent of their then school board policy is, and to teach the class, not crossing the line, not crossing the threshold, not bringing their theology into the class. When anyone breaks the law or moves outside of policy, there's consequences to be had, and those should be had. But doing it according to what is in front of you does not violate any civil rights, does not violate any freedoms. In fact, it is a protected freedom. The Supreme Court of the United States, Abington versus Shemp, 1963, is the precedent that says that the Bible can be taught in a secular setting, in an academic way, including a public school. I urge passage of this bill. Thank you very much, Mr. Speaker.
The gentleman from the 37th, Dr. Pushkin.
Thank you, Mr. Speaker. Would the lead sponsor please yield?
Certainly. Thank you, sir.
Thank you very much, sir. I heard you say yesterday during the public hearing, and just again, that if you felt if theology was being taught in public schools, that you'd be against that, but you see this, so you see this as being, the Bible being taught as like a literature course?
It's a social studies course, and how that the Bible has touched history, how the Bible has touched literature, how the Bible has touched art, how the Bible has touched music.
Okay.
And then the historical setting of it completely, the ancient history that's laid out in the pages of the Bible, going back into the Jewish nation, right on up through all of the ages, the ancient ages, before the time of Christ, after the time of Christ. The panorama history is unfolded. So it touches so many areas. That's, well, again, that's why
it sounds like a history course, which I would not necessarily be against. However, a couple questions though. Like, say with the first 5 books, who would you ascribe authorship to if you were teaching the class?
Moses was the human scribe of the first 5 books of the Old Testament.
Okay. What about the rest of what you would refer to as the Old Testament? Who would you ascribe authorship to?
Various writers, Isaiah, Jeremiah, David,
okay,
so forth, so on.
Okay, so you would admit that it was written by a group of men, right?
Yes,
several. Over the years, different folks have contributed to these writings.
Over 1,600 years.
Yes,
over
right.
1,600 years,
okay.
yes, sir.
Would you say that they were divinely inspired?
You asking me a theological question?
If you were teaching
The gentleman from the 27th out of Porterfield has raised a point of order. Would the gentleman state the point?
The gentleman from the 37th is asking a theological question, and I think the gentleman from the 39th has made this clear. This is a historical issue. If that is the context in which the bill is, I would like to keep it to the scope of the bill, not to any type of theological implication. Thank you.
The gentleman from the 39th may decline to answer any question he deems appropriate, or otherwise the chair will allow the exchange to continue as the two gentlemen themselves deem to be appropriate.
I'll say this, Delegate. What I believe about the Word of God, about the Bible, does not enter into the course study laid out for us in the bill.
Okay. Well, I asked that question because what about, because you got to remember now, in Article 3, I believe, Chapter 5 of the West Virginia Constitution, it's very clear that the legislature shall not prescribe, I'll skip around so just a basic, so it relates to this. The legislature shall not prescribe any religious tests whatsoever or confer any peculiar privileges or advantages on any sect or denomination. So what I was getting at is, say there were parents who were devout Christians who had a student in this class, but it was not taught that this was divinely inspired, but just taught like a history book. Would that not violate their rights?
No, sir. We're studying the matters of history, the matters of art, the matters of culture, the matters of literature, and we're studying the impact of the Bible on those particular areas, specifically not bringing theology into it.
So you believe that you could, and I mean this in the most sincerity, sir, I hope I don't get called out again, but you honestly believe that you can separate theology from the teachings of the Bible?
Do you honestly believe that you can't look at the Bible as an academic work?
No, I believe that you can, but I
Thank
think
you.
the
I
people who have
appreciate that.
deep beliefs could possibly violate their rights.
And I have faith in the teachers of this state that could do exactly what you said you could do to teach the Bible as
Well,
an
I definitely have
academic
faith
book.
in the teachers of this state too, and that's why.
I'm sorry? There's some noise, I'm sorry?
I have faith in the teachers of the state too. That's why I've stood by them over the years. But that's a whole different.
Yes, sir.
So that was last session.
Yes.
But
sir, sir, I don't mean that as a throwaway line. I mean that sincerely. I believe they can understand what the text of this bill is and understand, regardless of their measure of faith and practice, what the objective of the class is. I mean that sincerely.
But you do understand also that depending on the teacher, there could be different interpretations, as there had been for thousands of years of this book.
Yes, and specifically, we're not getting into the interpretation, because interpretation is the very thing that leads you to theology.
Depending on who teaches it. I think you cannot teach this book without some sort of interpretation. How many languages has it been printed in, sir?
Hundreds, likely thousands.
Okay. What was the original language of the first 5 books?
Aramaic.
Okay. What about what you would call the
later Aramaic, Hebrew?
Okay. I know that you're. In fact, I have a Bible in front of me, and I hope you would be pleased to know.
I do too.
And you know what?
Let's
This
match
happened
after
to
the
come from the
session.
Maranatha Baptist Church at Sissonsville, which I know you're familiar with.
I am.
And I've had this for
Great
years,
bunch of people.
They are. I actually bought a bus from them. It came with the bus.
Yes.
And I still have it. But I was looking through, for example, in the book of Judges. Are you familiar with chapter 19 in the book of Judges?
I don't have it memorized yet.
Okay, well, in verses 22 through 25, there's a pretty graphic scene described there, and I'm not going to get into it with pages in the room. But do you think with someone teaching this in the book of Judges, you think that would necessarily be appropriate for students?
For high school students?
Yeah.
I'd have to look at the passage, but I don't think that the course intention sets out to look at chapter and verse, and I don't think we want to get into content of books brought into Kanawha County because I have a history with that. I'm old enough to have lived through so many graphic things that were approved, and so I don't have any worries about the Bible.
Well, I was about 4 years old when they had the book wars, and really I was reminded of that. Of some of those tensions during the public hearing yesterday, sir. But that's what I thought of when somebody brought up that some books that aren't appropriate for young people to read, and I thought about this verse here from chapter 19 of Judges, verses 20 through 25. I would also say that another one I found was in Ezekiel chapter 23, 19 through 20. I also won't read that one in front of the pages, sir.
Well, again, Delegate, the purpose of the bill and the intent clearly of reading the bill is not to delve into the specific chapters and verses of specific incidents in the Word of God, but to highlight the significant impact that the Bible has had on culture, history, and art and all that.
But they're not going to look into chapters and verses of it.
Well, that would be a lot more than a one-year elective class.
But
that
could be one small part of it. You said Shakespeare is taught. We actually read chapters and verses of Shakespeare when we're being taught Shakespeare.
Yes.
Is that not
correct? We don't read the entire bound set though, because that's a lot of reading. We pick and choose the highlighted plays and the highlighted stories.
Could a teacher not pick and choose these particular chapters that might not be
Again, I have
appropriate for children?
faith in these teachers to know that that's not the part that needs to be highlighted to achieve the objectives of the bill. And Delegate, I think that you understand that, and so I cease to yield. Thank you.
I can understand. May I speak to the bill?
The gentleman is recognized.
I can understand why the gentleman chose to sit down, because this is exactly, this exchange we had right here is exactly why I think this is something that is deeply personal when you're talking about one's religion and how one learns about it. And I think that's exactly why it should be kept on in churches and in synagogues and mosques and at home for parents to teach their children about their religion. I lost my place here. Because it could always be interpreted differently, and depending on the interpretation, I don't think you could teach this book without some sort of your own interpretation, or interpretation that you've been taught yourself to pass along to people. That's how this book has been taught. And we all have, depending on what sect or denomination we come from, we have all had different teachings of this. And I just don't know how anybody could say with a straight face that you could separate theology from the Bible. This is religious teaching. And I'm going to read a little bit from this book that I received from the gentleman's church years before we even knew each other. It might have been years before he was actually preaching at that church. And this is from the book of Acts, and it's chapter 4, and it's verses 30, starting with verse 32. And I want you to think about this verse here, and we'll talk about how it could be different interpretations that you could get from this. It says, "Now the multitude of those who believed were of one heart and one soul. Neither did anyone say that any of the things he possessed was his own, but they had all things in common. And with great power the apostles gave witness to the resurrection of the Lord Jesus, and great grace was upon them all. Nor was there anyone among them who lacked, for all who were possessors of lands or houses sold them, and brought the proceeds of the things that were sold, and laid them at the apostles' feet, and they distributed them to each as anyone had need." Now, in the hands of a left-wing professor, that verse right there, those verses right there, could be pushing socialism. They gave up all their possessions. They sold them. They put them in one pot, and they laid them at the apostles' feet. They gave up all their possessions, and everybody had an equal amount. What does that sound like? In the right hand, if that in the wrong hands, what could that be taught there? Because it's all a matter of perception, and it's all a matter of interpretation, and it has to be in a matter of interpretation when it wasn't written. I mean, this is interpreted from the Greek. The book that I swore in on, this is in Hebrew. It has to be interpreted when you translate it from the original languages into English, and one's own slant on this would have to come into play when this was being taught. I do not think that you can separate theology from these books. Now, it says quite clear in our own state Constitution, Article 3, Chapter 15, that the legislature shall not confer any peculiar privileges or advantages on any sect or denomination. The way that this bill is written right now, without the amendment that was not adopted yesterday, it makes a statement to the Old Testament or New Testament. I stated yesterday, simply by referring to the first 5 books and the other books before the new, what is called the New Testament, as Old Testament, it discredits the religion that I was brought up in. That is conferring a peculiar privilege or advantage on a sect or denomination. On its face, it is unconstitutional. It discriminates against my religion. I'm Jewish, and like a lot of people in here, I woke up one day when the news came out when a class of correctional officers in West Virginia decided to pose doing a Nazi salute for their class photo. I was disgusted. I was appalled. I was upset. Yet, I was comforted when some members of this body were very quick to take action and condemn that. I appreciate those who did. I really do. And I also appreciate that there was a bill introduced this year to teach Holocaust education in schools. However, that bill That bill never made it on a committee agenda. And what we got was this bill that will allow the legislature to confer a peculiar privilege or advantage over any sect or denomination. That's what we got. And the gentleman from the 39th yesterday, as he was so eloquently defending this bill against the amendment that would have made it constitutional, and say that someone could possibly interpret a sacred text as even being as extreme as even being the writings of Hitler? Are you serious? Maybe if we'd have passed the other bill and had Holocaust education in our schools, we wouldn't hear stuff like that or even think stuff like that. Do we really think that somebody would take it that far? The bill that's coming from the Senate, it simply makes it a social studies class, like basically what you described earlier. Basically what was described earlier. Look, when I was elected to this body, and every year since then that I have been elected to this body, I don't refer to this as the Old Testament. This is a Hebrew Bible. Okay, this is what I was brought up learning about and believing. This is what we learned in Sunday school. Sunday school. And when I was sworn in, I put my hand on this Hebrew Bible and I swore to uphold the Constitution. And I would sincerely hope that the rest of you would follow that oath, uphold that oath, and uphold the Constitution and vote against this bill that clearly violates the religious freedom guaranteed in our own state constitution and the Establishment Clause of the U.S. Constitution. Vote against it. Or you could follow the biblical proverb in chapter 26, verse 11, and vote for it. Look it up.
The gentleman from the 29th, Dr. Steele.
Thank you, Mr. Speaker. I know some of us at times get a little frustrated when debate goes long, but I think today debate's been a very good thing. And listening to the gentleman from the 37th, I understand, where he's coming from. I understand where the gentleman from the 39th is coming from, and the others in here who've spoken. One of the reasons that I would urge support for the bill today is because of the tenacity displayed by both of them. I think the gentleman from the 37th is well-reasoned in his opinion. He knows his facts, and he knows why he believes the way he believes. I would say the same thing from the gentleman from the 39th. And I think one of the problems that we're experiencing in our society today is we're raising a generation of children that cannot put on that same display because they're never challenged about their beliefs. They're never challenged to examine them and to determine why it is that they hold something true. It can be difficult to examine one's religion. It can be difficult to examine the religious scriptures of another that you don't believe in the same way with. But learning and adapting and being able to defend your position as well as hear the position of another without anger or malice coming up is a central issue into growing into a mature adult. I firmly believe that this bill, and there are many like it, this bill isn't the be-all, end-all of that issue. But I firmly believe that we've got to start challenging our children to examine these tough topics. Too often we'll shy away from it, and we'll say, oh, we got to protect them from having to learn about that. We got to protect them from having to talk about that. And then we wind up with a generation that at times, I've heard many adults be discouraged about their ineptitude to address these issues. I think everything that the gentleman from the 37th said is absolutely right. There is no way of separating theology from the scripture that theology comes from. But I don't think that's a bad thing. I think that helps our young people grow and examine why they believe what they believe. And I firmly believe that if you're a Christian and you believe in the Bible and you believe in everything it says, that truth will stand on its own. I believe in the truth of the Hebrew scriptures and the Torah. I believe in all that. And in that is this. Psalms 107:20. He sent His word and healed them and delivered them from their destructions. I do not think any harm can come from examining these scriptures. They were sent to us to heal us. They were sent to us to be a beacon of light and a beacon of hope. They are sent to us to show us what a good life led is. And they will save us from our destructions. I firmly support this bill for the exact reasons that the gentleman from the 37th does not. And that's okay. And part of that is teaching our kids that that's okay. Thank you, Mr. Speaker.
The gentleman from the 16th, Dr. Hornbuckle.
Thank you, Mr. Speaker, and I will be very brief. The reason I'm going to be very brief is because I feel that the gentleman from the 29th is 1,000% right. 1,000% right. But I find it very odd that we missed an opportunity to include other texts in this teaching of history. Because without those other texts, we're actually denying our kids, for that same very reason, to look at other things, to examine everything else, to be able to learn and see what they think and enrich themselves. So again, I would not belabor the point, but the gentleman from the 29th is exactly right. And for that reason, I would have to vote no.
The gentleman from the 60th, Dr. Wilson.
Thank you, Mr. Speaker. I actually reached out to the Board of Education General Counsel and asked about these issues. The response I got was that the U.S. Board of Education has recently changed their guidelines, and if you'll allow me to, I'd like to read a short passage from that. Teaching about religion. This is from the U.S. Board of Education. It's also the guideline that our State Board of Education uses. Public schools may not provide religious instruction. I asked for clarification on that. That means faith and practice. Faith and practice. In other words, how to be a member of that religion, how to claim the benefits of that religion. Public schools may not teach that. I think that's a good thing. I don't want the public schools teaching my kids what to believe or how. But they may teach about religion. For example, philosophical questions concerning religion, the history of religion, comparative religion, the Bible or other religious teachings as literature, and the role of religion in the history of the United States. Bear with me for just a moment, please. I'm going to refer to the bill. Page 1, line 6. The purpose of a course under this section is to teach students knowledge of biblical content, characters, poetry, and narratives that are prerequisites to understanding the development of American society and culture. That's what we're doing here. This is not a course on faith and knowledge. This is not a religion course. It's not even a biblical course. It's a course. This is actually, the way that I envision it, is simply permission to, within the bounds of a course on American development, where America comes from, learn about the influence the Bible had on it. Now, in my studies, and I've had an eclectic set of studies, in my studies I've learned that there are 3 legs to the stool that upholds Western civilization. And they're generally referred to as Jerusalem, Rome, and Athens. Jerusalem, Rome, and Athens. Well, what does that mean? First of all, Jerusalem is the basis for the Judeo-Christian ethic. That's what we're talking about when we use the term Jerusalem in this context. The Judeo-Christian ethic, not the Christian ethic. The Jews came first. The Jews taught it to the Christians. It comes from the Jews. The Judeo-Christian ethic. That ethic is the foundation. Let me cover Athens and Rome real quick. Rome is administrative. Basically, this building we're sitting in, this method that we use to make decisions, is based on ancient Roman administrative procedures. Now, there have been a lot of changes, a lot of updates, but basically that's where it comes from. When we talk about Athens, what we're talking about is Greek philosophy, which is the foundation for how we seek justice and happiness. Justice and happiness. For the Greeks, these two were bound up in each other. Justice and happiness. You can't be happy if you're not living a just life. So let's go back to Jerusalem. The Judeo-Christian ethic teaches that man is created in God's image. The U.S. Constitution says that man is endowed by his Creator with the rights to life, liberty, and the pursuit of happiness. That is the foundation of the U.S. Constitution, natural rights, which are derived from your Creator. Now, whether you believe in that Creator or not, whether you worship that Creator or not, whether you agree with what He might say or what He might not say or what's been said about Him, that is a fact that these concepts were derived from this system, from Jerusalem, from Rome, from Athens. That's what this bill's about. It's about teaching those facts, where these ideas come from. Whether you agree with the ideas or not, this teaches where the United States of America comes from, why we value each other as individuals, and why we have built a system that protects the individual natural rights of each human being. It's because each human being is infinitely valuable, far above the state, far above any desires that this government might have. Each individual is infinitely valuable, and that idea can be traced through the ideas that I just went through, specifically the Judeo-Christian ethic. That's what this bill's about. Thank you, Mr. Speaker.
The gentleman to the 10th, Doug Kelly.
Thank you, Mr. Speaker. Would the gentleman from 39th yield?
Yes, sir.
Thank you, sir. My Bible is the King James Version. Not sure which one you read from, but it all says about the same thing.
It's my text as well. Thank you.
And my King James Version has two testaments. It has the New Testament. Could you define the New Testament for me?
Define the New Testament?
Mm-hmm.
The writings in the Bible that begin with the life of Christ to the completion of the text.
And how would you define the Old Testament?
The initial writings that God gave to humanity, from tracing the creation all the way up until the point of Christ's birth.
In other words, the Hebrew Bible.
The Hebrew text, yes.
Okay. Does your bill designate whether these teachings in the public school system would come from the New Testament or the Old Testament?
It's option.
It would be an option.
Yes.
So therefore, the Hebrew Testament would also
yes, sir.
be offered as an instructional manual. Thank you, Mr.
Thank you.
Thank you. Thank you, Mr. Speaker.
The gentleman from the 27th, Delegate Ellington, to close debate on the bill.
Yes, thank you, Mr. Speaker. Ladies and gentlemen, the bill allows county boards to develop electives in social studies for Hebrew studies on scriptures and other Hebrew texts in the New Testament. The bill does not preclude either sacred texts or comparative religious courses. And currently, some of the schools already have comparative religious courses. The bill does not preclude the format of the course either. Now, one of the questions earlier was about the certification of the staff. Now, availability of certified staff for a formal course may limit a county from implementing a variety of courses. However, for more in-depth courses, virtual courses could suffice. This bill does not preclude that possibility that it could be on a virtual site. Now, if our purpose is to educate the public, then we shouldn't be deterred from the subject just because religion is the topic. I'm sure the perception by the schools will be that lawsuits will follow, which discourages certain topics. This bill helps alleviate some of these fears by allowing county schools to develop these elective courses with the backing of the legislature and the state board. Now, I think everyone would agree that ignorance breeds discriminatory practices. I believe the best way to dispel ignorance is by educating our students. It doesn't make much sense for students to wait until their adult years, when they are college age, to learn about the influence of various religions have had on our culture. If our society expects our youth to predominantly attend public schools for their education, then there should be no reason these topics shouldn't be taught in the public schools, as long as they are elective, respectful, and not disparaging or favoring one religion over another. Now, as long as the school provides this instruction as an elective, with a variety of choices the student may choose from, then I believe the student will have their First Amendment rights protected in order to enhance their education with respect to any coursework dealing with historic and sacred and religious texts. Mr. Speaker, I wish we would go ahead and adopt this, and I would urge a green vote. Thank you.
The question before the House is, shall the bill pass? Those in favor will vote aye. Those opposed will vote no. The clerk will prepare the machine. Has every member voted? If so, the clerk will close the machine and ascertain the result. On this question, there are 73 ayes, 26 nays, and one member absent not voting. A majority of members having voted in the affirmative, the chair declares the bill passed. The clerk will please report the title.
Committee substitute for House Bill 4780.
Are there amendments to the title? If not, the title is read by the clerk. Will be and remain the title of the bill. The clerk will please communicate your action to the House and the Senate. Request concurrence therein. Next bill on third reading.
House Bill 4797, authorizing municipalities to enact ordinances that allow the municipal court to place a structure, dwelling, or building into receivership.
The question before the House is, shall the bill pass? Are there objections to having the bill explained in lieu of having it read? The chair hears no objection. The gentleman from the 35th, Delegate Capito, to explain the bill.
Thank you very much, Mr. Speaker. A couple days ago in this body, we passed a bill that provided some tools to our municipalities in our state to help with the abandoned structure problem that is running, unfortunately, rampant in West Virginia, and this bill is another one of those. So what this bill does, it provides that any municipality that adopts an ordinance pursuant to this section may authorize the municipal court to place a structure, dwelling, or building into receivership when the following circumstances are present. I would just note when it says the following circumstances are present, that means all circumstances need to be present. When the owner cannot be located after reasonable inquiry by the agency as required by this section, or if the owner refuses entry. That's one. Two, the enforcement agency obtains an administrative search warrant from either the municipal court or the magistrate court located in the jurisdiction of the municipality or county where the structure, dwelling, or building is located. Three, upon entry, the agency determines that the structure, dwelling, or building is salvageable and does not require demolition. And four, the code enforcement agency proffers to the court that the structure, dwelling, or building will require demolition or presents a substantial threat to nearby structures, property, or residents due to the risk of fire, structural instability, or attractive nuisance if it is not repaired, altered, or improved in the near future. If those circumstances are present, if all four of those circumstances are present, then the structure, dwelling, or building may be placed into receivership with the municipality or other entity that can make the necessary repairs, alterations, improvements to the structure. And any owner of the structure, at any time, any owner of the structure or dwelling or building may petition the court to end the receivership proceedings. Upon a showing that they will make the necessary repairs, alterations, and improvements to the structure to satisfy the code enforcement agency, the municipal court may then end the receivership process. Mr. Speaker, that's a summarization of the bill. I'm happy to take questions. I urge its passage.
The question before the House is, shall the bill pass? Are the members who wish to speak to passage of the bill? If not, those in favor of passage will vote aye. Those opposed will vote no. The clerk will prepare the machine. Has every member voted? If so, the clerk will close the machine and ascertain the result. On this question, there are 93 ayes, 6 nays, and one member absent not voting. A majority of members having voted in the affirmative, the chair declares the bill passed. The clerk will please report the title.
House Bill 4797.
Are there amendments to the title? If not, the title is read by the clerk, will be and remain the title of the bill. The clerk will please communicate the acts to the House, to the Senate, request concurrence therein. Next bill on third reading.
Committee substitute for House Bill 4803, relating to certification of electrical inspectors.
The question before the House is, shall the bill pass? Are there objections to having the bill explained in lieu of having it read? The chair hears no objection and recognizes the gentleman of the 45th, Delegate Martin, to explain the bill.
Thank you, Mr. Speaker. The purpose of this bill is to clarify that the state and subdivisions thereof are exempt from the requirement to have building electrical inspectors licensed and to allow the West Virginia Fire Marshal to grant electrical inspector licenses to journeyman electricians. I urge passage.
The question before the House is, shall the bill pass? Are the members who wish to speak to passage of the bill? The gentleman of the 15th, Douglas Foster, is recognized.
So, looks like this bill takes electrical inspectors. I know the fire marshal's office was interested in this, allowing not just master electricians, but journeyman electricians to inspect on these houses so that they could open. So I would assert that probably the reason that they're having trouble finding enough inspectors is because the hours are too high on the certification of the master electrician, and that's why we're therefore in this bill having to drop it to a journeyman. But I do support the bill.
The gentleman of the 2nd, Douglas Desario, is recognized.
Thank you, Mr. Speaker. I'll stand against this vote, and I know that they're just looking in the wrong place when they go to find master electricians, because right here in Charleston, Local 466 has a whole bunch of what we like to call gray hairs that are retired. They'd be more than happy to have this job. They're just not looking in the right place. Thank you, Mr. Speaker.
Are there other members who wish to speak to passage of the bill? If not, then the question before the House is, shall the bill pass? Those in favor of passage will vote aye. Those opposed will vote no. The clerk will prepare the machine. Has every member voted? If so, the clerk will close the machine and ascertain the result. On this question, there are 57 ayes, 42 nays, and 1 member absent not voting. Majority of members having voted in the affirmative, the chair declares the bill passed. The clerk will please report the title.
Committee substitute for House Bill 4803.
Are there amendments to the title? If not, the title is read by the clerk will be and remain the title of the bill. The clerk will please communicate the action of the House to the Senate and request concurrence therein. For what purpose does the gentleman of the 13th, Douglas Higginbotham, seek recognition?
To make a very brief introduction.
Are there objections? No objections are heard.
In the gallery, we have the acting superintendent of West Virginia Schools. I just wanted to introduce Clayton Birch, if you haven't had the chance to meet him yet. So, Mr. Birch, please stand.
Next bill on third reading.
Committee substitute for House Bill 4823, developing a plan for periodic audits of the expenditure of the fees from the emergency 911 telephone system and wireless enhanced 911.
The question before the House is, shall the bill pass? Are there objections to having the bill explained in lieu of having it read? The chair hears no objection. The gentleman from 56, Douglas Howell, is recognized to explain the bill.
Thank you, Mr. Speaker. The purpose of this bill is to require the Public Service Commission, in cooperation with the state auditor, to develop and adopt a comprehensive plan for periodic audits of the expenditures of the 911 system fees and to submit the results to the Joint Committee on Government and Finance annually. I urge passage.
The question before the House is, shall the bill pass? Are the members who wish to speak to passage of the bill? If not, then those in favor of passage of the bill will vote aye. Those opposed will vote no. The clerk will prepare the machine. The gentleman of the 60th, Douglas Wilson, your vote's not registered. Has every member voted? If so, the clerk will close the machine and ascertain the result. On this question, there are 99 ayes, 0 nays, and 1 member absent not voting. Majority of members having voted in the affirmative, the chair declares the bill passed. The clerk will please report the title.
Committee substitute for House Bill 4823.
Are there amendments to the title? If not, then the title is read by the clerk will be and remain the title of the bill. The clerk will please communicate the action of the House to the Senate and request concurrence therein. Next bill on third reading.
Committee substitute for House Bill 4853, relating to a customer constructing a connection or other infrastructure necessary for the customer to connect to the public utility.
The question before the House is, shall the bill pass? Are there objections to having the bill explained in lieu of having it read? The chair hears no objection. The gentleman of 35th, Douglas Capito, to explain the bill.
Thank you, Mr. Speaker. The bill before us prohibits certain discriminatory practices by public utilities. The bill adds an additional prohibition. It prohibits water and sewer utilities which are owned by public service districts and municipalities from prohibiting customers from constructing, installing, and maintaining a connection or other infrastructure necessary to connect to the utility. The bill was amended to provide that the applicable utility may not prohibit a customer from electing to construct or install at the customer's expense or hire a qualified contractor to instruct and install at the customer's expense extensions of water distribution main, sewer main, connections to customer service lines or pipes, and associated equipment that are necessary for the customer to connect to the public utility to receive service, subject to certain requirements and conditions, of course, including the connection meeting the utility specifications, public utility having a right to inspect, and providing that there is no requirement to initiate service until the customer transfers title to all extension facilities. Mr. Speaker, there was some discussion on this bill as to the position of the PSC, and of course, I'm in no position to speak for them, but I can attest to the fact that the Public Service Commission did review the bill, did have input on the bill, and I believe is satisfied with the prophylactic measures in place to ensure we keep the health, safety, and welfare of our citizens intact. I urge the passage of the bill.
The question before the House is, shall the bill pass? The gentleman with 51st, Douglas Hanson, is recognized.
Thank you, Mr. Speaker. The Public Service Commission may have had input into this bill, but the people who did not have input into this bill are those that it will most affect. And in order to explain that, I need to get a little bit into the weeds into this bill. This is a bill related to water and wastewater utilities across the state of West Virginia. And this bill only applies to publicly owned systems, not privately owned systems. West Virginia American Water Company is the largest privately owned system in the state. It serves over 500,000 West Virginians. They're not covered by this bill. The provisions of this bill do not apply to West Virginia American Water Company or their customers. Again, this applies only to publicly owned water and wastewater systems. The largest publicly owned water and wastewater system in the state of West Virginia is the Morgantown Utility Board in my district. It provides water and wastewater to a little bit more than 100,000 West Virginians. That's a big number. That's a big percentage of all West Virginians. They were not consulted for this bill. They do not support this bill, and I'll explain why. But it's not just the large utilities like Morgantown Utility Board that oppose this bill. The West Virginia Rural Water Association also opposes this bill. They represent the smaller public service districts in the more rural parts of the state. They also do not support this bill. There are a few problems with this bill. And Morgantown Utility Board, or MUB as we call it, they have some firsthand experience with some of these problems. The first problem is that it allows anybody to connect to the system. If you look at the bill on page 1, lines 15 and 16, the bill allows a customer, well, to be more precise, it says the public service district or municipality that owns or operates a water or sewer public utility may not prohibit a customer from electing to construct extensions into the system. So that means any customer, me, you, somebody like me who has no experience digging holes or doing plumbing, they cannot prohibit me from connecting into their system. I don't have any qualifications. I would not know what I'm doing. But according to this bill, they have to allow me to do it. Now, like I said, Morgantown Utility Board has some experience with this. They currently do not allow this to occur, and they do not allow it to occur on purpose. They maintain control over these connections into their water and sewer pipes. And the reason is, when they didn't, years ago, it caused numerous problems. Here are some examples of the types of problems that Morgantown Utility Board ran into when anybody was allowed to do this. They had extensions multiple times that were constructed into their pipes without the person who built it having first obtained a right of way. They did not have the legal authority to cross someone's property to connect into the system. They had a case where an extension was built from one property through the basement of another property to connect into the water system. They had situations where 4-inch lines were shoved into 6-inch lines. There were cases where lines were constructed with the reverse slope. So the water flowed the wrong way. And lines constructed without the proper bedding or the proper backfill material. And what happens under this bill, if these types of inappropriate construction techniques are used, is that the utility will ultimately be left paying. And when the utility pays, the ratepayers pay. West Virginians pay. And Morgantown Utility Board has among the lowest rates in the state. They're a very well-managed utility board. They have the lowest or one of the lowest rates in the entire state. One reason for that is that they don't have to go around and fix problems that are caused by unqualified people making connections into their lines. Now, they have some more practical concerns about this bill. From a practical consideration, it would be impossible for the utilities to actually monitor the construction 24/7 to make sure that these problems don't occur. And that's especially true in a location like Morgantown that's growing. One of the issues with a growing area like Morgantown is that there are a lot of new connections into these systems. And it's impossible to monitor them unless the utility board makes these connections themselves. This bill is a threat to public health and safety if these are made incorrectly and the water supply is contaminated. This is a threat to human health and safety. And clean drinking water is one of the most fundamental pieces of infrastructure that we as a legislature need to protect. And I would submit to you to think about whether or not this bill would pass if it had to do with other types of utilities, if it had to do with gas utilities or electric utilities. And my guess is that it wouldn't gain traction. Let's not take our clean drinking water systems for granted. Let's protect them. If there's a need for a bill to allow some small water systems to allow contractors to do this type of work, then let's consider a bill that does that. But what's not appropriate is to exempt the largest water utility in the state, West Virginia American. What's not appropriate is to draft a bill without even consulting with the largest utility system that this bill will affect, a water system that strongly opposes it. Thank you.
The gentleman with the 66, Douglas Espinosa.
Thank you, Mr. Speaker. Will the Vice Chairman yield?
Yes.
Thank you. Our colleague from the 51st kind of paints a pretty dire set of circumstances here.
Yes.
That don't quite mesh with my understanding of this legislation as it was considered before the Committee on Transportation and Infrastructure. My understanding is that anyone that would engage in this type of activity would have to be qualified in order to do so. Is that your understanding as well?
Yes, sir.
My further understanding is that the utility would be required to perform inspections of the construction in order to make sure that it conforms with their requirements.
An exhaustive inspection, actually. Yes.
Okay. My further recollection, and again, please correct me if I'm wrong, the utility would have to provide their specifications so that any entity that would be engaging in these extensions would have to know what those requirements are and then comply with those requirements. Is that my understanding?
The gentleman's correct.
Okay. So the suggestion that either myself, who does not have the extensive plumbing training that we've talked about here this session, would engage in this type of activity, I mean, that seems pretty far-fetched to me. Is that, would you concur with my reading of that?
I would concur with my friend.
All right. Thank you very much.
The gentleman from the 13th, Doug Cadle.
Thank you, Mr. Speaker. I put in probably hundreds of these back in the 70s. I say I'm a truck driver. That's the simplest and easiest thing to say. But I've always had trucks, and we had heavy equipment, and we've been in excavating business. We had a contract with the county to put in water taps. So I'm going to explain to people in here how this happens. And I could let a 12-year-old kid put one in after I showed him one time. You have to have a special tool. You put a saddle. Let's dig down. We find a pipe. We shovel it out. We take a rag and wipe all the dirt off of the pipe. And we have a brass saddle with 2 U-bolts that come around the pipe. The brass saddle has a rubber gasket on the back side of it. You put that all together and tighten the bolts, and then you screw the tool, the special tool, which costs quite a bit of money, that only the county or somebody that does it a lot can have because it costs a lot. Anyway, you put that tool on the pipe fitting, and then there's a needle, because you're working with a live water line, and you will flood yourself out. I've done it before. You can't believe how fast that water comes in that hole. You can't even get out of it. But anyway, you screw that in, and that punctures a hole through the pipe. You back that back out, then you shut the valve off, you unscrew the tool, then you put your fittings on there, and you go to plastic pipe, which goes wherever. And those vary in size depending on how much water you need. Most of them are 3/4 inch. That'll provide most of the water. If you were going in a commercial building, it might be bigger, but it's pretty simple and easy, and I would urge to vote yes on this.
The lady in the 51st, Doug Fleischauer.
Thank you, Mr. Speaker. I think if you look at this bill, it's kind of interesting, the name. It's called Duties and Privileges of Public Utilities Subject to Regulations of the Commission. And then the title of this section is Discrimination Prohibited. And actually, so what's interesting is the only group that it applies to, or the only groups, are non-investor owned water or sewer public utility companies. It does not apply to West Virginia American Water. And I agree with the statements by the gentleman from Monongalia about our utility, our city utility. And the last time I can recall a conversation about the difference in the charges between Morgantown and Charleston, we paid 20%. People in Charleston paid 5 times what we pay. And maybe we should have the same rules for both companies. I see no reason why we should differentiate on whether this is allowed or not allowed. West Virginia American Water is a very large company, and they will not have to abide by this law. There is a huge number of utilities that will have to abide by this law, some that are having much more difficulty than others that would have difficulty going around and inspecting all these. So I urge rejection of this bill for the reasons stated by the gentleman from Monongalia, and also because it's just really unfair.
The gentleman from the 46th, Doug Martin.
Thank you, Mr. Speaker. I'd just like to rise in support of this bill. You know, and I appreciate the PSC working with us on this bill, because I do think that this is a problem that a lot of folks are facing in our state. And, you know, creating jobs, I know that at least in my district, this has caused a lot of job losses or jobs not being able to come here. And I'm not just talking about actually putting the line in, but where the lines are going to. And so, you know, we talked about American Water. Some folks have said they're already doing this because they're in the business of selling water. You know, and I heard somebody talk about these lines are just put in and anybody could do it. There's a 20-point checklist that you have to do in order. You have to. It says right in the bill. It talks about you have to have an agreement with the PSC in order to construct this line. And not just any contractor can do it. In order to meet that 20-point checklist, you have to be bonded, you have to have experience, you have to show that you haven't had any problems with other PSCs or PSDs. You know, when we first had written the bill, I know that there were some problems with this, but once we had the PSC help us with it, I think it alleviated a lot of the problems. This has to be engineered up. It has to be stamped. It has to be approved by the PSC, or by not only the PSD and the PSC, but also the PSC or the PSDs and the municipalities can have the right to inspect this. And so, Mr. Speaker, I just think it's a great bill. I think that this is definitely a jobs bill. I definitely think that this is one of the best ones we've had. And, Mr. Speaker, I urge passage.
The gentleman from 51st, Douglas Hanson.
Thank you, Mr. Speaker. Would the Vice Chair Judiciary yield?
Certainly.
You were asked questions by the delegate from the 66, which I think were important questions, so I just wanted to follow up on that and perhaps clarify the question about whether unqualified customers were able to take advantage of this bill. So my understanding of the question was whether what I said was right about me or somebody who's unqualified taking advantage of this bill. And I guess this gets to sort of the finer points of the language in the bill, but if I could refer you to page 1, paragraph C. And there's a lot of extra words in there, but the way I read it, it basically says a public service district or municipality may not prohibit a customer from electing to construct extensions of a water main or a sewer main. It doesn't have the word qualified for customer. Now, it does have the word qualified if they want to hire a contractor. The contractor needs to be qualified, but it specifically omits the word qualified before the word customer. So would you agree that that means any customer can do it?
Well, the gentleman from the 66 asked me leading questions, and that's not a leading question, but I'll answer it. In C, the only place I would not agree, and here's why. So it goes on further, and I would agree with you that it does say that if a qualified professional makes the installation, they do have to be quote-unquote qualified. If the customer makes the installation, I think the prophylactic measures that we've put in place in other parts of the bill that require inspection, approval, necessary build-outs, I mean, I think we've put things in place to ensure that the build-out has to be appropriate regardless of who does it. That's my reading of the bill. Your opinion, that's just my opinion. You asked for it.
Thank you. Thank you. I appreciate that.
Yes, the gentleman is still recognized.
Briefly. So I think we do agree that it doesn't say that the customer needs to be qualified. The gentleman is right that there are other provisions in there related to inspections and an extension agreement and such. And so there are some protections in that bill. But what I would submit to you and what I've heard from the Morgantown Utility Board is that at least in their situation, and this may be different from a small water system, but in their situation where they have so much expansion going on and so many needs for extensions that it is simply impractical for them to properly manage contractors and customers who are connecting to the system, notwithstanding any other protections that are in here. And for that reason, I do think it is a problem. It is a problem for keeping our drinking water clean. And I would once again urge that we vote against this bill.
The gentleman from 53rd, Douglas Jennings.
Thank you, Mr. Speaker. I happen to be an old-time contractor. I used to put water lines in Morgantown. Then MUB came along and they said, nobody's allowed to do it except for them. And I understood why they did that, because there were some bad contractors. What they would do, they would just throw the lines in. A year and a day later, MUB had to take it over. And then a lot of times they had troubles. But I'll tell you the other side of that. We bid on a house that we was going to do. We had 200 feet of sewer line we had to put in. At that times when they changed that rule, 200 feet of sewer line cost $20-some thousand. The only one we could get to do it was MUB. This is what this bill is trying to address. We could have done it for $5,000. They could have inspected it all they wanted to, but that is the difference. And this is what this bill is trying to adjust, that they can't just come in. There's other contractors, these little contractors, who only have a rubber tarred backhoe, and you want to put a mainline extension in. Well, they come in and I don't know if you've seen some of these guys work, but you usually get maybe 2 hours of work out of an 8-hour day. But it costs hundreds of dollars per hour. That's how they charge you. And it's just unfair to the contractors. Another story is a mayor of a certain town decided that he didn't like the developer, so he wouldn't allow him to attach the water supply nor to the sewer supply. Now you can appeal this and you can go to the PSC, but it takes time and it takes years to get this through. This would alleviate that problem. And that's what we're trying to do so we can have more development. We're not trying to get around anything. Anytime you put in a sewer line, that sewer line is air tested. Even the manholes put out, they're vacuum tested. Everything is tested. They site test it. When you put sewer lines in, you use what they call a pipe laser. That laser shoots down the line, and every joint has to hit a target whenever you lay that pipe. That's how sophisticated this plumbing gets to be. And what we're trying to do is to allow more development and not letting these small PSCs try to stop it just because they don't like the developer. They want somebody else to develop it. And this is what I've ran into. And I certainly support this bill. Thank you.
The gentleman from 35th, Doug Capito, to close debate on the bill. Gentleman does not wish to close debate on the bill. The question before the House then is, shall the bill pass? Those in favor of passage will vote aye. Those opposed will vote no. The clerk will prepare the machine. Has every member voted? If so, the clerk will close the machine and ascertain the result. On this question, there are 60 ayes, 39 nays, and 1 member absent not voting. Majority of members having voted in the affirmative, the chair declares the bill passed. The clerk will please report the title.
Committee substitute for House Bill 4853.
Are there amendments to the title? If not, the title is read by the clerk will be and remain the title of the bill. The clerk will please communicate the action to the House, to the Senate, request concurrence therein. Next bill on third reading.
House Bill 4859, accounting for state funds distributed to volunteer and part volunteer fire companies and departments.
The question before the House is, shall the bill pass? Are there objections to having the bill explained in lieu of having it read? The chair hears no objection. The lady from the third, Delegate Storch, to explain the bill.
Thank you, Mr. Speaker. House Bill 4859 would clarify purposes for which state funds distributed to volunteer and part volunteer fire companies and departments may be used. By law, the legislative auditor audits their use of state funds. The bill would clarify for volunteer fire departments and the legislative auditor that volunteer fire departments may use their state funds to pay their debts, but only if the debts were for purposes for which the law allows them to spend their state funds. Volunteer fire departments may invest their state funds, but volunteer fire departments may not commingle their state funds with funds from other sources. They may not use the invested money as collateral or security for any loan, and they must retain all resulting statements of accounts and earnings for a minimum of 5 years. Finally, the bill would clarify the definition of accounts used to hold those state funds. I urge passage.
The question before the House is, shall the bill pass? Are there members who wish to speak to passage of the bill? If not, those in favor of passage of the bill will vote aye. Those opposed will vote no. The clerk will prepare the machine. Has every member voted? Lady in the third. The clerk will close the machine and ascertain the result. On this question, there are 99 ayes, 0 nays, and 1 member absent not voting. Majority of members having voted in the affirmative, the chair declares the bill passed. The clerk will please report the title.
House Bill 4859.
Are there amendments to the title? If not, the title is read by the clerk will be and remain the title of the bill. The clerk will please communicate the action to the House, to the Senate, and request concurrence therein. Next bill on third reading.
House Bill 4872, modifying the criminal penalties imposed on a parent, guardian, or custodian for child abuse.
The question before the House is, shall the bill pass? Are there objections to having the bill explained in lieu of having it read? The chair hears no objection. The gentleman from the 27th, Delegate Schott, to explain the bill.
Thank you, Mr. Speaker. You all may recall that last year we passed a bill overwhelmingly that modified the criminal penalties on a parent or custodian for child abuse, which resulted in injury. The bill went to the Senate, passed overwhelmingly in the Senate, went to the governor, and the governor and or his council was disturbed by the fact that we had failed to mention a term that he felt was important in the bill. And essentially, in the bill itself was primarily targeted at repeat offenders, and the penalties on them were substantially enhanced. But also, the first part of the bill basically dealt with those who are guilty of inflicting abuse that caused bodily injury, and that was, I guess you'd say, the least serious, if there is such a thing, of the type of child abuse. In that case, the penalty was raised from 1 to 5. It went to 2 to 10, and it also gave the judge the discretion in certain circumstances to basically impose a jail term of not more than 1 year. However, the phrase "be judged guilty of a misdemeanor" with respect to that 1 year jail term was not included, and for some reason the governor concluded that that was defective and vetoed the bill. All this bill does is insert the language that the governor wants and to make him happy, and therefore I urge its passage.
The question before the House is, shall the bill pass? Or the members who wish to speak to passage of the bill? If not, those in favor of passage will vote aye. Those opposed will vote no. The clerk will prepare the machine. Has every member voted? If so, the clerk will close the machine and ascertain the result on this question. There are 99 ayes, 0 nays, and 1 member absent not voting. Majority of members having voted in the affirmative, the chair declares the bill passed. The clerk will please report the title.
House Bill 4872.
Are there amendments to the title? If not, the title is read by the clerk, will be and remain the title of the bill. The clerk will please communicate the action of the House to the Senate and request concurrence therein. Next bill on third reading.
House Bill 4882, authorizing limited sampling and limited sale of wine for off-premises consumption to wineries not licensed in the state.
The question before the House is, shall the bill pass? Are there objections to having the bill explained in lieu of having it read? The chair hears no objection and recognizes the gentleman from the 66, Douglas Espinoza, to explain the bill.
Thank you, Mr. Speaker. This bill allows wineries not currently licensed or located in West Virginia to have a license to do a limited sampling and limited sale of wine for off-premises consumption at nonprofit events in a very limited capacity, in hopes that such wineries might eventually obtain a permanent winery or farm winery license in West Virginia. That's the bill, Mr. Speaker. I urge passage.
The question before the House is, shall the bill pass? Are there members who wish to speak to passage of the bill? If not, then the question is, shall the bill pass? Those in favor of passage will vote aye. Those opposed will vote no. The clerk will prepare the machine. Has every member voted? If so, the clerk will close the machine and ascertain the result on this question. There are 80 ayes, 18 nays, 4 members absent not voting. A majority of members having voted in the affirmative, the chair declares the bill passed. The clerk will please report the title.
House Bill 4882.
Are there amendments to the title? If not, the title is read by the clerk, will be and remain the title of the bill. The clerk will please communicate the action to the House, to the Senate, request concurrence therein. Next bill on third reading.
Committee substitute for House Bill 4886, requiring the PSC and the DOH to submit reports concerning activity on the coal resource transportation road system.
The question before the House is, shall the bill pass? Are there objections to having the bill explained in lieu of having it read? The chair hears no objection and recognizes the gentleman with 56, Douglas Howell, to explain the bill.
Thank you, Mr. Speaker. This bill requires the Public Service Commission and the Division of Highways to each submit reports to the Commercial Motor Vehicle Weight and Safety Enforcement Advisory Committee, to the Joint Committee on Government and Finance concerning activity on the coal resource transportation road system about violations relevant to PSC rules and current roads conditions. I urge passage.
The question before the House is, shall the bill pass? The gentleman with 25th, Douglas Painter, is recognized.
Will the chair yield? Do they already not have to report this stuff? I know the shippers have to the shippers have to report any and all violations.
I'm told that the DOH does not report to the Safety Council and neither report to the Joint Committee.
Okay, so this wouldn't affect shippers or receivers?
No.
Okay. Thank you.
The question before the House is, shall the bill pass? Those in favor of passage will vote aye. Those opposed will vote no. The clerk will prepare the machine. Has every member voted? If so, the clerk will close the machine and ascertain the result. On this question, there are 96 ayes, 3 nays, and 1 member absent not voting. Majority of members having voted in the affirmative, the chair declares the bill passed. The clerk will please report the title.
Committee substitute for House Bill 4886.
Are there amendments to the title? If not, the title is read by the clerk will be and remain the title of the bill. The clerk will please communicate the action of the House to the Senate and request concurrence therein. Next bill on third reading.
House Bill 4887 relating to revocation, cancellation, or suspension of business registration certificates.
Question before the House is, shall the bill pass? Are there objections to having the bill explained in lieu of having it read? The chair hears no objection. The gentleman from the 45th, Douglas Martin, to explain the bill.
Thank you, Mr. Speaker. The purpose of this bill is to implement recommendations of the legislative auditor that are necessary for the tax commissioner to purge inactive or fraudulent business licenses. I urge passage.
The question before the House is, shall the bill pass? Are there members who wish to speak to passage of the bill? If not, those in favor of passage will vote aye. Those opposed will vote no. The clerk will prepare the machine. Has every member voted? If so, the clerk will close the machine and ascertain the result. On this question, there are 97 ayes, 2 nays, and 1 member absent not voting. A majority of members having voted in the affirmative, the chair declares the bill passed. The clerk will please report the title.
House Bill 4887.
Are there amendments to the title? If not, the title is read by the clerk will be and remain the title of the bill. The clerk will please communicate the action of the House to the Senate and request concurrence therein. Next bill on third reading.
House Bill 4959 relating to clarifying the ability of the Economic Development Authority Board of Directors to enter into any contracts necessary to carry out its duties.
Question before the House is, shall the bill pass? Are there objections to having the bill explained in lieu of having it read? None are heard. The gentleman from 56, Douglas Howe, to explain the bill.
Thank you, Mr. Speaker. The purpose of the bill is relating to clarifying the ability of the Economic Development Authority Board of Directors to enter into any contracts and grants the Economic Development Authority has an exemption from the authority of the Purchasing Division. I urge passage.
The question before the House is, shall the bill pass? Are there members who wish to speak to passage of the bill? If not, then those in favor of passage will vote aye. Those opposed will vote no. The clerk will prepare the machine. Has every member voted? If so, the clerk will close the machine and ascertain the result. On this question, there are 97 ayes, 2 nays, and 1 member absent not voting. A majority of members having voted in the affirmative, the chair declares the bill passed. The clerk will please report the title.
House Bill 4959.
Are there amendments to the title? If not, the title is read by the clerk will be and remain the title of the bill. The clerk will please communicate the action of the House to the Senate and request concurrence therein. Next bill on third reading.
House Bill 4960 relating to exempting from licensure as an electrician.
The question before the House is, shall the bill pass? Are there objections to having the bill explained in lieu of having it read? The chair hears no objection. The gentleman from the 15th, Douglas Foster, to explain the bill.
Thank you, Mr. Speaker. The purpose of this bill is to exempt licensure as an electrician for any person who installs low voltage wiring, which is defined as 80 volts or less, and adds the person's immediate family to the exemption for the work requirement when they're working on their own property, so that a brother or son or daughter could help their family install a ceiling fan or light.
The question before the House is, shall the bill pass? Are there members who wish to speak to passage of the bill? The gentleman from the second, Douglas Nasario, is recognized.
Thank you, Mr. Speaker. I think there's a little bit of confusion right now. I've never seen a low voltage ceiling fan. So we need to understand what we're working here with, because a lot of people apparently don't understand. I take offense to some of the remarks that made today about some people only work 2 hours, get 8 hours pay. Well, this bill right here, there was an agreement made to it, so that we're not taking care of all the union thugs and their buddies. There was an agreement made to pass this. After that, I started receiving phone calls from contractors, union and non-union, that are saying that they're buying these low voltage systems out of state. And the people they're buying them from don't want to come to West Virginia and get a license. So you know what? Now they don't have to. They can come and put them in. So feel assured, when you vote for this, you're taking money out of the union and non-union contractors in this state that are getting paid for installing low voltage systems that you don't have to have a license for. So you answer your contractors, whether they be union or non, because this bill, as I said, I wouldn't have stood up and said anything today, but I take offense of every day getting poked in the eye for the people that go out to work and try to work for a decent wage, a decent way to have health benefits, a way to retire with some dignity, when all I ever hear is we have an uneducated workforce. So you know what? Let's just do away with all the licensures in this the state of West Virginia. Let's let anybody work on whatever they want, and you all should be good with it, apparently, by the way you vote. Thank you, Mr. Speaker.
Are there others who wish to speak to passage of the bill? Does the gentleman of the 15th, Delegate Foster, wish to close debate on the bill?
Yes, Mr. Speaker. I understand that there's some concern about other comments related. The gentleman expressed concerns about other comments made on this floor that's not related to this bill. First of all, I want to clarify what this bill does, try to explain it a little bit better. For example, on a low voltage wiring system, such as your deck lighting or your landscape lighting, what happens is there will be a transformer put in that takes the electrical charge down to, say, in this bill, it will be below 80 volts. And what that does is that transformer must be installed by an electrician. It has to be installed by an electrician, but this bill allows anything after that, which would be the low voltage, to be installed. For example, the person putting in your deck would be installing the lights, and that, or somebody doing your landscaping work. But this is something that's a low voltage that's not required, and I definitely support that part of the bill. But and then the other exception, I know the gentleman mentioned the ceiling fan and stuff are not low voltage. They're not. But what the exemption is related to a person, an owner or leasee of a property. Right now we exempt an owner or leasee of a property, but for example, like my mother is 65 years old. She may have trouble installing a ceiling fan by herself, but we exempt it and she's allowed to do it, but I'm not allowed to help her. In plumbing, we've already made this exception that a family member can help them install it. So that's what that portion of this bill does. That's not related to the low voltage portion. The low voltage portion is just related to the 80 volts or less, and allowing those to be installed by somebody that wasn't a licensed electrician. But to clarify, the whole system can't be installed by them. The transformer must be installed by an electrician. So I would definitely urge passage of this bill. And again, I appreciate the help of Mr. Steve White for helping me draft this bill.
The question before the House is, shall the bill pass? Those in favor of passage of the bill will vote aye. Those opposed will vote no. The clerk will prepare the machine. Has every member voted? If so, the clerk will close the machine and ascertain the result. On this question, there are 51 ayes, 48 nays, and 1 member absent not voting. A majority of those members present having voted in the affirmative, the chair declares the bill passed. The clerk will please report the title.
House Bill 4960.
Are there amendments to the title? If not, the title is read by the clerk, will be and remain the title of the bill. The clerk will please communicate the action of the House to the Senate, request concurrence therein. For what purpose does the gentleman from 22nd, Douglas Jeffrey, seek recognition?
Thank you, Mr. Speaker. Unanimous consent for an introduction.
Gentleman may proceed.
The doctors of the day are Carl Schrader and Kyla Whipp from Morgantown, West Virginia. If the House would make them welcome.
Are there further bills on third reading? If not, lady from the 49th.
Thank you, Mr. Speaker. I move the House stand in recess until 2:50 p.m.
Is there objection to the House standing in recess until 2:50? Chair hears no objection. The House will be in recess until 2:50 p.m.
Senate will please come to order. The Senate will please come to order. All those not having privileges of the floor will please vacate the chamber. And with those on the floor and our guests in the gallery, please rise as we are led in prayer this morning by Pastor Dennis Dye, who's the interim pastor for Whitesville First Baptist Church in Whitesville, West Virginia. And then please remain standing as we are led in the pledge this morning by the senior senator from the 15th, Pastor Dye.
Please bow your head.
Heavenly Father, as we come together this morning as a body of leaders and staff chosen by the people of this great state of West Virginia, let us give you praise and thanksgiving for your great love that you have bestowed upon us through your Son, Jesus Christ. Father, in your word, we are told that true wisdom comes from you and is given to those who ask it without doubting. So this morning, I intercede for all the members of the Senate and their staff, that you will bless each one of them with your wisdom. Wisdom to lead this state and to enact the laws that will not only honor you, but will be an expression of your love for your children in West Virginia. I ask, dear Heavenly Father, that you will anoint each senator with clear understanding of the needs of its citizens and the spirit of humility and cooperation in order to meet those needs. Finally, I pray that through your wisdom, your understanding, your humility, and the cooperation that you will give each senator to this state, we will become a beacon of democracy to every state in the United States of America. I ask these things in the name of Jesus Christ, your Son, and our Lord and Savior. Amen.
Amen. Thank you, Pastor. The senior senator from the 15th.
Members and guests, please join me as we recite the pledge to our great nation. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all.
Thank you. You may be seated. Reading of the journal.
West Virginia Legislature, Senate Journal, February 24th, 2020. The Senate met at 11:12 a.m. Senator Carmichael.
The senator from Cabell County requests unanimous consent that further reading of the journal be dispensed with and that it be approved as having been read. Is there objection? Chair hears none, so ordered. Introduction of guests. On behalf of the Senate, it is my pleasure to welcome our honorary pages for the day. Please stand and be recognized when your name is called. As guest of the senior senator from the 8th, we have Mackenzie Miller and Mickey Newdecker. As guest of the senator from Boone County, we have Chelsea Van Adder, Connor Bradford, Ryan Simpkins, Ashley Day, Ellie Goodbye, Ty McClung, and Tristan Messer. And as guest of the senior senator from the 17th, Caitlin Swore and Madeline Swore. They're standing in the front of our chambers as the Senate would give them a warm Senate welcome. Thank you. You may be seated. There are further introductions. Recognize the junior senator from the 17th.
Thank you, Mr. President. On behalf of the Senate, it is my pleasure and yours to introduce our doctors for the day. With us today, we have Dr. Carl Schrader as well as Dr. Colin Whipp. At the rear of the chamber, if you wouldn't mind standing, let the Senate give you a warm welcome.
The senator from Raleigh County.
Thank you, Mr. President. It's your pleasure and mine to welcome some guests in the galleries. In the North Gallery, we have Sam and Wendy Robinson. They are here visiting us today from Indiana. And then also in the President's Gallery, we have Landon Chambers. He is here, a 10th grader with Shady Spring High School, and he is shadowing me today and looking at all that is going on. I told him it was a good day to come. Would the Senate please make them feel welcome?
The senator from Preston County.
Thank you, Mr. President. It's your pleasure and mine, and on behalf of the senator from Tucker County and myself, we'd like to recognize some students today that's in the North Gallery. If they would rise when I call their name. From Aurora Middle School, we have Grace Schaefer and Carmichael Myatt, and their chaperone, Molly Gank. Also from East Preston, Tyra Host, Paige Lockery, and they're also chaperoned by Molly Gank. From South Middle School, we have Ashley Knowlton, Emily Buckaloo, Katie Annan, Caitlin Baker, Alexis Crosco, Tegan Findley, Taryn Veltri, Ethan Miller, Madeline Felix, and their chaperones today are Terry Hoyt, Nick Miller, Andrea Buckaloo, Katrina Knowlton, Philip Knowlton, and Heather Felix. If the Senate would please make them welcome. Thank you for being here today.
The senator from Boone County.
Thank you, Mr. President. On behalf of the senator from Logan, we're very pleased to have the chaperones of our pages from Scott High School today. They are Rhonda Bradford, Diane and Glenn Fields, Tamara Simpkins, Corey Fields, Caleb Simpkins, Jacqueline Day, Adam Lee Messer. If they'd stand, the Senate make them welcome.
The senator from Nicholas County.
Thank you, Mr. President. It's your pleasure as well as mine, and on behalf of the senior senator from the 11th, I'd like to introduce today the Nicholas County Commission President, Garrett Cole, and along with him, Jennifer Percy, the Executive Director of the West Virginia County Commission Association, if the Senate would make them welcome.
The senator from Monroe County.
Thank you, Mr. President. In the President's Gallery, it's my honor and yours, along with my friend and senator from Greenbrier County, our youth in government from Monroe County, across the county from Peterstown Middle School and Mountain View Elementary Middle School in Union, West Virginia. As I call your name, if you'll please stand and remain standing. From Mountain View, Tyler Fury, Jordan Lowe, Jackson Phipps, and Morgan Vass. And from Peterstown, we have Elizabeth Atkins, Isabel Atkins, Paige Amos, Caroline Keys, my daughter, Hannah Mann, Sadie Maxey, Mary Beth Meadows, Abigail Tolley, Catherine Vyers, and Bryson Witt, along with their advisor, Miss Ashley Mann. If the Senate would, give them a good Senate welcome.
The senator from Wyoming County.
Thank you, Mr. President. I wanted to introduce everybody to our circuit clerk from Wyoming County, Mr. Dave Bugstover. Could everybody give him a welcome? Thank you for coming.
The senator from Upshur County.
Thank you, Mr. President. On behalf of the senator from Nicholas and me, I would like to introduce the following people from the 11th Senatorial District, and I'll just advise the body that the 11th Senatorial District is the largest Senate district east of the Mississippi. From Upshur County, we have Terry Cutright, President, County Administrator Kerry Wallace, and Assessor Dustin Zickafus, and from Randolph County, we have the Assessor Phyllis Yoakum. If they please stand and the House or the Senate make them welcome.
Further introductions, the senior senator from the 17th.
Thank you, Mr. President. On behalf of the junior senator from the 17th, we're honored to have with us the mother of our pages today, Allison Soar. If she could stand, the Senate make her feel welcome.
The senator from Harrison County.
Thank you, Mr. President. On behalf of my senior senator from Braxton, it's your honor and mine, sir, to again recognize the Harrison County Assessor in the President's Gallery, Rocky Romano. And joining him today are Susan Thomas, who is the current Harrison County Clerk, wonderful person who does a great job in Harrison County, along with the President of the Association of Counties, Phyllis Yoakum, out of Randolph County. They're all here to express their concerns today, Mr. President, with SB 9, and I'd like to have the Senate make them feel welcome. Thank you.
Further introductions? Further introductions. Communications from the House of Delegates.
The Clerk of the House announced that the House amended and passed committee substitute for Senate Bill 339, authorizing DHHR promulgate legislative rules.
Message be received. Recognize the junior senator from the 17th.
Having the read.
Is there objection? Chair hears none. Senator may proceed.
Thank you, Mr. President. The purpose of the bill is to authorize the DHHR to promulgate legislative rules. The House amendments add dried leaf as an acceptable form of medical cannabis used via nebulizer or vaporization, and allows for dermal patches as a form of medical cannabis. It also reduces the number of years which security recordings are kept from 4 to 2. In addition, it modifies the definition of medical cannabis by referencing the acceptable forms in Series 10 of the rule. However, the definition does not reference the Medical Cannabis Act. Mr. President, the Senate amendment simply clarifies and gives reference to the Medical Cannabis Act in the definition of the medical cannabis. I urge adoption of the amendment.
Is there further discussion? Further discussion? Not. Question before the Senate is adoption of the amendment as explained by the junior senator from the 17th. All those in favor will say aye. Those opposed, no. The ayes appear to have it. The ayes do have it. I declare the amendment adopted. Recognize junior senator from the 17th.
Thank you, Mr. President. I move the Senate concur in the House amendments as amended.
Junior senator from the 17th moves that the Senate concur in the House amendments as amended. Is there further discussion? If not, all those in favor will say aye. Those opposed, no. The ayes appear to have it. The ayes do have it. I declare the motion adopted. Question now is, shall the bill pass? Is there further discussion? If not, all those in favor will vote yea. Those opposed will vote nay. The clerk will prepare the machine. Has every member voted? Has every member voted? If so, the clerk will close the machine and ascertain the results on this question being 31 yeas, 3 nays, 0 absent and not voting. More than the majority of those elected having voted in the affirmative, I declare the bill passed. I recognize junior senator from 17.
Thank you, Mr. President. I move the bill be made effective from passage and request unanimous consent that the roll call used on passage of the bill be used to make it so effective.
Junior senator from the 17th moves that the bill be made effective from passage and request unanimous consent that the roll call used on passage of the bill be used to make it so effective. Is there objection? Chair hears none. On this question remaining 31 yeas, 3 nays, 0 absent and not voting. More than 2/3 of those elected having voted in the affirmative, I declare the bill effective from passage. Clerk will communicate the action of the Senate to the House. Further House messages.
The House amended and passed committee substitute for Senate Bill 657, allowing designation of tourism development districts.
Message be received. Recognize junior senator from 17.
Thank you, Mr. President. I move the Senate concur in the House amendments to Senate Bill 657.
Junior senator from the 17th moves that the Senate concur in the House amendments to Senate Bill 657. Is there discussion? Recognize the junior senator from the 17th. I'll get to him and get to you in just 1 second. Recognize the junior senator from 17.
Thank you, Mr. President. The purpose of the bill for Senate Bill 657 allows the Development Office to establish up to 5 tourism development districts in Class 4 municipalities upon application by the developer of a tourism development project of $25 million or more who has already received a tax credit against the sales tax for the project. Projects within tourism development districts are largely exempt from municipal regulation, but the developer must pay service and utility fees and municipal taxes for the project. The House made a series of piecemeal amendments that make minor technical changes to clarify and improve the bill. The amendments do not change the substance or intent of the bill in any way. I urge passage.
Question before the Senate is adoption of the motion that the Senate concur in the House amendments to Senate Bill 657. Is there further discussion? Recognize the senior senator from the 16th.
Thank you, Mr. President. Would the majority leader yield for questions?
Senator yields. Senator does yield.
So this actually takes away all local control in Class 4 for these particular projects. Is that correct?
Well, it takes away some control, but not total control of the projects. They don't pay taxes. More control of the freeway. Takes away regulating municipal equipment codes and things like that.
Actually, it does take some control, but not total control.
So what control do they still have? Because the bill that passed here, it took all control away. It said no ordinances, the local folks would have no input at all. Did they make any corrections on that in the House?
The House amendments did not make any changes to that portion of the bill from what the Senate passed.
Okay, so that goes to what local control is there if there's, because it didn't have any leaving here, so.
Just that they're still responsible for paying municipal fees, taxes, etc.
Right, the developer is responsible for paying the fees. But as far as local control or any input, it basically has none. It took the local control away.
That's correct.
That's correct.
And there's 5 projects, not just one. Is that right?
There can be up to 5.
Up to 5. And also, in regards, we just passed a bill here giving highways more control or more power, particularly for taking. This allows for the highway department to come in and actually use eminent domain to take property. Is that correct? Or the roads?
It does not.
It does not prohibit it. The highways has the right to come in and be able to take the roads.
It doesn't address this. It just says they're going to assist in roads, but it doesn't say they're going to take roads or not take roads.
It doesn't change or make a difference either way.
I understand the bill doesn't, but the highways have that power. You're bringing the highways department in. There's no local control. Highways could exercise eminent domain in taking property. Say that there's some type of property in this district, they can do that.
My understanding, it's not within the scope of the bill. That's not addressed in this bill.
I understand it's not addressed in the bill, but it allows for the highways department to do this. There's no way of prohibiting it.
That's correct. So if the bill passes or doesn't pass, does that change?
So my understanding, regardless if this bill passes or doesn't pass, is that is true regardless.
Senator, I got to disagree, because if this bill passes, it takes away all local control and it opens up that community for eminent domain and other types of taking that the state can come in, because the state is in control of this project. Between that and the developer, the local folks have no input on this any longer. So it does allow for eminent domain.
What I'm being told, the scope of the bill does not affect eminent domain one way or another.
Okay, that may be, that is correct. But we passed a bill that gave Highway Department more power, okay? And the Highway Department can exercise all the powers they have right now within this tax district, where there would be no opportunity for the local people in any way to have input on that. They can actually take property. And Kilo versus New London talks about this, of taking private property away, the public institution taking private property away from one individual, giving it to another for public use. This makes this, by setting up this tax district, would make this vulnerable to be able to be utilized, would it not?
Does that open it up to where they can? Actually, not just because they can. There's all the other subject of zoning ordinance. That is eminent domain issues.
So council feels this is going to make no impact whatsoever off of current standards, regardless if this tax district is in there or not. It makes no difference in terms of eminent domain, whether they can come in now or come in regardless if this is in existence or not.
Well, I disagree with your counsel in regards to the fact of the matter is it does open it up. It invites the Department of Transportation in there. It allows them to use all their powers to be able to grab the land to make it part of that tax district, and that's between the state and the developer, and those local folks have no input on that. It does open it up and make it vulnerable. So
Recognized for questions and response.
Thank you, Mr. President. Mr. President, again, you know, I understand the intent of this, and I'm all for the initial project that actually is being, that may have predicated this. I don't think I think they're using a situation in my district to actually perpetuate another type of an agenda. But the thing of it is the project in my district, my understanding is moving forward regardless of this. So this may not even have to be used, which will be a very good thing. The only problem with this is the unintended consequences of what happens. It's not talking about one project. That one project will happen. What it's going to do is make it vulnerable. About 73% of our municipalities throughout the state of West Virginia vulnerable to a taking. To basic a taking, where an industry can come in and not even go to the local community, Now, I'm not talking about a specific project, because the project in Harpers Ferry did go to local community. I'm talking about in general. This bill will allow for anybody to go to the state and bypass a local community and be able to do a project. Yes, get tax credit, tourism tax credit. And we all say, well, tourism. Well, you know what? Let me tell you what tourism tax credit's allowed. And it'd be a good project. Hershey, the Hershey Company. What they did is they actually built a visitor center, and they took tourists through their chocolate factory, and they were able to get tourism dollars. Budweiser, down in Virginia, Williamsburg, did the same thing. That's not a problem. But there's other companies that come in, such as Rockwell, that wasn't accepted by my community. And the way they can get tourism dollars is very simply, the product Rockwell is producing is only 3 in the world produce this product. They can develop a visitor center and do tours of it and get themselves a tourism dollar or tourism dollars to do it. And therefore qualify as a tax district. Listen, maybe all of our communities would want things like that. And that's fine, but let the local people be able to also express that and be part of that. And I just can't believe that this conservative body, so-called conservative body, run by the Republicans, is actually not upholding local control. That's even in your preamble. This is taking local control away from folks, because we see a shiny object, and what is the ramifications of this? This allows Highway Department to come into these communities and do eminent domain, not for roads, but grabbing for land for tourism development. What if a farmer wants to keep their farmland, and part of this tourism district that's between the developer and the state, their land's part of it, they don't want to sell their land, but the Highway Department comes in and says, tough. That's tough. This is part of the tourism district. They're investing more than $25 million. Your farmland's best use is to do this. It's a taking. It's a taking clause that we're putting in place. And I'm just going to tell you, you may get the good, but also think about the bad and the ugly that's going to come along. And I hope that everybody who votes for that, and I'm going to carry it around in my pocket, because when the bad and the ugly does come into these small communities, I'm going to make sure everybody understands what you invited in. Because what you're trying to do here is wrong. And the process is going about taking away people's self-determination, taking local control, bypassing local people, and basically taking their properties to have no recourse is wrong. Mr. President, I would ask that people vote against this. Thank you.
We are debating the amendment, so I just wanted to be clear on that. Senator from Harrison seeks recognition regarding the motion by the junior senator from the 17th to concur in the House amendments to Senate Bill 657.
Question of the President.
Yes.
Debating this amendment is also debating against the bill, isn't it, if we don't concur?
No, we'll be voting on the bill after the amendment is disposed.
I will wait then, Mr. President. Okay. Thank you.
Is there further discussion regarding the motion by the junior senator from the 17th? Not. The question for the Senate is that the Senate concur in the House amendments to Senate Bill 657. All those in favor will say aye. Aye. Those opposed, no. The ayes appear to have it. The ayes declare the amendment adopted, or declare the motion adopted. The question now is, shall the bill pass? Is there further discussion? Recognize the senator from Harrison County.
Thank you, Mr. President. You know, I've often said that if hypocrisy was fuel, we wouldn't have an energy crisis. And, you know, it's on both sides. Don't believe that I'm blaming any one side for hypocrisy, but this is the epitome of hypocrisy, because we stand up here and demand local control. How many times have we heard it said in response to one bill after another, and here we are doing the exact opposite. You know, I don't know about the hilltop development. I mean, personally, if somebody wanted to come in my area and I had a vote to bring a $135 million development, I'd do that in a second. I don't live in Harpers Ferry. I'm not from Harpers Ferry. But you know what? I am from Harrison County, West Virginia, and I don't want to give up my area's ability to say no to something they don't want. And that's what we're doing by this bill. We're telling everybody, every one of your counties, every one of your cities, that you can say no, you don't want something, and the state's going to force it down your throat. And think about what we've done here. This is a $100 million plus development. The limit in this bill is $25 million. That's a good garbage dump. Now you got to make it a tourist attraction, but listen, I can make anything a tourist attraction. To get around that rule, that doesn't mean anything. You know, the gentleman from Berkeley, he lives in that area, and he's still standing up and saying, this is a bad idea, not just for his area, not just to force this down their throat, but for every jurisdiction in West Virginia below the state level of government. I think seriously. I'm not going to carry your names in my pocket, but you know what? Every time I hear you say local control to justify a bill, I'm going to raise this vote up. I'm going to remind you that you voted against local control because you didn't like it in one instance, and you've changed the face of West Virginia by doing so. I urge a no vote on this bill.
Is there further discussion? Further discussion? Not the question before the Senate is, shall the bill pass? All those in favor will vote yea. Those opposed will vote nay. The clerk will prepare the machine. Has every member voted? Has every member voted? So the clerk will close the machine and ascertain the results. On this question there being 21 yeas, 13 nays, 0 absent and not voting, more than the majority of those present and voting having voted in the affirmative, I declare the bill passed. Junior Senator from 17th.
Thank you, Mr. President. I move the bill be made effective from passage.
Junior Senator from the 17th moves that the bill be made effective from passage. All those in favor will vote yea. Those opposed will vote nay. The clerk will prepare the machine. Has every member voted? Has every member voted? So the clerk will close the machine and ascertain the result. On this question being 21 yeas, 13 nays, 0 absent and not voting, less than 2/3 of those elected having voted in the affirmative, I declare the motion rejected. Clerk will communicate the action of the Senate to the House. Further bills on third read, or House messages.
The Clerk of the House announced the passage by that body of committee substitute for House Bill 4009 relating to the process for involuntary hospitalization.
Message will be received and referred to Committee on Health and Human Resources with a second reference to the Committee on the Judiciary.
Committee substitute for House Bill 4252 authorizing miscellaneous agencies and boards to promulgate legislative rules.
Message will be received and referred to Committee on the Judiciary.
Committee substitute for House Bill 4388 limiting the Alcohol Beverage Control Commissioner's authority to restrict advertising.
Message will be received and referred to the Committee on the Judiciary.
Committee substitute for House Bill 4530 authorizing daily passenger rental car companies to charge reasonable administrative fees.
Message will be received and referred to the Committee on the Judiciary.
Committee substitute for House Bill 4626 West Virginia Development Achievements Transparency Act.
Message will be received, referred to the Committee on Economic Development with a second reference to the Committee on Finance.
Committee substitute for House Bill 4668, creating the misdemeanor crime of trespass for entering a structure that has been condemned.
Message will be received and referred to Committee on the Judiciary.
Committee substitute for House Bill 4748, relating to the increase of fees that private non-government notary publics may charge for notarial acts.
Message will be received, referred to Committee on Government Organization.
The House adopted committee substitute for House Concurrent Resolution 75, naming the highest peak on Wolf Creek Mountain in Monroe County, Boone's Peak.
Message will be received, referred to Committee on Natural Resources with a second reference to the Committee on Rules. Are there further communications from the House of Delegates?
No, sir.
Communications from the Executive?
There are none.
Reports from standing committees.
Your Committee on the Judiciary has had under consideration committee substitute for Senate Bill 119, creating online voters guide, and has amended same, now on second reading, having been read a first time and referred to the Committee on the Judiciary on February 24th, 2020, and reports the same back with the recommendation that it do pass as amended. Respectfully submitted, Charles S. Trump IV, Chair.
Report will be received. Recognize the Senator from Morgan County.
Thank you, Mr. President. I request unanimous consent that the bill be taken up for immediate consideration, that the amendment be reported on the second reading and read a second time.
Is there objection? Chair hears none. Clerk will read the bill a second time.
Committee substitute for Senate Bill 119, creating online voters guide. Second reading of the bill.
Are there amendments to the bill?
Yes, sir. The Committee on the Judiciary moved to amend the bill.
Recognize the senator from Morgan County.
Thank you, Mr. President. I request unanimous consent to explain the amendment in lieu of having it read.
Is there objection? Chair hears none. Senator may proceed.
Thank you, Mr. President. The committee amendment adopted to that bill narrowed it substantially. It requires additional information that people have to put in their certificate of filing when they file for public office. And the additional information includes campaign websites, campaign Facebook connects. I'm not a Facebook person, so campaign Twitter accounts, that sort of thing. And it directs the Secretary of State to take that information and compile basically an online guide for all the candidates who filed for public office, so that and it's digital, it's electronic, but so that someone utilizing the Secretary of State's website could then see all the candidates, and if he or she wanted to learn more information about a particular candidate, then by mouse click could be led to a website or a Facebook page or a Twitter. I'd be happy to try to answer questions, Mr. President. Otherwise, would urge the adoption of the committee amendment.
Is there further discussion? Further discussion. Not question for the Senate is adoption of the Judiciary Committee amendment as explained by the senator from Morgan County. All those in favor will say aye. Those opposed, no. The ayes appear to have it. The ayes do have it. I declare the committee amendment adopted. Are there further amendments to the bill?
No, sir.
Not. The bill will be engrossed and advanced to third reading. Are there further reports from standing committees?
No, sir.
Reports from select committees?
There are none.
Introduction of bills.
Senate Bill 852 by Senators Carmichael, Mr. President, and Prezioso by request of the Executive Supplemental Appropriation of Public Monies from Treasury to Department of Education School Building Fund.
Bill will be referred to Committee on Finance.
Senate Bill 853 by Senators Carmichael, Mr. President, and Prezioso by request of the Executive Supplemental Appropriation of Public Monies from Treasury to Department of Education School Building Authority.
Bill will be referred to the Committee on Finance. Further bills, introductions of bills?
No, sir.
Resolutions.
Senate Resolution 52 by Senator Tarr designating February 26, 2020 as West Virginia Child Care Association celebrating Children and Families Day.
Under the rules of the Senate, the resolution will lie over one day. Are there further resolutions?
No, sir.
Motions? Petitions?
There are none.
Unfinished business?
Senate Concurrent Resolution 47 requesting study of effectiveness of current laws maintaining private roads.
Resolution will be referred to Committee on Transportation and Infrastructure.
Senate Concurrent Resolution 48, naming the U.S. Army Private First Class Ronald Lee Berry Memorial Bridge.
Resolution will be referred to Committee on Transportation and Infrastructure.
Senate Concurrent Resolution 49, requesting DOT-DOH evaluate October 1, 2018 updated oil and gas road policy.
Question before the Senate is adoption of the resolution. Is there discussion? Recognize the senator from Morgan County.
Thank you, Mr. President. I request unanimous consent that the resolution be taken up for immediate consideration and considered for adoption.
Question for the Senate is adoption of resolution. Is there discussion? Recognize the senator from Morgan County.
Thank you, Mr. President. This is a resolution adopted by the Judiciary Committee and recommended relating to an updated oil and gas road policy. It started actually with a bill that was referred to our committee, and late in the session and with lots of complexities, the committee decided to convert it to a study resolution. So what this resolution would require is that the Department of Transportation evaluate whether changes to the October 1, 2018 updated oil and gas road policy are needed to reflect current economic conditions and infrastructure conditions. The objective of the study plan would include the following. One, identifying if there are gaps in existing policy that resulted in damages to West Virginia roads without correction or reimbursement of costs. Two, coordinating with stakeholders to resolve the issues identified. And three, if necessary, proposing recommendations for specific amendments to the oil and gas road policy, an alternative policy, or permitting scheme. The West Virginia Department of Transportation would make its report to the Joint Legislative Oversight Committee on Transportation and Infrastructure during this summer. So I'd be happy to try to answer any questions, Mr. President. Otherwise, urge the adoption of the resolution.
Is there further discussion? Recognize the senator from Wetzel County.
Thank you, Mr. President. I rise in support of this resolution. I think a lot of the gas companies have done a lot of good on maintaining the roads, but we still have some bad players out there that are not taking care of the roads that they have destroyed. So I would support this resolution. What we have now is definitely not working, so we need to get a study to find something that will work to preserve our roads. I urge passage of the adoption of the resolution.
Is there further discussion? Not. The question before the Senate is adoption of the resolution. All those in favor will say aye. Those opposed, no. The ayes appear to have it. The ayes do have it. I declare the resolution adopted. Clerk will communicate the action of the Senate to the House. Further unfinished business.
Senate Resolution 50 designating February 25th, 2020 as Fairmont State University Day.
The senator from Marion County.
Thank you, Mr. President. I ask unanimous consent that the resolution be taken up for immediate consideration, the committee reference be dispensed with, and a resolution be put upon its adoption.
Senator from Marion County requests unanimous consent that the resolution be taken up for immediate consideration, committee reference be dispensed with, and that the resolution be placed upon its adoption. Is there objection? Chair hears none. Clerk will please read the resolution.
Senate Resolution 50 designating February 25th, 2020 as Fairmont State University Day at the Legislature.
Question before the Senate is adoption of the resolution. Is there discussion? Recognize the senator from Marion County.
Thank you, Mr. President. Today is Fairmont State University Day at the Legislature, and we're proud to have a contingent in the back of the chamber here. But let me tell you a little bit about the university. Fairmont State University is a comprehensive liberal arts university that turns opportunity, passion, and hard work into excellence. Fairmont State offers dozens of certificate and degree programs and associate, baccalaureate, and master's degree level programs. They have 140 fields of study and 40 degree programs. Let me share also with you some of the enrollment statistics we have at Fairmont State University. We serve the students of this state. 89% of the students are in-state students. We also, out of that number, have 40% non-traditional students, 61% first-generation students, and 90% of those students receive financial aid. We're taking care of the educational needs of students in West Virginia. Students from every county in the state attend Fairmont State because they have among the lowest tuitions in West Virginia. Second lowest funded four-year institution in West Virginia, so they do more with less than most financial educational institutions in the state. Fairmont State generates a total impact of $83 million to our economy. In 2018, for every dollar that this legislature spends at Fairmont State, the university returns $5.69 into the state's economy. It provides over 830 jobs in our region. It's the third largest employer in Marion County, and it contributes $42 million to the region in wages and salary. Mr. President, I'm proud to stand here and urge the adoption of this resolution.
Thank you. Is there further discussion? Recognize the senator from Harrison County.
Thank you, Mr. President. You know, Fairmont State plays a tremendous role in north central West Virginia, and particularly in Harrison County, where it's had a presence for longer than I can remember. My mother is a graduate of Fairmont State with a teaching degree. My younger brother played ball there. Along with my friend from Marion County, I can't tell you what an economic driver Fairmont State is in our area, in our aerospace program, and in many other endeavors, both in medicine and other vocations that are so needed in West Virginia. Its new president, President Martin, she's not so new anymore. She's been around for, I think, almost over a year now. She brings a rich family history to Fairmont State that has really reinvigorated Fairmont State. One of the neatest things I ever saw was her in her Fairmont State sweatshirt out on first day for freshmen. She's out there greeting everybody. Those are good things. That's what West Virginia is about. And what Fairmont State brings is truly about West Virginia, and I stand in full support of this resolution. Thank you, Mr. President.
Thank you. Is there further discussion? Recognize the senator from Brooke County.
Thank you, Mr. President. I stand in support of this resolution with my good friend from Marion County. I am a proud Fairmont State alumni. You know, I look back on the 4 years that I was there, and really the years that changed my life. People that I met at the school who really changed the trajectory that I was on. People like Dr. George Sprouse, who was my political science professor and my advisor. Ed Denny, who was one of my swim coaches, Pat Snively, who was one of my coaches, who is still the coach there now, made me into the person that I am. But it's not just the school that I have a lot of pride in, but I really enjoyed being a part of the community of Fairmont and living in the town of Fairmont. I felt, you know, coming from a small town of Wellsburg, I felt right at home in Fairmont, going to places like Yan's and Call Cessno's and the 8th Street Confectionery. Really enjoyed being a part of Fairmont and living there. And the people that I met there still to this day remain some of my best friends. My college roommate, his son was the ring bearer at my wedding, and he was in my wedding, was fraternity brothers with him. And so I think Fairmont is a place where people, and for all you students there in the back, look around to the people that you're here with today, because chances are those are the people that you're going to be friends with for the rest of your life. I see a fist bump there. I know those, they're going to stay friends. So it's a place where you come together, where you meet people that are really going to shape how you are as a person in the future you'll have. So I stand in strong support of the resolution.
Is there further discussion? If not, the question before the Senate is adoption of the resolution. Yeas and nays have been demanded. Is the demand sustained? The demand is sustained. All those in favor of the resolution will vote yea. Those opposed will vote nay. The clerk will prepare the machine. Has every member voted? Has every member voted? So the clerk will close the machine and ascertain the results. On this question being 33 yeas, 0 nays, 1 absent not voting, more than the majority of those present and voting having voted in the affirmative, I declare the resolution adopted. Junior Senator from the 17th.
Thank you, Mr. President. I request unanimous consent that the comments by the senators from Marion, Harrison, and Brooke be placed in the appendix of the journal.
Without objection, so ordered. Junior Senator from the 17th.
Thank you, Mr. President. I move the Senate stand in brief recess for the purpose of presenting this resolution.
Junior Senator from the 17th moves that the Senate stand in brief recess for the purpose of presenting this resolution. All those in favor will say aye. Those opposed, no. The ayes appear to have it. The ayes do have it. I declare the Senate in brief recess to present this resolution. Senate will please come to order. The Senate will please come to order. Are there additional items under unfinished business?
Yes, sir. Senate Resolution 51, recognizing the Shinston Fire Department's 90th anniversary.
Recognize the Senator from Harrison County.
Thank you, Mr. President. I request unanimous consent the resolution be taken up for immediate consideration, committee reference be dispensed with, and the resolution be placed upon its adoption.
Is there objection? Chair hears none. Clerk will please read the resolution.
Senate Resolution 51, recognizing the Shinston Fire Department on its 90th anniversary.
Question before the Senate is adoption of the resolution. Is there discussion? Recognize the Senator from Harrison County.
Thank you, Mr. President. Today it is truly my honor to stand in support of this resolution recognizing the Shinston Volunteer Fire Department on its 90th anniversary. You know, 90 years is a long time, but it's particularly long when you think of the achievements that have been achieved, the achievements that have been seen by the volunteer firemen that have served Shinston now for 9 decades. You know, from its original first fire chief, Henry Carter, and I'm going to just quickly name the others: Joe McIntyre, Bob Harrison, Bob Bennett, Jim Spatafor, Doug Gregory, and Dylan Olivito. They've truly achieved a lot. In 1944, they were there when the tornado hit Shinston, West Virginia, killing more than 100 people. In 2016, during the floods, they raised over $2 million in relief supplies and got them to needy West Virginians. Back when this volunteer fire department was first formed, they had about 35 calls a year that they answered to. Last year, they had over 900. You have to think about the place volunteer firemen occupy in the state of West Virginia. 80% of our firefighting capability comes from volunteers. It's a lifetime job that doesn't pay anything. The efforts of the Shinston Volunteer Fire Department are nothing less than heroic. It is my honor to stand in strong support of this resolution for the unsung heroes of the Shinston Volunteer Fire Department and the unsung heroes of volunteer fire personnel all over the state of West Virginia. Mr. President, I stand in support of Senate Resolution 51.
Is there further discussion? Recognize the Senator from Braxton County.
Thank you, Mr. President. Indeed, it is our honor to recognize these guys. When you travel around in West Virginia, there's a few things that you kind of take for granted. And if something happens to you, someone's going to come help you. And that's exactly what the guys at Shinston Fire Department do. Their reputation is as good as any out there, and we're fortunate to have them. And you know, the one thing that we sometimes forget about in the volunteer fire departments is it's dangerous. You know, when they go out on that call and they go into a building, they don't really know what's in that building, but they don't hesitate. They go. They're there 24 hours a day, 365 days a year, they're there. And there's a comfort that all families have because of that. And again, it's my pleasure to stand up and recognize the Shinston Volunteer Fire Department as well as all the volunteers across the state of West Virginia. Urge adoption.
Is there further discussion? If not, question before the Senate is adoption of the resolution. All those in favor will say aye. Those opposed, no. The ayes appear to have it. The ayes do have it. I declare the resolution adopted. Junior Senator from the 17th.
Thank you, Mr. President. I request unanimous consent that the comments by the senators from Harrison and Braxton be placed in the appendix of the journal.
Without objection, so ordered. Junior Senator from the 17th.
Thank you, Mr. President. I move the Senate stand in brief recess for the purpose of presenting the resolution.
Junior Senator from the 17th moves that the Senate stand in brief recess for the purpose of presenting this resolution. All those in favor will say aye. Those opposed, no. The ayes appear to have it. The ayes do have it. I declare the Senate in recess to present this resolution. The Senate will please come to order. The Senate will please come to order. Are there additional items under unfinished business?
No, sir.
Bills on third reading.
Committee substitute for Senate Bill 38, requiring schools provide elective course on Hebrew Scriptures or Bible.
Recognize the junior senator from the 17th.
Thank you, Mr. President. I request unanimous consent that the bill lie over one day, or I will take its place on the calendar.
Is there objection? Chair hears none, so ordered.
Engrossed committee substitute for Senate Bill 213, relating to administration of trusts. Third reading of the bill.
The question before the Senate is, shall the bill pass? Is there discussion? Recognize the senator from Morgan County.
Thank you, Mr. President. The committee substitute for Senate Bill 213 is a bill that comes to us from the Probate Committee of the West Virginia State Bar, and it addresses directed trusts, administration of trusts. It amends and reenacts several sections of the code that are located in Chapter 44D, but it adds a whole new article to the code in Chapter 44D, and it's designated as Article 8A, which would be the Directed Trust Act. And this is a uniform law. It has been adopted in other states. It is recommended to West Virginia, Mr. President, by our Uniform Law Commission. In a directed trust, a person other than the trustee or the settlor or grantor of the trust has the power to direct action, expenditures, that sort of thing, by the trustee, and has power over the trust administration. The bill defines that person as a trust director and identifies the duties and responsibilities of a trust director along with a trustee and the interplay between the two when both exist. Mr. President, I'd be happy to try to answer questions. Urge passage of the bill.
Is there further discussion? Further discussion? If not, all those in favor will vote yea. Those opposed will vote nay. The clerk will prepare the machine. Has every member voted? Has every member voted? So the clerk will close the machine and ascertain the results. On this question being 33 yeas, 0 nays, 1 absent and not voting, more than the majority of those present and voting having voted in the affirmative, I declare the bill passed. Recognize junior senator from 17.
Thank you, Mr. President. I move the bill be made effective July 1, 2020, and request unanimous consent that the roll call used on passage of the bill be used to make it so effective.
Junior senator from the 17th moves that the bill be made effective July 1, 2020, and requests unanimous consent that the roll call used on passage of the bill be used to make it so effective. Is there objection? Chair hears none. On this question there being 33 yeas, 0 nays, 1 absent and not voting, more than 2/3 of those elected having voted in the affirmative, I declare the bill effective July 1, 2020. Clerk will communicate the action of the Senate to the House.
Engrossed committee substitute for Senate Bill 246, including family court judges and retirement system for judges. Third reading of the bill.
Question before the Senate is, shall the bill pass? Is there discussion? Recognize the senator from Wood County.
Thank you, Mr. President. Senate Bill 246 would allow family court judges to enroll and participate in the state judges' retirement system. Currently, family court judges are in the PERS system, and the code specifically excludes family court judges from participating or enrolling in jurors. This bill would remove that exclusion. Family court judges would be required to make the election to join jurors if they wish to do so. I'm happy to answer questions. Otherwise, Mr. President, I urge passage.
Is there further discussion? If not, all those in favor will vote yea. Those opposed will vote nay. The clerk will prepare the machine. Has every member voted? Has every member voted? If so, the clerk will close the machine and ascertain the results. On this question being 33 yeas, 0 nays, 1 absent and not voting, more than the majority of those present and voting, having voted in the affirmative, I declare the bill passed. Clerk will communicate the action of the Senate to the House.
Engrossed committee substitute for Senate Bill 284, creating West Virginia Healthcare Continuity Act. Third reading of the bill.
Question before the Senate is, shall the bill pass? Is there discussion? The senator from Marshall County.
Thank you, Mr. President. Senate Bill 284 is brought to us from our state's Attorney General. What this bill does is it provides protections to West Virginians in the event that the Affordable Care Act, also known as Obamacare, is overturned. The bill would require that the insurance commissioner publish a notice in the event that the ACA, Affordable Care Act, has been overturned. In 90 days after that published notice, the provisions of this bill will become effective in terms of action by the insurance commissioner. 180 days after that, the insurance commissioner will promulgate rules, and the provisions of this bill apply to health insurance plans. If the insurance commissioner determines that tax credits authorized under the ACA have been determined invalid, then a commission is created under the bill to identify state or federal policies to replicate the tax credit authorized in the ACA. This bill describes that commission and its duties. The bill also requires the insurance commissioner to create the West Virginia Patient Protection Program, which is a reinsurance program to provide payment to health insurance issuers for claims for health services provided to eligible individuals with expected high health care costs. The commissioner is to establish a framework for the plan. Mr. President, the bill also requires an actuarial analysis to take place. The bill provides that the insurance commissioner will prepare emergency rules to implement the plan and submit detailed reports to the legislature. The bill sets forth minimum coverage standards for plans and details the 10 benefits the plan shall include. The bill also notes that the plan that provides coverage for any children or stepchildren shall continue to offer coverage at the option of the policyholder until the unmarried child or stepchild reaches the age of 26. The bill provides a health insurance policy may not impose a pre-existing as exclusion and may not deny enrollment to any individual on the basis of a pre-existing condition. The bill does provide that a policy issuer may restrict enrollment to open enrollment and special enrollment periods. It may impose an affiliation period on any health insurance policy that is not provided through an individual market, and it may provide that it does not exceed 90 days and shall not apply to emergency services and use other alternatives approved by the insurance commissioner to address the adverse selection. Mr. President, I urge passage.
Is there further discussion? Recognize the junior senator from the 8th.
Thank you, Mr. President. I stand in opposition to this bill. My opposition is twofold. One, the Democratic caucus provided or proffered a bill to protect folks with pre-existing conditions that was much more expansive and more in line with what's provided, the protections thereof provided by the ACA. 700,000 West Virginians are protected by the ACA, 700,000 individuals with pre-existing conditions. That's something that we should not forget, and that is a fact according to West Virginia University. The second reason why I oppose this bill is I just can't abide by the politics of it. And I've already critiqued this, but I'll say it again for posterity, that the Attorney General has made his goal in this state to strip away protections under the pre-existing conditions that we have under the ACA, and has now before us introduced us a bill that doesn't come anywhere close to protecting West Virginians. It would be analogous to having a 3-floor house with 6 bedrooms and 4 bathrooms, and the attorney and an individual burning it down to the ground and then forcing you to buy a house from him that's half the size with very little space. That's just not right. That's what my opposition is attached to this bill. And I urge a no vote. Thank you.
Thank you. Is there further discussion? Further discussion. Senator from Marshall wish to close debate, or recognize Senator from Marshall?
Mr. President, for the reasons stated, I urge passage of this bill.
Question for the Senate, shall the bill pass? All those in favor will vote yea, those opposed will vote nay. The clerk will prepare the machine. Has every member voted? Has every member voted? If so, the clerk will close the machine and ascertain the results. On this question, there being 20 yeas, 14 nays, 0 absent and not voting, more than the majority of those present and voting having voted in the affirmative, I declare the bill passed. Clerk will communicate the action and send it to the House.
Engrossed committee substitute for Senate Bill 511, regulating pawnbrokers.
Recognize the senior senator from the 8th.
Thank you, Mr. President. I ask unanimous consent to amend on third reading.
Is there objection? Chair hears none. Are there amendments?
Yes, sir. Senators Jeffrey, Lindsay, and Trump move to amend the bill on page 5 after section 3 by adding a new section designated section 4 to read as follows.
Recognize the senator from Morgan County.
Thank you, Mr. President. I request unanimous consent to explain the amendment in lieu of having it read.
Is there objection? Chair hears none. Senator may proceed.
Thank you, Mr. President. The committee substitute for Senate Bill 511 has a number of sections in, we're in Chapter 47, Article 26. The original engrossed bill added a whole new section, 4764. This amendment, the pending amendment offered by the 3 senators named, would rewrite that language in Article 4. The substantive change based on the amendment is what it does is it strikes some of data that would be reported in electronic database that is required and discussed in the Act in Section 4. The significant change is that it excludes firearm information from any database. And so I urge adoption of the amendment.
Is there further discussion? Not. The question before the Senate is adoption of the amendment as explained by the senator from Morgan. Question before the Senate is adoption of the amendment as explained by the senator from Morgan County. All those in favor will say aye. Those opposed, no. The ayes appear to have it. The ayes do have it. I declare the amendment adopted. Are there further amendments to the bill?
No, sir.
Not. The bill will be engrossed. Clerk will read the bill a third time.
Engrossed committee substitute for Senate Bill 511, regulating pawnbrokers. Third reading of the bill.
Question before the Senate is shall the bill pass? Is there discussion? The senator from Morgan County.
Thank you, Mr. President. As I mentioned earlier, the engrossed committee substitute for Senate Bill 511 amends sections in the West Virginia Pawnbrokers Act. That's Article 26 of Chapter 47, and it creates new sections now, new Section 4 at least. There are regulations existing as to pawnbrokers. Let me just go briefly through what this bill does now. It includes some new definitions, so we're defining new terms. Gift certificate, general use prepaid gift cards, store gift cards, those are new defined terms in the Act. There are some new prohibitions in the Act. There's a new Section 2A, which requires a pawnbroker, says a pawnbroker can't accept or for pawn or purchase goods, 1, from a minor, 2, from a person who's intoxicated or under the influence of alcohol or controlled substance, or appears to be, 3, articles that the pawnbroker knows or has reason to believe are stolen items, 4, gift cards, prepaid gift cards, store credit, merchandise cards. They're ineligible after this bill passes for pawn transactions. Property with serial numbers, personalized inscriptions or initials that mark that the pawnbroker knows or has reason to believe have been intentionally altered or rendered ineligible. The new section, Section 4, creates a database, and pawnbrokers be reporting the record of their pawn transactions, excluding firearms, to this database, and it's believed that this will help law enforcement as law enforcement agencies do their work in trying to track down stolen property. There are penalties in the bill for breach of those actions. The bill does also add a requirement, this was in last year's bill here again, mandating video surveillance of the entrances and exits to a pawnbroker's place of establishment, place of business. Be happy to try to answer questions, Mr. President. I urge passage of the bill.
Is there further discussion? If not, all those in favor will vote yea. Those opposed will vote nay. The clerk will prepare the machine. Has every member voted? Has every member voted? So the clerk will close the machine and ascertain the results. On this question being 31 yeas, 3 nays, 0 absent and not voting, more than the majority of those present and voting having voted in the affirmative, I declare the bill passed. Clerk.
Senators Jeffries, Lindsay, and Trump move to amend the title of the bill.
Question before the Senate is adoption of the title amendment. All those in favor will say aye. Those opposed, no. The ayes appear to have it. The ayes do have it. I declare the title amendment adopted. The clerk will communicate the action of the Senate to the House.
Engrossed committee substitute for Senate Bill 514, creating West Virginia FinTech Regulatory Sandbox Act. Third reading of the bill.
Question before the Senate is, shall the bill pass? Is there discussion? Recognize the senator from Mercer County.
Thank you, Mr. President. The purpose of this bill is to authorize the West Virginia FinTech Regulatory Sandbox Program, which enables a participant to market and test innovative financial products or services in the state. The bill requires the West Virginia Division of Financial Institutions be responsible for administering the program in partnership with other appropriate agencies. Happy to answer questions. Otherwise, I urge passage of the bill.
Is there further discussion? If not, all those in favor will vote yea. Those opposed will vote nay. The clerk will prepare the machine. Has every member voted? Has every member voted? So the clerk will close the machine and ascertain the results. On this question being 34 yeas, 0 nays, 0 absent and not voting, more than the majority of those present and voting having voted in the affirmative, I declare the bill passed. Clerk will communicate the action of the Senate to the House.
Engrossed committee substitute for Senate Bill 530, relating to taxation of aircraft. Third reading of the bill.
Question before the Senate is, shall the bill pass? Is there discussion? The senior senator from the 15th.
Thank you, Mr. President. Senate Bill 530 provides that an aircraft that is purchased in West Virginia be removed from the state within 60 days is exempt from consumer sales and service tax. This is known as the flyaway rule. This is a concept that has been adopted in states to encourage additional economic activity in aviation that benefits airports and the aviation service companies. This will make West Virginia more attractive to aviation entities. The bill provides the necessary FAA forms to evidence the sale, and transfers are required. Mr. President, I urge passage.
Is there further discussion? If not, all those in favor will vote yea. Those opposed will vote nay. The clerk will prepare the machine. Has every member voted? Has every member voted? Close the machine and ascertain the results. On this question being 34 yeas, 0 nays, 0 absent and not voting, more than the majority of those present and voting having voted in the affirmative, I declare the bill passed. Junior Senator from 17.
Thank you, Mr. President. I move the bill be made effective July 1, 2020, and request unanimous consent that the roll call used on passage of the bill be used to make it so effective.
Junior Senator from the 17th moves that the bill be made effective July 1, 2020, and request unanimous consent that the roll call used on passage of the bill be used to make it so effective. Is there objection? Chair hears none. On this question there being 34 yeas, 0 nays, 0 absent and not voting, more than two-thirds of those elected having voted in the affirmative, I declare the bill effective July 1, 2020. Clerk will communicate the action of the Senate to the House.
Engrossed committee substitute for Senate Bill 614, changing method of allocating funding from safe school funds. Third reading of the bill.
Question before the Senate is, shall the bill pass? Is there discussion? The senator from Jefferson County.
Thank you, Mr. President. Members may recall that last session, the legislature passed a bill requiring cameras in special education classrooms. This bill sets out the manner in which the Department of Education should allocate additional funding for the 2019-2020 school year into the special revenue account known as the Safe Schools Fund to fully accomplish the goal of that bill by providing funding for all the school districts to have cameras in special education classrooms. The bill then provides that once all the schools are equipped with cameras in special education classes, that funding will revert to the prior funding mechanism based on the number of public schools. The total cost for this year is $400,000. Mr. President, I urge passage.
The question before the Senate is a further discussion. Further discussion. If not, the question before the Senate is, shall the bill pass? All those in favor will vote yea. Those opposed will vote nay. The clerk will prepare the machine. Has every member voted? Has every member voted? So the clerk will close the machine and ascertain the results on this question being 33 yeas, 0 nays, 1 absent and not voting. More than the majority of those present and voting having voted in the affirmative, I declare the bill passed. Junior Senator from the 17th.
Thank you, Mr. President. I move the bill be made effective from passage and request unanimous consent that the roll call used on passage of the bill be used to make it so effective.
The Junior Senator from the 17th moves that the bill be made effective from passage and request unanimous consent that the roll call used on passage of the bill be used to make it so effective. Is there objection? Chair hears none on this question being 33 yeas, 0 nays, 1 absent and not voting. More than 2/3 of those elected having voted in the affirmative, I declare the bill effective from passage. Clerk will communicate the action of the Senate to the House.
Engrossed committee substitute for Senate Bill 635, allowing administration of small estates. Third reading of the bill.
Question before the Senate is, shall the bill pass? Is there discussion? The Senator from Morgan County.
Thank you, Mr. President. The committee substitute for Senate Bill 635 is another bill that has come to the legislature from the probate committee of the State Bar, the West Virginia State Bar. It amends a couple sections of the code that are in Chapter 44, and it creates a new article in Chapter 44, would be designated as Article 1A. Chapter 44 is estates. Article 1A would be the West Virginia Small Estate Act, and it has in the new article 6 sections, but in summary what it does is that it provides an expedited process for the administration of small estates. And those are defined. What a small estate is defined in the Act. The definition of a small estate is that it does not exceed a fair market value. Assets do not exceed a fair market value of $50,000. The total aggregate fair market value of real estate, which is probate, does not exceed $100,000. And so under this expedited process, Mr. President, someone could administer an estate that meets the eligible definition for a small estate without going through all the formal probate process that exists in the law now for all estates. So I'd be happy to try to answer questions. Otherwise, I urge passage of the bill.
Is there further discussion? If not, all those in favor will vote yea. Those opposed will vote nay. The clerk will prepare the machine. Has every member voted? Has every member voted? If so, the clerk will close the machine and ascertain the results. On this question being 34 yeas, 0 nays, 0 absent and not voting, more than the majority of those present and voting having voted in the affirmative, I declare the bill passed. Recognize Junior Senator from the 17th.
Thank you, Mr. President. I move the bill be made effective January 1, 2021, and request unanimous consent that the roll call used on passage of the bill be used to make it so effective.
Junior Senator from the 17th moves that the bill be made effective January 1, 2021, and request unanimous consent that the roll call used on passage of the bill be used to make it so effective. Is there objection? Chair hears none on this question there being 34 yeas, 0 nays, 0 absent and not voting, more than 2/3 of those elected having voted in the affirmative, I declare the bill effective January 1, 2021. Clerk will communicate the action of the Senate to the House.
Engrossed committee substitute for Senate Bill 668, enacting Uniform Trust Decanting Act, third reading of the bill.
Question before the Senate is, shall the bill pass? Is there discussion? Recognize Senator from Morgan County.
Thank you, Mr. President. The committee substitute for Senate Bill 668 is another uniform act. It is the Uniform Trust Decanting Act. And what it would do is it would create a whole new article in our state code in Chapter 44D. And the article, it would be designated as Article 8B, the West Virginia Uniform Trust Decanting Act. And the purpose of the bill is basically to allow process when a trust, an existing trust, inter vivos or testamentary, I assume, but an existing trust is no longer functional or no longer serves the purposes for which it was created and formed, but can be salvaged. Its purposes can be salvaged by putting its assets into a new trust. And so it is yet, if I didn't mention this, another bill that comes to us from the Probate Committee of the West Virginia State Bar. But the idea and the word decanting, I guess this helps me figure out how that works or understands it, but it's like decanting a bottle of wine. You'd be taking the assets of one trust from that trust, pouring them over into a new trust that would function differently, and this bill permits that in circumstances. I'd be happy to try to answer questions, but urge the bill's passage.
Is there further discussion? If not, all those in favor will vote yea. Those opposed will vote nay. The clerk will prepare the machine. Has every member voted? Has every member voted? So the clerk will close the machine and ascertain the results. On this question there being 34 yeas, 0 nays, 0 are absent and not voting, more than the majority of those present and voting having voted in the affirmative, I declare the bill passed. Junior Senator from the 17th.
Thank you, Mr. President. I move the bill be made effective from July 1, 2020, and request unanimous consent that the roll call used on passage of the bill be used to make it so effective.
Junior Senator from the 17th moves that the bill be made effective July 1, 2020, and request unanimous consent that the roll call used on passage of the bill be used to make it so effective. Is there objection? Chair hears none. On this question being 34 yeas, 0 nays, 0 absent and not voting, more than two-thirds of those elected having voted in the affirmative, I declare the bill effective July 1, 2020. Clerk will communicate the action of the Senate to the House. For what purposes does Senator from Wetzel seek recognition?
Mr. President, I ask unanimous consent to return to the second order of business.
Is there objection? Chair hears none. Introduction of guests. Recognize Senator from Wetzel.
Thank you, Mr. President. We have in the North Gallery students from Wetzel and Marshall County that are here for the Youth in Government Day. If they'd stand, the Senate would love to make you welcome.
Thank you. Are there further introductions? Bills on third reading.
Engrossed committee substitute for Senate Bill 760, allowing state college or university apply to HEPC for designation as administratively or financially exempt school. Third reading of the bill.
The question before the Senate is, shall the bill pass? Is there discussion? The Senator from Jefferson County.
Thank you, Mr. President. The committee substitute for Senate Bill 760 provides a process for state college and university to become designated as an administratively exempted school. The committee substitute also requires the Commission to propose rules to implement the state college and university exemption status section. It also confirms the currently exempted school status of WVU, Marshall, and WVSOM, but changes references to those schools from exempted schools to statutorily exempted schools. The committee substitute requires the Commission to submit an annual report to LOCIA. I'm happy to answer any questions. I urge passage.
Is there further discussion? Recognize the senior senator from the 17th.
Thank you, Mr. President. Will the senator from Jefferson yield?
Senator yield. Senator does yield.
Senator, I understand that this bill sets forth some different criteria that schools would have to reach to be able to get this exempt status.
Yeah.
Do you know what the schools are right now that would qualify under this?
I believe, and I haven't gotten any official notice of this, but I believe that Fairmont, Shepherd, and West Virginia Liberty.
Okay. And then how many total schools would this apply to?
All the current four-year regional schools.
Okay, and what's that total number? Do you know?
7 total, 4-year regionals.
Okay, thank you.
No problem.
Thank you. Is there further discussion? If not, all those in favor will vote yea. Those opposed will vote nay. The clerk will prepare the machine. Has every member voted? Has every member voted? So the clerk will close the machine and ascertain the results. On this question being 28 yeas, 5 nays, 1 absent and not voting, more than the majority of those present and voting, having voted in the affirmative, I declare the bill passed. Clerk will communicate the action and send it to the House.
Engrossed committee substitute for Senate Bill 772, clarifying American Law Institute's restatements of law. Third reading of the bill.
Question before the Senate is, shall the bill pass? Is there discussion? Senator from Morgan County.
Thank you, Mr. President. The committee substitute for Senate Bill 772 would just create a single new section of code. It goes in Chapter 2, Article 1. Article 1 is an article that addresses the state's common law, and it's a very short section. I can read you the whole bill. It would add a section that reads as follows. In any action governed by the laws of this state concerning rights and obligations under the law, the restatement of the law and other legal treatises are not controlling authority. I interpret that as meaning the courts are not bound by those until such time as our Supreme Court of Appeals would say a precept or part of the restatement or some other treatise is adopted as precedent and controlling law in this state. Be happy to try to answer questions. I urge passage of the bill.
Is there further discussion? Recognize the junior senator from the 8th.
Thank you, Mr. President. Will the senator from Morgan yield?
Senator yield. Senator does yield.
Absolutely.
Yes, Senator. Would it be consistent with this bill for West Virginia courts to continue to read the restatements, the legal treaties, and other sources and cite and quote these sources where relevant?
Where relevant for them to be cited by the courts or by litigants before the courts?
Yes.
Yes, absolutely. Yeah. I think, to be honest with you, I'm not sure that this really creates any variation from what is current law regarding the restatements or treatises. I think lawyers or litigants can continue to cite them as persuasive authority and argue to the court or to our Supreme Court that they should be adopted, that a principle set forth should be adopted as binding authority. I think that all this is trying to do is to make clear that until our Supreme Court says we adopt this part of the restatement as the law of West Virginia, it's not controlling on lower courts. But obviously if the Supreme Court does do that, it is binding.
So, because ALIs right now are not controlling, correct?
I don't believe they are.
All right. And again, I just want to be certain that courts can continue to rely upon restatements, treaties, and other sources where relevant.
Oh, I think so for purposes of persuasion or consideration, as you know. Okay, I'll take a little liberty here and say one of the reasons I felt for so long that we need an intermediate appellate court is that I think it would allow for some broader development of our decisional law in this state. But without getting into that at length now, we'll say that there are questions which arise that have not been answered by our court. You know, you get, as a practitioner, you do some research and you find that, you know, there's really no Supreme Court case from West Virginia that deals directly and squarely with the issue you've got before you. So as a lawyer, what do? You look for other authority. You say, that could be, how have other states dealt with this? What does the restatement of law say about this? What does Professor Williston on contracts say about this question? And you cite what you can find to the court and try to persuade the court that this is, since we don't have binding authority, controlling authority, this is what the court should look to and use to decide the question before it.
And practitioners and courts can still do that?
Absolutely.
Even with the passage of this law?
I don't think there's any bill we could pass that would stop practitioners from doing that. Because you have to if we have an open question of law that hasn't been answered by our Supreme Court or by a statute, we have to try to convince the court what the legal result, what the interpretation of law should be.
Thank you, Chairman.
Thank you.
Is there further discussion? Recognize the senator from Harrison County.
Thank you, Mr. Chairman. I rise in opposition to this bill. As the discussion just revealed, this bill really doesn't do anything. The ALIs, which have been a common reference for lawyers, it goes back to Lawyering 101, are persuasive law. They've always been persuasive law. They'll continue to be persuasive law. And I don't think our Supreme Court needs us to remind it that they're persuasive law, which means they're not binding. All we do is blur the line between the legislative and judicial branch, and I think we're treading into territory that's not only impermissible, but it's unnecessary. I've urged a no vote on the bill, Mr. President.
Is there further discussion? Further discussion? Senator from Morgan wish to close debate? Senator from Morgan to close debate.
I would just say, I'll say again for the record, I don't think this changes the law. I don't. Is there utility in putting this in the law? I agree with my friend from Harrison that it's not necessary to explain to or remind our current Supreme Court that restatements of the law or treatises are not binding, but we have had temporary Supreme Courts for which I think there might be utility to put in code some reminder of what the law actually is.
Question before the Senate is, shall the bill pass? All those in favor will vote yea. Those opposed will vote nay. The clerk will prepare the machine. Has every member voted? Has every member voted? If so, the clerk will close the machine and ascertain the results on this question being 22 yeas, 12 nays, 0 absent, not voting. More than a majority of those present and voting having voted in the affirmative, I declare the bill passed. Clerk will communicate the